Someone's on mute.
Sorry. How's that? That better?
Sir.
Just after discussion with my client, we will stipulate to the fees of Mr. Craig.
All right,
To
understood.
go through that process if he didn't want to.
For the purposes of the record, do both parties have those amounts available now, or do we want to wait, do that later?
Wait to do that later.
Okay. Anything else, Mr. Bernie?
No, Your Honor.
All right, Mr. Craig, anything on your end?
Yes, Your Honor, I'd just like to see if we can stipulate to admit the pretrial order into evidence. It does have some stipulations attached to it as well.
Any reaction to that, Mr. Bernie?
I don't know that that would, if that just confuses the jury. It seems like what's been in the pretrial order has been part of the instructions in the case. So I think it's sort of duplicative of what has been discussed in the case so far.
So just to be clear, I haven't gotten a request to introduce the pretrial order before, but if it's just to declare some stipulations, I think you could do that. I wouldn't think the pretrial order, similar to the admissions or the interrogatories, wouldn't be something that goes back
Okay.
during deliberations. I think that's fairly clear. But is there a particular stipulation or anything that you wanted to announce as part of the pretrial order?
Well, I just think there are statements made by the plaintiff in the pretrial order. I would like to be able to share those with the jury if necessary.
Those are statements of counsel.
I mean,
My
statements.
client-
Well, let's not interrupt each other.
All right.
All right. Yes, sir, Mr. Craig. So in the same way you handle this with interrogatories and admissions in the complaint, again, if you can, I'm going off just the civil treatise I'm referring to, is that you use those as prior statements to impeach somebody who's on the stand.
Okay.
And you can confront them with those. But in terms of just admitting it as a document to say and reading off a prior statement, I don't think that's a permissible use or possible use rather.
Okay. All right.
If you've got some other authority, feel free to present it to me. If there's like you said, a legal stipulation, then we can talk about that. But if it's just kind of referring to other things within the pretrial report that are written down somewhere, I don't see how that.
I think Your Honor makes a good point. The only thing I am a little confused on is the stipulations that are an attachment to the pretrial order. I would like those to be part of the evidence if possible. And are those read into the record or?
So can you refer me to those? Where exactly in here?
Let's see, it's an attachment, so it'll be toward the back. Let's see here. Attachment 2 should be right after the contract.
All right, so I'm looking at attachment 2 and it lists. All right. So, right, these are essentially statements of fact that appear to have been agreed to by the parties, listed out numerically in attachment 2.
Your Honor, I think that, I think it could necessarily confuse the jury as to number 4. I mean, I think that it implies that there's no other agreements in the case, which I think the evidence is clear, to the least supports the idea that we should be able to present those agreements that are outside the contract. To the extent that it limits that in some way, I would object to that.
Your Honor, are not stipulations binding on the parties? And
Sure.
I would submit that it clarifies the matter for the jury.
Well, okay, if that's the sole concern here, I don't see the stipulation as foreclosing the jury's consideration of whether there were separate oral agreements or whether the agreements were modified. I mean, I think that's still very much at issue here, but the fact that there were 15 kind of matter-of-fact statements here agreed to in the pretrial order, I don't see a reason why that couldn't be tendered as an exhibit or and also announced in open court before the jury if you want to summarize those. That's how I've used and seen stipulations used in past trials.
I agree with that, Your Honor. That's
All right.
fine.
So then we would remove attachment 2. You can mark it as a separate exhibit. That'll go back in the list of exhibits, and you can do with it what you will during the evidence portion. All right. Anything else, Mr. Craig?
No, thank you, Your Honor. I guess I'm moving to admit, and has that motion been granted?
Well, let's get a number on it.
Okay, so that would be Defendant's Exhibit 123.
All right. 123 being attachment 2 from the pretrial order.
Yes, Your Honor.
Any,
No objection, Your Honor.
all right, then that's admitted.
Your Honor, if I might, I do recall I have a housekeeping matter in terms of witnesses. We have Summer Benton, character witness. She's a police officer and she has a 3:30 court appearance in another case. She could be here before then. I think she's going to be here in Fulton County. So just alert the court, it'd be extremely short testimony, just as the character of Mr. Reynolds, and if there could be some flexibility in getting her in to testify.
All right. And this is just for personal opinion, her personal opinion of his character.
Correct, Your Honor. And it would be, who is she? How does she know Simon? What's his character? That's it.
Understood. Okay, Mr. Craig.
Well, I have my standing objection about witnesses based on discovery. I won't rehash it for you because you know it well.
Right. And I've been trying to look up some of the other case law on it before, and I've, been, and I'll find the site when it gets closer to it, but there's some cases out there about where if you don't even put character witnesses in the pretrial order at all, regardless of whether it's interrogatory, that shouldn't preclude a rebuttal witness from testifying. So the question would be, is this really a rebuttal witness? And again, the phrasing of your interrogatory on its face was, is there anyone with knowledge of this circumstance, right? And so if solely what this witness is being called is just to say Mr. Reynolds is of good character, I wouldn't actually say that fell under the umbrella of the interrogatory.
Might I offer a different perspective on
Sure.
that, Your Honor? So it's any party with discoverable information that you might use to support your claims or defenses. Defenses, of course, applying to our counterclaim for fraud. Fraud does put character at issue in the case. So they've been on notice of that since the counterclaim was filed, long before the close of discovery. And we have not offered character evidence per se of any kind. We don't have witnesses in here impeaching his character and saying he's a bad guy. We've proceeded based on the direct testimony of my client and her expert and the facts. There have been maybe some prior inconsistent statements that we've used, but there's really been no character evidence. So I would submit that there's no need for a rebuttal witness on the issue of character.
All right. Yeah. Last statement, Mr. Burney, and then I'm going to take a look at the get double check law on this. But if I do allow it, I'll keep your timing into consideration. But last word.
Francisco called my client Mr. BS, which clearly calls his character into question. Mrs. Maia has accused us of lying about all kinds of matter of things in this case. So I think that necessarily calls the character of my client into question. This witness has been known to them since early July, when this pretrial was entered. And they've had every opportunity to take her deposition, or to ask to amend the pretrial order to add their own character witness. There's never even been a request. What is Ms. Benton going to testify to? So, there hasn't been any action on their part to try to mitigate. This is the facts of the case. We're trying to get the right things in front of the jury. And I think my client is entitled to one character witness when they've accused him of lying, of fraudulently changing documents. They've called him Mr. BS. I think that they put character well into issue in this case, and we should be entitled to a very brief, less than 10-minute witness on character.
All right, so I'll take a look at that. Again, the procedural hangups are the ones standing out to me. I want to make sure that is proper. So, Mr. Byrne, anything else?
No, thank you, Your Honor.
Okay, Mr. Craig?
So just one last question about the stipulations.
Mhm.
I would like to read these into evidence at some point. I suppose we could do that after all the witnesses have testified.
Whenever you want to do it in your presentation of the evidence, since it's part of your case.
All right, great. Thank you very much, Your Honor.
Any decisions about claims that may or may not be pursued?
Oh, yes. So we will not proceed on the slander of title claim. We're setting that aside because we just haven't had time to produce evidence on it. And it's a tiny, tiny part of our case.
Okay.
So
We'll remove that from the verdict form and the charge on the slander claim. Anything else?
and of course, I will take that out of my attorney fee claim accordingly.
You've got a way to actually subdivide that out.
I do. Yes.
All right. Okay. If there's nothing else, then we'll ask Deputy Scott to retrieve the jury.
Yeah, you can. Okay. May Mrs. Maia
That's, yeah,
take the
absolutely.
stand?
These six and get ready to go.
Oh, yeah. About the jury.
Thank you, Deputy Scott. Please be seated, everyone. Thank you, members of the jury. Welcome back. And hats off to you. I think most of you beat me in this morning, so very much appreciated. So we are ready at this point to resume plaintiff's cross-examination of Ms. Maia. And Mr. Byrne, you may proceed.
Thank you, Your Honor. If we could bring up defendant 76, please. Let me see it. Yes. Ms. Maia, I believe you testified that this was the picture of your backyard prior to construction.
Correct.
Uh,
Correct.
Prior to this project with the VA, you had another grant from the VA or received monies from the VA for the metal ramp, correct?
No.
Okay, did you have a metal ramp in place when this project started?
Yes.
Okay, and how did you obtain that? How did that ramp come into play or come into place?
I disassembled it from another location and I put it there.
Okay, so but the contract refers to the fact that there's an existing ramp.
Correct.
A ramp, is that ramp in this picture?
No.
Should it be? I mean, if this was taken right before construction started, shouldn't the ramp be in this
I
picture?
didn't say it was taken right before construction.
I didn't say you did. I'm
Well,
asking you.
you did just now.
Okay.
I think. Did you?
I'm sorry if that's what you thought I said. What I meant to say was, you stated that this picture was taken just before construction began. Was the ramp there before construction began?
I didn't say it was taken just before construction.
When was this picture taken?
I think I said it was taken, at minimum, I said a year. I think I said a minimum a year.
So this picture doesn't accurately reflect the actual condition of your backyard prior to construction then?
I believe I said it's the only difference topographically is that we removed the tree and we had a stump grinding. So topographically, it's the same.
You had a what was that in?
So the tree, you can see that there's a tree on the left.
Correct.
And we had stump grinding
Right.
to remove the roots that Simon said he removed, but we had stump grinding done.
Was there some ramp there before?
So the ramp is durable medical equipment. It is not permanent property. You can pick it up and move it around.
Uh-huh.
And so the ramp lays on top of the grass and you can just move it around. And that's what we did. And so there was a ramp that we placed on top of the grass. Yes, before construction.
Understood. So my question to you is, the ramp extended from the deck, correct?
Correct.
And how, did it go all the way to the parking area?
At various times, yes.
Okay. And so my question to you is why isn't the ramp in this picture?
Because we didn't put it there.
Okay, so you're saying that you took the ramp out of the picture and then took this picture to show that that's what it looked like prior to
No, this
construction?
was prior to the ramp.
Okay. So the ramp was in place.
No.
You didn't move the ramp before
No,
construction?
no. So I think you've misunderstood. So if you recall, yesterday, I said that this was at least a year before construction. I didn't say it was just before. So you recall that. And I also said that I moved my parents in because of the construction. So it was like a couple of months, right? So my ramp is because of my dad.
I understand that. That's not the
So-
question I asked.
So then the ramp
Excuse me, ma'am.
doesn't,
Let me just keep
Well-
this on. This isn't, we don't have to go into all this. I'm just
but I'm
asking you.
explaining the ramp.
Okay, the question I asked you is, right before Mr. Reynolds and Reynolds Renovations came out to work on your property, was the ramp in place?
Yes.
Okay, that's all. Thank you. You can pull that down, Katie. Thank you. Mrs. Maia, you've had people out, well, let me back up. When is your statement of when the last time Reynolds Renovations did any substantive work on your property?
I think I'm in agreement with Simon on that around February. I think he said January, but I would say more around February.
Okay. And do you recall what the last thing that they worked on there was?
I mean, as you know, when it comes to construction, the last things are, a little more less visible, right? So the main thing was the retaining wall,
Okay. So that's the last thing you remember of any substance being done?
right?
Okay. And from that date, February, somewhere early spring, late winter, early spring in 2022, have you had people come out to look at the property to see what the issues are?
Yes.
Who are those people?
Well, I listed them and it's hard to recall because I'm a little nervous, but I did list them in my interrogatories. But off the top of my head, I hired a company called Home Probe. And I hired Gary, I wish I could look at my interrogatories because they're all listed there, but the main ones are Home Probe, Pablo, of course. There's a couple other, they're in there in my interrogatories. Dan something, I don't know, there's numerous.
There was many, right?
Yeah,
I mean, you were having people come out to look at the property and say,
Right.
what's wrong with this?
Mhm.
David Ahern, do you know that name?
Yes, I do.
And who is he?
Objection, Your Honor.
On the grounds?
Consulting expert, not discoverable.
Can
Can we
all right,
approach?
Evidence.
No,
or-
I mean, just asked a question about who is an individual.
Okay.
So I'd overrule that.
He's an expert.
Okay. And so anybody else that you can think of that came out and looked at the property?
Yes, there's everybody listed on the discovery that we provided to you. And I just, because of nerves, I don't remember their names.
Right. But it was several people, more than 5, right?
I don't remember. It's on the discovery that we provided to you.
And are any of those people planning to come and testify here in this case?
Well, I didn't think I wanted to pay all that money because it's so expensive, but we provided the reports to you.
Okay. My question to you was, are any of those people being brought to testify in this
Yes,
case?
yes.
Who is that?
Pablo?
Okay, thank you. How do you know Pablo Blanco?
I don't, other than as I really don't know him other than just an expert witness.
Does your husband know him?
No.
And did you pay Mr. Blanco to do work? I mean, to come out to your property and look at it?
Yes.
How much did that cost?
I have to look at the contract.
And when did Mr. Blanco come out to look at your property?
It was around the time that you did, so not that long before that.
Was he there before when we were?
Yes.
And that would be July of 2023?
I'll go with that. I don't remember the dates.
And do you know when you presented him as a person who might testify in this case?
It was immediately upon identifying him.
Okay. If we could do defendants 28, please. Ms. Maia, do you know when this picture was taken specifically? Like the date and time?
No.
So it could have been taken any time after the building of the retaining wall up until right before this trial started.
Right until right before the trial started?
Correct. I mean, you just said you don't know when the picture was taken.
No, that wouldn't make sense because it was provided to you in discovery.
Okay. So it was taken sometime between when the case started and when you made the discovery response with this document.
So we met our discovery deadlines, so it would be within that period.
All right, thank you.
And
Excuse me, ma'am, let me ask you a question. It's
Okay.
cross-examination. Can you pull up the plans and specifications? You'll have an opportunity to cover any of this with your attorney when I'm done.
Your Honor, I think she should be allowed to complete her answer, even if she pauses to consider.
That's fine, Your Honor. If she needs to add something, it's as long as it's related to the question.
It is.
Related to the question. You can continue, ma'am.
Can you pull that back up? The picture?
I'm sorry?
Can you pull the picture back up?
So you're going to talk about anything except for when the picture was taken?
No, I'm asking for the picture back
I
up.
understand, but if what you want to say is related to when
Yeah,
the picture was
yes.
taken, then we will. Okay,
Yes,
put it
that's
back
why
up.
I'm asking for the picture.
So does that help you understand what the date and time of when this picture was taken?
Yes, it does.
Okay.
Because I can now, looking at the picture, it jogs my memory because I can see that there's still when you throw down the hay type items when you are trying to grow new grass, that's still there. And so this was taken when very shortly after the completion, when we were walking around trying to document, because I now remember that there's still all that debris from when you throw down grass seed, and there's that like like hay type stuff.
Sure.
And so now I remember walking around, taking the pictures, and there's still that item, that stuff, and then the back wood is still very fresh. So now it's starting to come back that this was taken very soon after this completion, and everything was still pretty fresh.
So spring of 2022. And at that time, you identified that there was an issue, some issue with the retaining wall or whatever the reason you took that picture for. You realized that you had to take a picture to document that.
Well, no, that's not why. I mean, that's
Okay.
not the reason why. We're just taking the pictures to document because.
All right. Can you bring up the contract, please? Yeah. And if you could scroll down to Exhibit B, please. Keep going, please. Keep going. Okay, hold on a second right here. Actually, keep going. Go ahead. Okay, if you can go back up just a little bit. Up a little bit. So, Miss Maya, if you look at this image on the right elevation, that shows the north side of the ADU, right?
I'm not sure can you point to it? I'm not sure what you're referring to.
Yeah, it's the one of the four little drawings on that one's the one on the right in the middle. It says right elevation.
Okay, yes. Mm-hmm.
And so if you were looking at that, you'd see the ADU, and if you look to your left, you'd see your home, right?
I'm not putting it in place in my head. I'm not sure.
Okay. But this elevation shows that from this side, the front door of the unit is level with the ground. Correct?
So I'm having a hard time placing that where you're saying that is where my house is, and all, like, I'm not visualizing it. So where,
I'm just trying to ask you that this picture, this elevation shows that when completed, the building should be level with the ground right outside the front door.
okay, so where it says right elevation, that's the exit door of yes, that's like where the driveway is?
Right.
Yes,
I mean, the plans require that it be level to the driveway.
yes,
Because you're moving out, potentially your
Yes.
father with a
Correct.
gurney or in a wheelchair,
Correct.
you don't want to bump.
correct,
Okay.
yes.
If you can go down, Katie. Actually, Katie, if you could pull up. Where's that? James?
Yes, sir.
Photograph that showed front of the property where you're looking at the red line, the orange.
So the front of the property. Um,
Sorry?
It's, so when I think of so Chris, not trying to be obtuse here, I'll help you out, but looking at the front of the property, I think of that's the front of the main house. But when you're talking about wraparound porch, looking, oh, okay.
No, it's not the house.
Let's see here. Let me look at my PowerPoint real quick. And then I can look at my exhibit list. Oh, you got it?
Could I get up and get a Kleenex for my?
I think that's it, Chris.
We got some at the,
Hasn't been admitted, but is that what you're
That's
looking
fine.
for?
We
Scott, you need to put that box in the witness stand.
We'll stipulate to admit it if you want.
All right, if we can put Dependents 55 up, please.
The computer's having a stroke.
So, just,
I got
did the
it.
court reporter catch that exchange?
I'm sorry. we'll do it again.
Okay.
For the record, we're discussing defendants 55.
Yeah.
This has already been tendered and admitted? Or
I think
expected?
55 was already in, or maybe we
Okay.
didn't argue.
It's been offered in this case, whether he's admitted it or not. I think I'm entitled to just ask her to refresh her recollection about this.
We're
So-
okay with it.
So Ms. Maia, this is a photograph of the ADU that Reynolds Renovations built, correct?
Correct.
And from this photograph, can you tell whether or not the front door of that property is level with the driveway?
I can't, but I know that it is.
And can you show me on what part of this photograph where the corner of the deck is sticking out over the driveway as you testified?
So it is very hard to tell from this angle because it's sort of like an optical illusion, but that is actually, it is. And if you were to actually stand on the side, you could see that it is. This is like an optical illusion and this weird angle.
Okay, thank you.
It is, yeah. Well.
Mrs. Maia, you've testified in this case that there's just one contract, correct?
There is one valid contract, correct?
And that includes everything that was done on your property.
Correct.
So if we looked at the plans and specifications that came with the contract that you say is a valid contract, the October 20 contract, correct? It would have information in there about the tiling on your front walkway.
So that tile was because Simon
I understand. I'm
purchased-
just asking you if those plans and specifications would show the tiling on your front walkway is what has to be done by Reynolds Renovations as part of the
I
contract.
never requested that.
You never requested that Simon,
Correct. Let's talk about it. That was to remedy a problem that Simon created.
we're talking about the walkway in the
Yes.
front of your main
Correct.
house.
Correct.
Okay, so what do you think Simon did to create that problem?
So can we bring up a picture of the bathroom?
You can discuss that with your attorney. Where? Text message.
Well, this is related,
Okay. Again, you can put that up with your.
but this is related.
It was, we have all these exhibits, Mr. Corporal. Thank you. This. Nothing goes wrong. I'm looking for 15D. Let's get that one moved first.
I can pull it
Oh,
up.
these,
I have 15D pulled out
where's that?
on my computer.
Okay, I need to see this. Yeah, it's.
This. That's what you marked as D.
Go back to the C. Huh? So you would agree that in the plans and specifications, there's no discussion of the tile?
Correct. Wait, no, I do not agree.
Tile in the front of
I
your
do not
home?
agree.
Okay, tell me about why you don't agree.
So, can we bring up the plans for the bathroom? It's related 100%.
Okay,
And also the contract where we signed for the tile. Can we bring, that's also related.
I don't, you can bring that up with your
But
attorney.
this is your question.
Okay,
I'm
but
answering your
you can,
question.
he can come back and ask you. I've got you on cross-examination. I'm
But
not
this-
trying to be
this is
difficult,
the
but I have a
answer.
limited amount of time, ma'am.
It's the answer to your
And
question.
I'd like to ask, I just want to know, in the plans and specifications, is there any discussion of the walkway in the front of your house? Just say yes or no.
That tile
Okay,
is a direct cause of the contract.
I understand. Is there a discussion of the tile in the front of your home?
That tile is a direct cause of the contract.
All right, I think we can move past that.
It's directly from the contract. And we can talk about it, but you won't bring it up.
You paid, your attorney he's going to get a chance to come back and talk to you about these things. And you paid for that tile to be installed in the front of your property.
Twice.
You paid twice for the installation?
No, I shouldn't have paid it all for the installation.
You did pay for the
Was
installation.
forced to,
You were forced to.
correct.
Why were you forced to?
Because Simon had the front in a position where people couldn't walk on it. So when the nurses came, they came and they left, meaning I had to pay the nurses because they arrived and then they left without treating my dad. So not only did I have to pay them, but then he didn't get the treatment. So then I'm forced to resolve the situation as quickly and as quickly as possible so that I'm not paying them for leaving, and also my dad's getting the care because he's got appointments, 6, 7 nurses a day, clinicians,
Thank you.
and then Simon has them so that I can't get the care.
Understood. Okay, so,
So I'm forced to pay him
but
when I wasn't
you
supposed
ordered,
to.
tile was ordered for the ADU, correct?
The tile was a mistake order that Simon made.
Okay. You say it's his
Yeah.
order. Did you select the tile to be ordered?
I did not select that tile.
Okay, but you stated that it's important that everything be per the contract.
Correct.
And so when you selected the tile, it wasn't the right tile for the ADU, correct?
Correct. He ordered the wrong tile.
Okay, and what was the solution for that?
The correct solution was for Simon to return it, and he wouldn't. So I thought, okay, Simon's a very nice guy.
Okay, so hold on a second.
Until he's
You took
not.
the tile didn't work in the ADU. So did you take the tile and say, let me return it?
I'm not the contractor.
Okay.
It's
but
not my money.
That's a yes or no question.
He
Did you
paid for
try
that.
to do that?
I don't even know where he got it.
Did
No.
you ask him where he got it and say, Simon, give me
I-
the tile and let me return it?
I asked for the receipt multiple times and he wouldn't give it to me.
Did you ask for the tile and where it came from so you could return it?
I asked for the tile. No, I asked where it came from and asked for the receipt and he wouldn't give it to me.
It was your intention to return it?
No,
Okay. And what, did you ask Simon to do anything with the
I
tile?
asked for him to return it and he wouldn't because they said they don't take it back without some kind of 20 or 25% restocking fee.
Okay. And so once that was made clear, did you ask Simon to do anything with the tile?
Well, he is like, as I said, he's very nice until he's not. So I want to say, okay, well, let's do something that keeps it going, that works for everybody. Okay, so I will cover the tile and then you get the right tile. And I feel like that's an amenable solution. We can continue working together, but you install it and don't charge me. So now this works for both of us. This is a workaround that I think is a friendly solution. I
Okay.
didn't want that.
But whose idea was it to put the tile on your front walkway?
It was mine.
Okay.
Because he wouldn't return it.
And so when the tile was going to be put on the front walkway, how was that tile going to be put there?
He was going to install it and not charge me because I'm actually helping him because he wouldn't return it.
And how much tile are we talking about and how long was the walkway?
Well, can we bring the picture up?
I don't have a picture of that. I'm just asking you if you know, how much are we talking about?
It's
Is it
not-
your whole front
It's-
walkway?
It's not that, it's a small walkway. We had the picture up. I think you have it in your evidence. It's not a long walkway.
Okay, so it's your testimony that you didn't want to do anything with the tile, but Simon agreed to put it in the front walkway and did not charge you for that.
He was not supposed to charge me.
And do you have any evidence, an email, a text, anything that says, hey, thanks for putting that in and not charging me.
It's a friendly conversation that I thought would just be just simple. Like what can go wrong with that, right? It's just, hey, this is okay, right? I'm helping him. He wouldn't return it. What's the fastest way through this? I'm not going to litigate over this, right? The tile was like
That's fine. So we've
$600.
talked about the
It was
tile. Let's move on, please.
$600. And it was supposed to be $600. It ended up costing me like $3,000.
Okay.
It's supposed to be $600.
Did you object to that expense?
Yes.
And did you pay the expense?
Well, when the thing is torn up, nurses are going away. I have no choice.
Well, that has nothing to do with
It
the
has
paying of
all
it.
the
So you're saying you paid him,
everything
you
to do
paid
with
him
it.
before he put the tile in?
When it's partially there and nurses are leaving, I have no choice.
Okay.
That's
So the nurses couldn't
choice.
walk around on the grass
No.
next to the
Let's
walkway?
pull it up.
No, I'm just
No.
asking you if they could have.
No, they wouldn't.
Okay.
You
that's
saw
fine. I'm
you
moving
saw the
on.
front walkway with the dirt embankment. No, they wouldn't. They arrived, and because they arrived, they still get paid. Because some are free, some I have to pay. They arrive, their GPS triggers that they're at the house, they get paid, they leave. My dad doesn't get care. And Simon doesn't work until he gets paid.
You
as he says.
testified that if you go to the ADU now and plug anything in, a circuit breaker blows. Is that a correct statement?
It had been, so that's documented by Home Probe as well. And we had electricians come out and work on it, and I'm not sure it's totally fixed now. I think
I would object. Okay. I just asked you if you stick one in and it blows and you say yes. Does it blow the break or when you?
To this day, some things I think do blow.
Okay.
But for many months, yes. When you were there, I think it still did. Home Probe documented that and the things to you.
Okay. So Home Pros is not part of this case.
Home Probe, we did give you
All
that
right, just
evidence.
listen to the question that's asked. Answer only the question. He asked about your
So
personal
at what
knowledge.
point?
Do you have anybody from Home Pros coming to testify in this case?
To testify? No.
Are you an expert in electrical work?
I'm not an expert, no.
Okay. And you stated that you've had some people come out and do work.
Yes.
Okay. What are those people? Who are those people that came out and did work? Just who are the people that did work for now?
I can't remember their names. They're listed in the interrogatories and the responses.
Okay. And are any of those people going to come and testify in this case?
No.
Okay. And are you going to submit invoices from any of the people that came and did work in this for you?
I think we did on some of them. I think we did.
Are they going to be entered into evidence in this case?
I think they are.
Okay.
They're in our discovery.
You talked a little bit about the complaint that you made to the VA. And you stated, I think that Eric Good gave you 1 day when you contacted him to complete the complaint. Why do you think Mr. Good was so short with you?
He was being transferred to a different department. So that was it. And if he just was leaving and he was transferring everything to Philip Richards.
Okay.
So
And so did he indicate that was a deadline to you that you couldn't go past when you were going to submit your complaint?
he said that he's closing all of the cases on his desk. And if I didn't get that complaint in, then it would just be closed. So just put something in. It didn't matter what it was, just he said just a simple piece of paper just to hold it open so that he could pass it off and it would go from there to Philip.
Did that make sense to you that the VA would put a deadline on you? I mean, this is in late February, March of 2022, right?
So the way he is phrasing it is just put it in that you have a problem. That is not the comprehensive end all to the problems.
Okay.
So there,
Got it.
it's just
So
for the
then
record, it's-
he takes it and then he transfers it over to Mr. Good, correct?
No,
Okay, what happened with the complaint then?
you said it went to Mr. Good, it went to Mr. Richards.
Richards, I'm sorry, correct. And so it goes to Mr. Richards and Mr. Reynolds, through Reynolds Renovations, responds to that complaint, correct? Just yes or no, he responded to the complaint.
I know, I want time to actually hear your question and think about it.
Thank
So
you.
please allow that. So I think that after it went to Mr. Richards, I think that he may have communicated with Francisco first. I don't think that-
Who communicated with Francisco?
That's what I'm trying to figure out. I don't know if it went to Mr. Reynolds first or to Francisco or what. Because at that point I had, I want to talk about it again. I had
Understand.
my stuff going on.
You had your family issues,
Yeah, I'm
understand?
not doing that again.
Not trying to go there with you.
But you're asking me what happened next.
Okay,
And I'm not exactly sure who it went to next, but at some point they started talking about it and I don't know
Right.
what happened, who it went to first.
okay. And so, but you are aware that Mr. Reynolds filed a formal response to the VA to your complaint?
I'm aware.
Okay, and you had an opportunity to look at that response,
Right.
and you had an opportunity at some point in the future to supplement that claim that you made and to add in all the other things.
No.
Okay, why is that?
He just shut it down. He did not want to hear it.
And how did he shut it down?
He just said, you didn't state that in your first complaint. And as, paraphrasing Simon, the VA was desirous of closing the case. That's all they cared about. He didn't want to hear anything. He said, you didn't state that in your first complaint. The VA just wanted to shut it down, as Simon said. They just didn't care.
But you took the time to write this initial complaint up, and as you stated, you didn't have time to put everything in, so you put in
Exactly.
just a few things.
Exactly.
And the VA came back, or Simon came back, the VA issued a response and what should happen, right?
Mhm.
And then they said nothing else can be submitted. And you've got the emails and the letters from the VA saying nothing else can be submitted.
Yep.
You asked them in writing,
Yep.
okay, and they refused.
He said, you didn't mention that before.
Okay. Is it possible that during the course of a construction, there could be more than one set of complaints?
Yes, there could be more. Yeah.
So if you learn of one thing in the beginning of a situation and then a little bit later, you could add more,
You should.
right?
Absolutely.
But you're saying the VA wouldn't allow you to do it?
Shouting to the wind. Nobody cared. Nobody cared. Because I didn't state it in my first complaint. They were desirous of just shutting the case down, as Simon said.
What kind of work have you had done at the property since Reynolds Renovations stopped working? What kind of work have you had done? Actual work on the ADU?
I think Francisco would have been a better person to talk about with that.
You don't know of any work that you've had done?
I do, but I'm just saying my answer would not be complete. We had to have the gate fixed because the gate was never functional.
Francisco was here yesterday, I think it was. It's been a long week. And your client, your lawyer had an opportunity to ask him any question. You didn't ask him any questions about that. Why is that?
I don't know, but this is your question.
Okay, so the question is, what work have you had done at the ADU since Mr. Reynolds, through Reynolds Renovations, completed his work? What work have you had done?
So I'll answer, but I'm just letting you know my answer is not going to be as complete as Francisco's
Okay.
would have been if you asked that. So we had to have the gate fixed.
When you say the gate, you're talking about the electric gate that goes over the driveway?
Correct.
Okay.
Um,
What else?
We had to have the AC repaired.
And when did the AC repair happen?
I don't remember.
Okay. And what else?
We had to have some faucet repair.
Okay.
We had to have some electrical work.
What kind of electrical work did you have done?
I don't recall the extent of it, but I do remember, and because I'm not totally knowledgeable, but I do remember some of the more just like visual things like the box hanging off the wall and
What box?
the outside things being loose.
Okay, like
some
the panel or whatever.
that, yeah, and there's some things wrong in the breaker area, but that still is not fixed even after that. There's some bigger problem hidden in there somewhere that,
How do you know that?
because that's still a problem.
Okay, so you had you had the gate repaired, you had a faucet repair, you had some electrical work done. Do you know what the cost was of those repairs?
I don't remember.
Okay,
Feel like there's other things I just don't.
this is your opportunity to tell the jury all the work that you've had to have done on this ADU after Simon Reynolds
Right,
and Reynolds
and
Renovation
so-
left it in such a bad condition.
Right, and so that's why I'm telling you, because of the things that I have, my burden, my husband has been doing a lot of that, and he was here for you to ask, and you didn't ask that.
I didn't ask that. That's correct. So you don't know. That's your answer.
No, that's not my answer. I said I could answer some of it, but not all of it.
Okay.
And my husband would have been a better person for you to ask, and you didn't.
You showed a picture of a warped floor. When was that picture taken?
When? Of, I don't remember. I mean,
You
it
know who
was
took the picture?
multiple people. There's so many of those pictures, so I don't know which one that one was. We have a lot
So
of,
it's the one that you introduced into evidence to show the warped floor. We've only had one picture about a warped floor. You showed the picture. I'm asking you, when was
So-
that picture taken?
so we have about 100 of the pictures, and I don't remember which one that was. We didn't show the more comical ones, I'm sorry, but I don't remember which one that was.
Okay, so the picture, so you don't recall when any of the pictures that were taken in this case when they were taken?
That's not accurate.
Okay, so when were they taken? You've
So-
introduced one into evidence. We can show it again.
Okay, we could. So the pictures were taken spanning the period April 2022 through months and months and months after.
Let's put 75 up, please.
So from the period, I would say around April of 2022 is when we started taking pictures through months and months and months and months after.
Okay,
So there's a span of pictures.
all right. And so, but in terms of this particular picture right here,
Mhm.
can you tell us what the date and time was when that picture was taken?
Sometime before discovery. So I don't know.
Okay, and can you tell me who took the picture?
No.
Your Honor, I'd move to strike. This picture, the foundation is not there. She doesn't know what the date and time when it was taken. She doesn't know who took it.
All right, at this point, it's already been admitted, and so I think
We did object at the admission of it.
I understand you did, and she laid the foundation at that point. So at this point, the jury can weigh her testimony and decide what to credit and what weight to give this picture.
Thank you,
So,
Your Honor.
Overruled.
Thank you.
I do recognize the tape measure as my father's. So I'm actually now remembering. That that's my dad's tape measure. It's one of those old school wooden ones that fold back and forth. So this picture is actually very helpful now. Thank you for pulling it up. It's one of those ones that go like this zigzag.
Mm-hmm.
So that tape measure is one that you put in your pocket, you know? And so I think that we were there possibly with James, maybe?
Okay, that's fine. We can move on.
Yeah.
I think the jury understands.
Yeah, I do.
What you
I
know,
do. It's
understand
coming
about it.
back now.
Okay.
Thank you for
Um,
pulling that up.
so any other work that you can recall that you have actually had done on the ADU since Mr. Reynolds Renovations stopped work at the property in the spring of 2022.
Sorry, can you repeat the question?
Is there any other work, actual work that you have had done to remedy any of the issues created by Reynolds Renovations after they left in spring of 2022?
Uh, I, I think I had, okay, now we're talking about it. I had to have somebody come and help me in the yard because the debris was buried I had tried to go out there with like a crowbar because I couldn't dig, the shovel broke trying to dig out the big debris. So I just could not do it anymore. I had to have somebody come, like one of the neighborhood kids. So, I mean, that's like immaterial. I feel like we're wasting time on that. But I
Okay.
had to have somebody actually come, like, spend a couple days doing that, digging out big blocks. And that's actually a problem. My mother fell out there. I mean, she's
So you
old.
said you spent a couple days,
Yeah.
and so you don't know who it was that did it?
No, it was one of the neighbor kids.
And how much did you pay him?
It was like $10 an hour.
So how many hours did you pay him?
It was like, it's like 5 hours a day. It's like,
10 hours then?
yeah, it's about, it's. It was about. But there's still a lot of debris out there that
Why
we
didn't you
still
have
can't
him,
get
why didn't you get the rest of the debris?
because it's so big. You need a machine.
Okay.
It's like not movable by a human.
Okay.
It's like a ton.
And you haven't had anybody come move all this debris in your backyard?
I am financially broken by this case
Okay.
and I can't get the loan because I tried to get a loan
Right. So
and I couldn't because of the
when
loan.
was the last time you tried to get a loan?
It's documented.
Have you tried to get more than one loan?
I lost my job, so I lost my opportunity. I tried to get the loan while I was employed and I couldn't because of the lien. Then I lost my job. So now I cannot get a loan.
I thought you testified earlier that you were a stay-at-home person when this project started.
When the project started, I was a stay-at-home and I was employed.
Okay. You worked remotely from home. And when did your job stop?
The month and year,
Yes, that's fine.
can we look on LinkedIn?
I'm sorry.
Can we look on LinkedIn?
If you know what, this is stuff your lawyer can cover. I'm not trying to be difficult. It's if you can give us a general idea when it left, when you lost your job.
It was right after my dad died.
Okay, so that would have been February of 2023. And you've been stay-at-home since that time, correct?
I had a job for a few months and then I
Okay.
lost that one too. So
Okay. And so, other than the one loan that you've talked about, there's been no other attempts to get a loan because you say you've been unemployed and you couldn't get a loan. Okay. You're not blaming Mr. Reynolds for you being unemployed.
no, I'm blaming him for not getting the loan I applied for when I was employed because I had the lien.
Okay.
I tried to get a loan to pay for these repairs, but I had the lien.
What is the work that you have had done to remedy, let's talk about the fence. Fence was paid. Give you a minute.
Can I take a break?
Yeah. Members of the jury, if you can step out. Mr. Craig, I have a question as I turn to the charges in the verdict form. Is your breach of contract counterclaim for both The defendant and or plaintiff and counter defendant, or just for one?
Breach of contract is just for the plaintiff.
Just for the incorporated. All right.
And on that topic, Your Honor, I do have a couple of, based on what's happened, I'd like to add a couple. I have them ready to go. I can email those to you. They're just two. One is about production of evidence, and then under the contract claim, a duty to mitigate.
I think we'd already included mitigate as just a pattern charge that might seem applicable, but email over what you have when you have it so that we can all
I will
take
do
a
it
look.
the minute I sit down, Your Honor.
All right. And Ms. Maia, just let me know when you're ready to proceed. All right.
Sorry?
We can go off the record. That's fine.
According to Mr. Craig, it would be incredibly helpful if your client and you didn't step on each other.
Understood. I apologize.
It's, she trails off, so it's already hard for me to keep up because the volume goes up and down, and then when we all step on each other, I might.
Should we ask her to, get closer to the microphone? I think,
I jacked up,
I see.
so yeah, just.
It's sometimes hard in the flow of it,
No,
so I understand.
I get it, I'm trying to, I understand it's trial, I understand the work of time, I'm just saying that there's gonna be inaudibles if that keeps happening, I don't like inaudibles.
Understood.
You're under, may I run to the restroom
That's
as
fine.
well? And, okay. I'll be back. Thank you.
Figure out the one. Stopped at 119.
Yeah, I'm not sure.
Okay, okay, because I was like, did I miss something? So I like panicked for a second, but okay. So 120, 121, and 122 haven't been produced yet. Okay, cool.
See if it can be seen. But it's on, that's under access to it right now.
They're in your exhibit binder. Already tabbed.
This is business. The tiles and that was her idea. It's her idea that Brad took a day
The tile went down within another day. It was a hold for weather, but it wasn't like it was in disrepair. It just made the sound as if it was like.
All right, Deputy Scott.
About the adjourn.
I know, just now, you just stash this.
Thank you, Deputy Scott. Please be seated, everyone. Mr. Bernie, you may continue.
Thank you, Your Honor. Mrs. Maia, is the ADU, as we sit here today, is it being air conditioned?
Yes.
Okay. And does the ADU draw power, or does the air conditioning unit get its power from the ADU?
I don't know. There's separate how that works.
Okay, so you don't know, that's fine. Can you turn the lights on in the ADU?
Yes.
Okay. Um, Who paid for the appliances? In other words, were the appliances part of the contract price?
That's a big debate. It's written in there.
Okay, can we pull up the contract again and go to Exhibit D, please? But just to say that, there's a refrigerator that is in the ADU, correct?
Mhm.
Is that the same refrigerator that's been in there since the beginning?
Yes.
And who purchased that refrigerator?
Uh, Nobody. It's just my old refrigerator.
Okay. And so that refrigerator has been put into the ADU and has been there since that time.
Yes.
And you're saying that Simon didn't put the right size refrigerator there,
He didn't put any refrigerator in there.
but you're saying he was supposed to. Can you show me on this line item on the contract where appliances are?
Can you go to scope of work?
I'm asking you if it's on Exhibit D, ma'am.
This is the estimate.
Okay,
correct? Can we
so I
scroll up
understand what it is. I'm just asking you if it's listed on this document.
on the estimate?
Yes, Exhibit D to the contract.
So in the estimated items, can you scroll up for a moment so I can see if I'm understanding what I'm looking at? So Exhibit D, estimate. Okay.
Is there any doubt that that's part of the contract in this case for
Yes,
the
I
ADU?
want to make sure because we have so many versions.
Understood. But do you now agree that that is the Exhibit D to the contract?
Exhibit D, estimate, yes.
Okay, and so this is
So-
the line items that were included in the document.
Right, and my understanding is the scope of work has appliances.
Okay, but there's nothing in this document that talks about appliances.
In the estimate,
In Exhibit D.
in Exhibit D estimate, no.
Oh, okay. And
Well,
so-
unless you include it under electrical or plumbing. I don't know.
That says electrical and lighting fixture allowance.
Well, I guess technically appliances are electric.
Is it your testimony that appliances are included in this?
I believe it's under scope of work.
Okay, so but in terms of that document, it's not included.
The contract document,
Let's move on. What other appliances are in the ADU?
there was the microwave,
Okay,
the stove,
and who put the microwave in?
Simon,
Okay, and what about the stove?
Simon.
Okay, and who purchased the stove?
I don't remember. I think, I don't remember. I think I did.
Okay, and do you know what the cost of the stove was?
Remember.
Any other appliances?
I think Simon did the microwave. I did the stove. I think I did I don't know. It was so much back and forth on that. I don't remember. It was so much arguing. It's confusing.
Okay,
And then after that, we were trying to get it up and functional. After all of that was said and done, I put in a washer dryer, but that's still not installed. Oh, no, it is installed.
all right. With regard to the fence, in regards to the fence, there's been some discussion about whether the fence was moved, correct? About how far the fence was moved.
Which
There's been
part of
some
the-
disagreement about how far the fence on the north side of the property was moved.
Correct.
Okay, and there's that particular fence, you asked Simon to move it out,
False.
okay? Why did it get moved?
Because Simon said, well, actually, there's a couple reasons. So Simon often, you could see that there's some pictures as well that was part of, I think it may have been your exhibit or ours, I don't know, but there's things leaning on the fence. And I kept telling Simon, and you'll see in some text messages, stop putting things on the fence. You're causing the fence to lean. And you'll see that through some months.
If you put D49 up.
So
Thank-
there's problems with him leaning heavy things on the fence. There's also, that's maybe some of it, but there's also other cases.
Okay,
And then over several months, I think at the very end, I'm usually pretty nice, but at the end, I'm like, I told you to stop doing that. It was not my proudest moment. So there's some leaning issues. And then also Simon said, hey, I think we can reclaim a few inches while we're fixing this leaning. So, okay. But when he was responding well, I'm going to leave it at that. So,
okay, so your testimony is that he said, hey, you might be able to move the fence. I mean, this picture was taken early on in the construction. This is the foundation of the ADU, correct?
That is
And-
early
and-
on, correct?
And the fence behind it that you see behind, that's the fence we're talking about.
Correct,
The fence wasn't moved then.
correct.
So the fence wasn't moved to facilitate construction.
I can't say that, no.
Okay, but the fence was, Simon suggested, per your testimony, he suggested moving the fence and you said, okay.
That's not quite what I said.
What did you say?
So there's several issues, or at least a couple. So one is he kept leaning things on the fence. So there were leaning issues causing things, and that was over the span of several months. There's evidence of me telling him to stop putting heavy things and making the fence lean, not only on this part of the fence, but on the other south side opposite of that. He also had to fix the other side. And then also, this is the foundation, which you have a lot of room to move around on the foundation. But when you're starting to build walls vertical, that Ed's a large-sized man. The space in between that fence and a vertical wall, I mean, you can envision him squeezing in there. It's not a
Okay.
lot. So, I mean, he's gonna have to move that fence.
And there was fencing on the south side of the property where your electric gate was, correct?
Yes.
And that he did some work on that fencing. Do you remember what he did?
Yes, it's replaced.
Okay. When you started the ADU project, did you anticipate moving that fence, the north fence?
No.
Okay.
We shouldn't have had to do that.
When you when on a day-to-day basis, are you using the ADU at all?
No, on a day-to-day basis, no. It's mostly
Okay.
storage.
So you're using it for storage?
It's just, yeah, it's got my dad's old wheelchairs, his bed chair, it's like bed bath chair. It's mostly storage.
Okay. When this foundation was laid, did you ever go out and walk around the property and see what was happening?
Yes,
Okay, you were interested because it's a new ADU, it's where your dad's gonna be, you wanted it to be right, correct?
correct.
So you testified earlier that this was built not where it was supposed to be.
Correct.
Did you tell Simon, hey, that slab doesn't look like it's in the right spot?
So regarding the slab, my main concern, that was the most obvious thing to me when he started pouring it, was, Simon, it's raining. Are you sure that you're supposed to be pouring this because of the rain? Right? And I said, it's gonna be raining tomorrow. And your plan is to pour this concrete tomorrow. And it's gonna be raining several days after that. I don't think that sounds right. And then he kept telling me, it's fine, we're gonna put plastic over it. And so I kept telling him, are you sure that's right? And so my concern over the slab, I was really worried about all the rain, the heavy days of rain.
Okay,
And so I was kind of obsessively worried about the rain. And so that was my big worry. And so when it's this layout here with all of this dirt, I did not have the expertise to know that it's a foot off. Because in my novice eye, I can't tell that is a foot off of the plan because I'm not a surveyor.
okay.
But what the obvious thing to me was, it's gonna be a lot of rain. Are you sure this is right? And he kept telling me it's right. And now we have this wavy floor.
Okay. So you're saying that the wavy floor is caused by the waves in
I
the
don't know.
concrete?
I don't know. Is
Okay.
it? He said
I don't
it's
know. I'm
not.
asking, we didn't know about it until you testified here today.
Knew about it, didn't, I don't know. He did it. How can he not know?
I guess I'm just asking you about the wavy floor. Is it your testimony that the wavy floor is caused by wavy concrete?
What else would it, I mean, I
I don't-
think,
I
I'm
don't
not the
know. I'm
expert.
just
with-
asking you if that's what your testimony is.
I think I'm gonna make a guess that it's wavy concrete, but Simon's the expert and I will defer to his 35 years on
Okay.
why it's wavy.
Do you recall sending text messages to Simon concerning family members that had looked at the ADU and liked it?
I remember my brother being the only family member.
Okay.
And I also said my brother had a concern and Simon dismissed the concern. My brother liked it and my brother had requests and statements that needed to be repaired. And Simon just said, go talk to Ed. And then I talked to Ed and then Ed dismissed that.
And that's regarding the flashing around the door?
There's more than that. Yeah.
Okay. And so you documented that to Simon?
So I talked to Simon about it. And I think that there is text messages. And then there's also conversations to Ed about it as well.
Have you had anybody come and tell you what it will cost to fix that particular issue?
It's part of Pablo's conversation. And yeah. But they just dismissed me and when I asked them about that to fix it, I actually said, please fix it. And they just didn't, you know.
So let's talk about David Ahern. He was your previous proposed expert in this case, correct?
Correct?
Okay. He's not going to testify in this case, is he?
So
You can just
no.
answer.
No, he's not testifying. It is extremely expensive.
That's all I have. Thank you.
Redirect.
Yes, Your Honor. Could I take just a minute to prepare and I mean, you can
sure.
run my clock.
Simon. Yeah.
122. Not just yet.
I don't know.
Can I go to my attorney for a moment?
Mr. Craig?
Oh, I'm sorry.
Can I
Ms. Maia wants to step
approach
down
you?
for a minute and
Is that all right with
With
you,
you?
Your Honor?
In the middle of her testimony, I'm not going to object, Your Honor. We're just trying to get the facts in front of the jury, and if
All
she
right.
needs to talk to her attorney, I'm all for let them talk about whatever they'd like to talk about.
all right, Ms. Maia, you can step down.
That third copy to Mr. Bernie. Yeah, sure. All right, Mrs. Maia, let's proceed. You remember yesterday, during your cross-examination by Mr. Burney, he asked you some questions about text messages, correct?
Correct.
And you stated that certain text messages had been deleted, correct?
Correct.
And I think he asked you which ones had been deleted. Is that right?
Correct.
Okay. And you said that you couldn't specifically remember off the top of your head.
Correct.
Okay. All right, I'm handing you what's been marked for identification as Defendant's Exhibit 22. Excuse me, 122. Do you recognize what this is?
Yes.
Are these your notes?
Yes.
And would this help refresh your recollection concerning deleted text messages?
Somewhat, yes.
Okay. Would you like to take a minute to consult that?
Yes.
And there are several points listed there. Why don't you tell us about the first one? And bear in mind, we need to move quickly on this.
Okay.
Okay.
Um, well, I notice I made an error. I say Simon omitted all text messages between July 12 and October, but it was actually between June. There's more. It was between June and October. So he omitted the first 4 months of our communication.
Okay.
And Simon omits further where I texted him the VA's contact information. This contradicts Simon's deposition where he stated he was introduced to the project by Shona.
Okay. So he testified in the deposition. He was introduced to the project by Shona.
Right, and so he deleted where I sent him that.
Okay.
Simon omits where I complain regarding my first contact with Shona, and he steps in to contact me,
So
her for me.
these text messages contradicted his deposition testimony?
Yes, where he said that I had some prior relationship with Shona.
Okay.
And so I am complaining to Simon that, hey, this person, Shona, she's not responding. Can you, can you make the connection between us?
Okay.
Deleted that.
Let's move to your second point. And go ahead and tell us about that.
Okay, the second point, Simon deleted texts that indicate he wrote the scope of work that is in the signed contract. Contracts are judged more strictly for the person who wrote them, and I think he's trying to avoid being held accountable for the scope of work. And then I circle where his text messages are there, and then I circle mine where I quote, I say to Simon, I think the scope of work is the narrative section you submitted already. And so he deleted my comment to him about that.
Okay. So yeah, earlier in this trial, he testified that you drafted the narrative's description of plans.
Right.
And then you testified that the two of you worked together on it and he did the scope of work portion, correct?
Correct.
Okay. And so he deleted this text message, which shows that he did the scope of work portion.
Correct. And there's also the email but we're not talking about that right now.
Okay.
Okay.
Let's go to number 5.
Okay. Oh, okay. Deleted text messages recommending interior doors that were too small to fit the openings. This shows Simon was really managing the door process, not Shona. But for me, this is prior to the signing of the contract. And also the text messages, I feel like with 35 years of experience, the doors are too small. You mention it before the plans are confirmed to somebody that doesn't know, right?
Okay. So earlier we saw a picture of the door that was
Correct.
too small.
Correct.
And these are text messages talking about the size of the door.
Correct.
Okay.
And he's sending me pictures of, and then later he's sending me, I would order this, and the door is too small for
Okay.
the barn doors type.
So
Oh, okay.
all right, let's do 6 and 7.
So deleted text where I show Simon, I'm looking at a specific tile for the shower walls. This goes to what we were talking about, the big controversy about the tile, right? I never picked out tile that he purchased. He deleted all the evidence of that from his text chains. I have it in mine.
Okay. And what about number 7?
Deleted text about the concrete shortage related to the driveway. So that speaks to where he talked about the concrete shortage in the driveway. The driveway should have been way higher, right? The driveway was lower because it was less concrete. If you put the right amount of concrete, the driveway would have been higher. We would not have needed the retaining wall, right? Everything would have been higher. And so he deleted those text messages. I have them in mind.
Okay. Let's talk about, there's others. Okay, well,
This goes on and
let's talk about number 10 real quick.
on. Okay. Oh, okay. So he deleted text where he says he put up temporary lights to pass inspections. This was his way to get around the actual electrical inspections. This means that the final electrical was never really inspected, only the temporary electrical was inspected. He tricked the inspector into getting inspecting materials that were not final, but he told me this was the way it was normally done.
Okay, so that's not all of the examples, but that's a sample set, correct?
Correct, and it just goes on and on.
Okay. Thank you very much, Mrs. Maia. That's all I had for you.
Okay.
Any recross on those points?
No, Your Honor.
All right, you can sit down, ma'am. Defense prepared to call the next witness.
Your Honor, our expert will not be here until noon, unfortunately. I apologize. He's a contractor. He's super busy. And, we haven't known exactly when he would be called. So we've been trying to give him advance notice, but
All right, do you have any other evidence or anything else you were planning to present?
I could, the stipulations that we discussed earlier.
If that's something you were planning to present, then why don't we do that now?
Okay, great. Oh, he'll be here by 11?
Might be here, maybe 11:15.
Okay, he's telling us he should hopefully be here by 11:15. Okay, Your Honor, I would just like to read into evidence some of the stipulations between the parties. And do you want to instruct the jury on what stipulations are?
Sure. All right, members of the jury, the parties in this case have entered into stipulations that I have approved regarding certain matters. When parties stipulate to facts, that's in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. Mr. Craig.
Thank you, Your Honor. So this is from Defendant's Exhibit 123, which as I recall has been entered into evidence. And I'm not going to read all of the stipulations to you, but I am going to read just a couple of them. So,
Your Honor, I would object and ask him to read all the stipulations that we've agreed to in the case. But that was what I thought was going to happen. That was never presented to me, that only some of the stipulations would be read.
All right, so it's going to be entered as an exhibit, and it is, I believe, an exhibit that would go back with the jury. If in rebuttal you feel that some need to be read that he does not read, then I think you can present or emphasize them then, or you can read them in your closing.
Okay.
All right, Mr. Craig.
all right, stipulation number 4, October 20th, 2020, plaintiffs and defendants entered into a contract, which is defined as the contract, capital C. Number 5, the contract required plaintiff to complete a construction project at the property for the construction of an accessory dwelling unit. Number 6, the contract was a valid and binding agreement. That's it.
And then other than this witness's testimony, Mr. Craig, do you anticipate presenting any other evidence?
No, Your Honor. That will be my last witness.
All right. Mr. Burney, the potential other rebuttal witness.
I'd like to read the other stipulations in your honor, if I might, in rebuttal to what was just read.
Four.
Right.
That's fine. You can proceed.
Thank you. I'm just going to read the remaining stipulations that we've agreed upon. Number 1, plaintiff Reynolds Renovations, Inc. is a Georgia corporation with its principal place of business at 1360. I'm going to omit the address. It's the personal home of Mr. Reynolds as well, if that's okay, Your Honor. Any objection to that, James?
No objection.
Thank you. Defendant Regina Maia is an individual resident of Fulton County residing at address, the property. Number 3, defendant owns the property. Number 4 has been read. 5 and 6 have been read. The construction described in the contract was primarily funded by a grant sponsored by the U.S. Department of Veteran Affairs. 8, Mr. Ordonez was a disabled veteran. 9, Mr. Ordonez's disability was related to his military service. 10, the VA provided a grant to fund the construction with additional funds to be paid by defendant. Number 11, plaintiff started work on the project on or about May 20th, 2021. Number 12, on or about March 10th, plaintiff sent defendants an invoice for work completed in accordance with this agreement. At the time, plaintiff identified this as the final invoice for work completed. 13, on or about June 13th, 2022, plaintiff filed a claim of lien in the amount of $7,536.50 on the property. Number 14, the city of Atlanta issued a certificate of occupancy for the ADU. And number 15, former defendant Antonio Ordonez passed away on February 18th, 2023. Thank you.
All right. And Mr. Burney, did you say you also, this other witness that you potentially were going to bring, is that witness available?
Not at the moment, Your Honor. I was anticipating that the expert would go first and then we would contact them and see they are very close. They may be able to be there before 11:15.
All right. Why don't we do that? And members of the jury, I'll take something up outside of your presence and we'll be back with you when we can resume the evidence.
All right, the jury.
All right. As to the issue of Summer Bitten, so this is the sole witness that it appears plaintiff wishes to call that is listed on the pretrial order, but was not included in response to any interrogatories. And first, let me just kind of put this in an evidentiary context. After reviewing Georgia Rules of Evidence by Millich, I'm looking at section 14.8, which talks about rehabilitating an impeached witness. It says that until a witness has their credibility attacked, that rehabilitation or character evidence is generally not admissible. But when a witness is attacked and can be attacked by proof of a prior inconsistent statement, which is what I think was pursued by the defendant here when we started talking about that prior lawsuit and the results of it and whether that was accurate testimony during Mr. Reynolds' direct examination. So Mr. Reynolds' credibility having been attacked through a prior inconsistent statement, now the plaintiff would be allowed to introduce or attempt to rehabilitate his reputation in the community for truthfulness or a character witness's own opinion of the subject's truthfulness or both. And that same witness can then be impeached themselves or cross-examined as to shortcomings in their knowledge or other things along those lines. So that's just to give you a sense of evidentiarily speaking, where I think we are. As to the more pressing point, which was raised by Mr. Craig of why this wasn't included in the interrogatory response, he cites in his initial motion primarily relying on the Lee case and the four factors that are there. And in looking at that, I'm also taking into account there's a Dunwoody obstetrics, I'm not quite trying to pronounce that case as well from 2022-363, Georgia Appeals 90. That's one that I think is actually more on point, that talks about where someone didn't identify someone in an interrogatory and that was found to be misleading or intentionally deceptive. And again, taking into consideration all of these cases and many of the factors that Mr. Craig raises through the Lee case and other cases that have talked about where a rebuttal witness is left entirely out of a pretrial order, it was found to be error not to allow such a rebuttal witness to testify. And so relying on those and kind of what's been presented to me as to the impact this witness would have, I don't think it would be the appropriate remedy for me to exclude the testimony of Summer Benton entirely. If Mr. Craig, you want to be able to talk with Summer Benton before she takes the stand, I certainly can grant that time if you want to just kind of preview her testimony and meet with her. Is this the homicide detective, Summer Benton, by the way? Okay. All right. So you can meet with her out in the hallway and just kind of get a preview and you tell me how much time you'd need for that. It sounds like this, and generally I think these character witnesses are 5-question directs. And
I could preview it because I don't want to get in any
Sure.
trouble or I'm going to ask her who she is, what she does, about her occupation to lay some foundation for who she is. I'm going to ask her how she knows Simon. I'm going to ask her what's her own opinion of his character. And I'm going to ask him, what's his reputation for truthfulness as far as she knows. And that's it.
all right. So with that, Mr. Craig, anything that you want to preserve for the record or response?
We'll just preserve our objection, but thank you to the court for such a thorough consideration of the motion.
Well, appreciate that. Do you want to be able to meet with her before she takes the stand?
Yes, I think that would be just fine. If we have some time, we might as well use it productively, and I'd be interested to meet with her and chat with her for just a few minutes.
All right. And so guess I would, since she may only be a 5 to 10 minute witness, I would say we'll probably just plug her in first before your expert arrives. Have you?
So sorry. I have told Summer to be here at 1:15.
Okay. We had told her to be here at 1:15, Your Honor. We thought that would be a good guess.
I mean, if she's just at APD headquarters down the street, can we just ask her to start walking this way?
I think, I don't know, we can, but
Well, I certainly can. I wasn't going to do that, Your Honor, until.
just say Judge McAfee's asked if you could possibly come as soon as possible.
She'd probably rather knock it out than just be left at some indefinite.
Got a 3:30 in this courthouse.
Right. And where what I'm seeing potentially as the road ahead is if we're able to hear from her, we're able to hear from the Mr. Blanco, we can push that, we'll see how long his direct and cross goes, but potentially it sounds like we could be resting both sides closer to maybe 1 and let the jury go on a kind of an extended lunch break while we hear any motions and then break as well and then come back for a charge conference. I could see that as potentially our road.
I'm sorry, Your Honor, I've just been distracted because I noticed my clock was running.
Well, right, and I was going to say, and I'll pause it now, but I would say that this time would fall on you since it was your case and you don't have a witness here ready to go, right?
I understand.
I'll pause it now just because this would be a discussion we should have. Whether I was going to need to make this ruling regardless, but if we're killing time for another 30 minutes because we didn't have witnesses available, I think I would see that as falling on you. I think theoretically it would be in my power to force you to rest at this point, which is kind of the expectation in our criminal world, but I don't think that we're going to do that here. So
I appreciate the
All right.
court's balanced approach, and I do apologize for any unnecessary delay.
So, and you're saying 115 is, or excuse me, 1115 is still his ETA? And for Detective Benton?
She's on her way.
We're told she's on her way right now, Your Honor.
Okay. All right. Then we will go into recess, I think probably until Detective Benton arrives. I'll let the jury know we're going out of order again. And then as soon as your expert's here, we will take that up. Any idea, again, just so I can try to plan of how long I push into the lunch break for the jury, any idea how long and how much time you were looking at for Mr. Blanco on direct?
Well, Your Honor, I will try to be as quick as possible. I know I'm limited to the shot clock there, and I'll definitely get it done in that time. And then at that point, I would be essentially resting. I might have to leave a little something for redirect, but hour and a half.
Okay.
I might go faster. I'll try to, but
So it seems to me we're likely to need to give the jury their lunch break before we would come back and complete evidence, just so we can plan accordingly. And that's just where the chips fall. So with that, I guess the last thing I'd inquire is, I'd asked yesterday if the parties still have the expectation of needing the full 2 hours, or if there's some agreement on if there's some amount less than that. Start with you, Mr. Burney.
For the closing, Your Honor,
Mhm.
I can't anticipate it taking more than maybe, I don't want, definitely not 2 hours for me. I would think I could definitely do it within an hour.
Okay, Mr. Burney is proposing an hour.
yes,
Correct.
that would be agreeable.
All right. And I'm not going to rush right into it. I'm going to let y'all to, give you some time to collect your notes and thoughts and everything. And we could always bring back the jury and charge them tomorrow morning if we're, depending on where we fall.
I think it's a good idea if we can we promise the jury to get the case today. I'd like to help do that if we can.
All right. I'm certainly here to facilitate that as well. What was I going to say? In terms of, I don't have the statute at my fingertips though, so y'all have to remind me here, especially when folks are bringing claims against each other. I think you typically would have the right to open and conclude, but because there are counterclaims, you do not? Or did you plan to open and conclude?
Case, I think the plaintiff always gets an opportunity to open and close and to split it up as if they choose to.
Okay, let me,
I would reserve that right.
yeah, and I'll double check. I think it's complicated when there are counterclaims, Brock, because he's technically a plaintiff too.
I'll look as well, Your
Yeah.
Honor.
All right. Yes, sir.
Oh, I was just going to comment on that issue if the court will
Feel free.
allow. So I think, at this point, our counterclaim is much larger. I mean, we haven't put in evidence of our damages yet, but we've got a much more substantial claim than the plaintiff. The plaintiff's claim at this point is $7,000. We're claiming construction defects and all these repairs needed. As the court might easily infer from that, the cost of such repairs much, much greater than $7,000. We also have more counts, more complexity, and essentially we have become the plaintiff in this case. So to that end, we would request the right to go last at closing.
So that's, here we go. And I think I've got the answer here. So that would be a new one for me in terms of a legal theory that we can swap things around just based on who has, the volume of evidence. I think it's just, I'll just do this. I'll give you a site here. I think I have it handy. 273 Georgia 370, excuse me, 273 Georgia 735. And my note for this case is, if counterclaims exist, plaintiff does not have the right to open and conclude. So I will check that site make sure that's still good law.
Do you have that site handy again, Your Honor? I was just gonna.
Sure, it's I have it as 273 Georgia 735. I'm trying to reacquaint myself with it here.
The update on Pablo. Okay, all right, that was 9. That's okay. Okay, he might be here.
Your Honor, if I may.
Yeah, that's fine. I mean, the case
Is
isn't,
that what happened there was that one party's cases, all their claims were dismissed. That's why the order changed. And that because they bore the burden of proof. Here, we both have it. You know, I think that there is, and not that this is the issue in this case, but that's why there's races to the courthouse.
all right. The case isn't quite as crystal as I remember it, so I'll keep looking at the issue. And for now, let's just go off the record. And whenever Detective Benton arrives, it'll be, we'll put her up.
Sure. Wait.
Second, I cut you off. No, no. I didn't know if you were going or not. Keep it the same. Not ask her. She said, "It's fine." I said, "Fine." Might hold it into that. Okay, but that would be excellent. Good, good. Good, good.
Yeah. Good. Doing okay? You feeling all right?
She was just being so difficult. I think the jury saw she's being tricksy.
She is. She's cute. That whole, come on, get a tear. I can get a tear in a minute. I just have to think about things. I think about my hero, the lightning nut job that got shot yesterday. That makes me cry for the country.
And then the freaking that, and then the girl, and then the school shooting, the high school.
Evergreen already had a shoot.
Katie, you look so tired. Man.
I'm so
You
tired.
didn't go out last night, did you?
No, I went to bed.
Glad to hear it.
I don't drink during the week normally.
Normally, unless you're around your attorney.
Yeah.
Don't say those things.
Yeah.
You know, when I was in grad school in Louisville, there were all these little bars all the way up and down on the way to campus. And because there was so much shift work back then, this is the 80s, guys would get off work 6 a.m. They'd be in a bar. And it's so strange to walk by bars and see people.
Yeah, like when you're going to class, you're like, I just got up.
What are you doing?
I know. I'm hoping they need one after today, but
I knew they were gonna come out with some freaking text messages. I mean, the thing is, none of them are relevant to any of the issues.
No. And I was wrong when I spoke earlier this morning on the property quality of it, but I did say go out and have him talk to Ed. It's okay.
Say it again.
I labeled it, but I said, she gave, I said, thank you, go talk to Ed, take care.
my son's on the live stream right now, and he just texted me and goes, I don't drink during the weekdays normally. It's because of that. Shut the fuck up, Arslan.
Great, great, you guys. I'm glad I changed the topic from the case.
Turn this on. Yeah, we're on recess right now.
Arslan, go away.
That's funny.
He said, tell Chris I
Oh.
said I love him.
We're not gonna have, Karen back or.
Could you send that extra jury instruction?
Yeah. Thank you for reminding me.
Yeah, of course.
Morning.
Good morning, how are you?
All right, I didn't even know you were here.
Right now, they're necessarily excellent.
No, I was laughing at your comment yesterday that sometimes the law clerk talks more than the judge.
Oh, I have seen it happen.
That's why we have a chat.
Yeah. Well, there was one judge that like made her read all the case law and all of like, I can't remember his name. He was older. And I was up, it was like near Canyon somewhere. But yeah, like, you know, he was just very,
No, that's fine, sweet.
made her do a lot. Yeah, she had to read a lot of stuff for him, so.
Oh, yeah, I'm reading everything.
Yeah,
Yep.
so, yeah, some of y'all are.
So I don't look up very often.
It's funny.
Well, good to see that. I guess it affects his-
You know how those retired ones here.
Hmm.
It opens up the city, see that.
I think everyone has their own comfort level and their philosophy and style, so.
I had a judge here and the trial was.
I wonder if it's because we're not on the works, like.
I got some error that said something like, I manage work.
That's right.
I wonder if it's because we're not like on their server.
Oh, I wonder. That could be. I can save it to the OneDrive.
Oh.
I'd much rather be at my lake house. Yeah. Yeah, literally had a shot with the judge. So that was pretty cool.
I'll let them
I
know.
mean, you can't really complain to anybody. You can't really complain to your staff or.
Summer's on the elevator. I don't know if that meeting is just him
Tough
and
job.
her.
It's the election. Never had.
Could you let His Honor know that Summer is on the elevator and coming up?
Oh, great news.
Yes,
Yeah.
ma'am.
Let's not rush into this. I gotta get these things over here. Hold on.
I'm not Russian. Russian.
Can I spell her name?
Yeah, it's Summer, Benton, Benton. Chris wants a minute, man.
I'm okay. It's fine. I don't want to delay anything. Let me get this. I'm just trying to get this to you. Planet's gonna. What was that? What's happening? Page 11.
Oh, no. What went? Yeah, it's like, okay. Yeah. Air one.
What the hell's happening here? And you're not bring 55-gallon drum.
You said I'm a thirsty girl. I like my water.
Hardly enough gin and juice for a young one. Oh, boy.
How else do you think I get my morning started? I'm ready to shower like gin and tonic after this today. That's my plan. I'm finally getting sushi tonight, so
Where you going?
I don't know. My friend has like some new place she wants to try.
I'm gonna do that. Don't hurry, whatever it is on my son.
I don't know if it is.
No, but I gotta go.
I believe your witness may be here.
Okay.
All right.
Let me have a minute with her. Get these down, James.
Okay.
I don't even know.
I let the court know she was on the way out.
Okay, thank you so much, Mr. Reynolds.
Tell anybody that I had that I didn't use it there.
I left her bees and rice for 2 days ago, staying right back. I still have to go to inside, but it feels better now that I'm off it. So.
What's on the main seated?
Mhm.
Do you mark the stipulations? Do they have a number?
He did.
I just have a number.
Yeah, I think he marked it as fence 123. And we can clarify that on the record.
Your Honor, I understand the detective is here.
All right, then
Confirm this meeting.
if you want to step out, feel free. Okay,
Very much, Your Honor.
all right.
See, if I'm gonna drink an energy drink, I wanna feel like I'm invincible. I wanna feel like I'm super.
They call that whiskey.
I hate whiskey. Chicken girlfriend for the first time.
Wait, Mr. Reynods, you said a name on the first day of the trial. Gumbe Anya?
Jumbe,
Jumbe.
Jumbea. Jumbe. And his wife's name's Anya. Is Azayye. So African Ugandan word or Kiswahili for
I've been meaning to ask you that.
I know it didn't help much, but actually, as a traveler, you might know when they have djembe dancing, it's stilt dancing in the Caribbean, and Brazil, Africa. The djembes are spirits. And if, they call it mako djembe when you're dancing, but the djembe, they say, listening. So people that I worked with in the Caribbean, they reversed my name, so I wasn't signing as a woman. So I'm coming back. But it's done with that yet. Because the guy I worked for from Angola, his name was Nathaniel. They called him Tanny. I said, why do you call me a Tanny?
Detective Benton's ready, Your Honor.
Okay.
Thingy. It's so crooked. My goodness. That I think made it worse.
Ranger.
Oh, okay. Yeah, then y'all come on up. Morning.
Morning.
Good morning.
Y'all weren't firing yesterday?
No, Judge left. No, yesterday was Wednesday.
Oh, you just Monday, Tuesday, Thursday, Friday? Oh, okay. I thought you were Monday straight through Thursday now.
No.
Okay.
Wednesday off from Bobby on Friday.
Yeah,
Like not.
it's all good. We'll be here.
Thank you, sir. Thank you so much.
Good morning. Thank you, sir. A little heavy. A little heavy.
It was their first day today. So
Okay. That's a brand new one?
still got the training. on.
All right, returned in open court. There you go. Thank you so much. Take care. All right, why don't we go ahead and bring in Detective Benton? It appears like Mr. Craig's back and we'll go on the record here. Yeah, that's
Be the issue that it does sound.
Want me to go get her?
And Deputy Scott, if you can go ahead and start corralling the jury. I think someone's got to step out and grab the detective.
Yeah, go ahead.
Oh, thank you very much. We're not.
Yeah, that's the style of the case.
Yes.
Hmm. All right, ready to go back on the record? All right, we are back on the record. We've got all parties in council present, and I understand Summer Benton is here, ready to testify, and so she's making her way down. Let me first note as well, housekeeping, I think it was Defense 143, which was tendered and marked as a full copy of the admissions from the pretrial order, so just making sure that exhibit number was accurate. Is that right, Mr. Craig? 143?
143, was that the
We thought those were the
I
stipulations.
thought that was 123.
123, thank you. Okay, so we have that corrected for the record, 123. As it relates, I just want to flag this, is the issue of the order of closing arguments. I went back and had a chance to read that case I cited to you all, and I don't think that case said what I thought it says. So it really doesn't answer the question we're at here. And so, we've got OCGA 9-10-186 and Uniform Rule 13.4 is really our only point of guidance, and only about a dozen cases that have looked at it, and none of them cite counterclaims. And so it seems like it's completely silent on the issue of counterclaims. And the statute itself, though, reads that if the plaintiff has the burden of proof, they get to open and conclude. And so, Mr. Craig, I'd say preserve your objection, and perhaps you can go get some guidance on that one day. But I think I'd follow the statute and what we have.
I think you've done an exhaustive search, Your Honor, and
But there's not much to look for. I mean, it's
Yeah.
all kind of on its lonesome there. So to that end, I think, Mr. Bernie, you would be allowed to open and conclude closings. And then I'll note, you can review this over our lunch break. We've got a proposed verdict form for you to take a look at. And we try to delineate this all out through and make it really more specific as to giving them some guidance of how to fill it out and how to make findings as to each particular party. And we don't have to talk about that now. I just want to let you know that I provided you with a copy, and you can share your thoughts when we get there. And we'll also have a copy of the consolidated request to charge as a starting point for our charge conference. So with that, unless there's anything else, we'll bring back the jury, and I'll let them know this is now Mr. Bernie's chance to call a witness.
Not for the jury.
Around.
Yes.
Thank you. Please be seated, everyone. Members of the jury, thank you for your patience. As you learned before we broke, but due to some witness availability issues, we're going to go out of order again. Mr. Bernie, and on behalf of the plaintiff, seeks to reintroduce his own evidence in rebuttal. And so we're switching back to the plaintiff's evidence, and Mr. Bernie is going to be calling a witness. So, Mr. Bernie.
Thank you, Your Honor. We would call Detective Summer Benton, please.
This motherfucker's the testimony of the matter of this case is the truth and nothing but the truth, so help you.
I do.
You may be seated. Please explain your name to the court.
Summer Benton, Summer. R is my middle initial. Benton, B as in boy, EN, T as in Tom, ON.
Good morning.
Good morning.
How are you today?
I'm good. How are you?
Thank you for being here.
Mhm.
You're here of your own volition, correct?
That's correct.
You're not under any subpoena.
No.
Okay. And can you state your occupation?
I am a homicide detective for the City of Atlanta Police Department.
And how long have you been in that position?
I have been with the Atlanta Police Department for 24 years, almost 24 years, and I've been in the homicide unit over 16 years.
Okay. And are you familiar with Simon Reynolds and Reynolds Renovations?
Yes.
How do you know them?
I first met Simon when I moved into Chosewood Park over 20 years ago. He was a neighbor, and then he became a contractor for me.
Okay. And how would you describe your relationship with Mr. Reynolds?
Amazing. He has been nothing but spectacular in every aspect that I have asked on a business standpoint. He's been trustworthy. He's been honest to a fault. And I've recommended him to numerous people, friends, family, for his work.
And when was the first time you engaged with him in a business context?
That was when I bought my own house still in Chosewood, and actually had him do a full renovation of my home.
And that would have been approximately what year?
I want to say 2003, 2004.
Okay. And what is your opinion of Mr. Reynolds' character for truthfulness?
He's extremely truthful, almost to a fault. I've never caught him in any type of lie or deceit.
Okay. And do you have an opinion as to or understanding of his reputation and character in the community?
Yes, got an amazing reputation in the community, especially within Chosewood and the Grant Park area. He is constantly being called upon to do work, or just if he sees a neighbor in need, he comes and assists.
Thank you so much.
Cross-examination.
No questions, Your Honor.
All right, thank you, Detective. Take care. All right, with that, I think I might have seen someone walk in who's,
Yes.
we'll switch
Mr.
back
Blanco is here.
to the defendant's case, and defense may call their next witness.
All right. Defense calls Pablo Blanco. You want to get, thanks so much. That on silent? Is it on?
Just going to leave it.
Oh, is it silent?
Yeah.
Okay, great. Thank you for being here, Mr. Blanco.
Hold up, Deputy Scott.
Sorry.
But for the testimony, the matter of this case is the truth and nothing but the truth to help you.
Yes, I do.
Or speaking clear into the mic, would you state and spell your name for the court?
Pablo Blanco.
Spell it as well.
EABLOBLANCO.
Thank you, Mr. Blanco. Thank you for being here.
You're welcome.
What is your occupation, sir?
I'm a general contractor.
A general contractor?
Yes, sir.
And how long have you been doing that for?
Since 2013.
And are you formally educated in contracting or in construction?
Yes, I am. I got a bachelor degree of architecture and a post degree in architecture, but I'm not a registered here, so I work as a GC.
Okay, so you are, you said you have a bachelor degree in architecture, is that right?
Yeah.
And then another degree in architecture?
Yes,
Okay.
it's a post degree.
Post degree?
Yes.
Okay. And where did you get your bachelor's degree in architecture?
From the college in Uruguay in South America.
In Uruguay?
Yes.
And where did you get your postgraduate degree in architecture?
In Barcelona, Spain.
In Spain, okay. And what was the name of the school that you attended in Barcelona?
Politécnica de Cataluña.
Okay. Now, what do you do currently? You said you're a general contractor. How long have you been working as a general contractor?
Since 2013.
2013. Okay. And what kind of work do you do as a contractor?
I do commercial and residential.
I see, both
Projects.
commercial and residential. Okay. And are you doing renovations mainly, or do you also build entire buildings?
Both.
Okay. Now, I understand you are getting paid for your time today. I just want to talk about that briefly.
Yes, I am.
Okay, now you're laughing a little bit
Yeah,
about
because
that.
I didn't check how much.
You don't know how much? I see.
I know it's written, but I haven't checked.
I see. Are you a professional expert witness?
No,
Okay.
my first time in court.
Is it your first time in court?
Yes, on this side, yes.
I see. So are the fees from your testimony today a substantial portion of your income?
No,
All right. And is the fact that Mrs. Maia is paying you for your time today, is that going to affect your testimony?
no, sir.
Okay. Are you still able to give objective and unbiased testimony, even though you are being compensated for being here?
I will try my best.
Okay. So you're an architect and you've worked in as a general contractor since 2013. Are you familiar with the general business practices of the residential construction industry?
Yes, I have a license. That means that I took exams.
Okay.
So when you take a GC exam, you have one that is for construction and the other one is for law.
Oh, very interesting. So you have a general contractor's license?
Yeah, I got two. One, which it is residential and commercial, and then I upgraded my license to a full tier GC.
Okay. All right.
Sorry, I didn't quite understand what you said, sir. What kind of GC?
Full tier, that means I have no restrictions. I can do whatever my insurance lets me.
All right. And are you familiar with construction contracts then?
Yes, sir.
And are you familiar with construction project financing? How? Go ahead.
Yes.
Okay. And have you been to, are you familiar with the property that is at issue in this litigation today?
Yes,
And have you been to that property?
I did.
Okay. And did you inspect the property?
I did a walkthrough, yes, and I inspected it.
All right. And are you familiar with the work that has been done?
Yes,
Okay. And did you observe any defects in the work that was done there?
there were some defects, yes.
Okay.
Your Honor, could we have a quick sidebar, please, just for a moment?
Okay.
It's interesting. Right now.
It's like, Simon, I appreciate you making the effort to keep doing it. He said, my daughter is very snooty, but it's Spanish.
All right, Mr. Craig, you can proceed.
All right. Your Honor, I'd like to tender Mr. Blanco as an expert witness.
Mr. Bernie. Question to,
Your Honor, I would object to the tender and that it doesn't say what the expert testimony is going to be about.
usually you're asking to voir dire the witness or Rather
You tendered
just-
the witness as an expert.
that's
I
right.
think you should say what kind of expert it's
yeah,
going to be.
in the field or on the subject of what exactly, Mr. Craig?
Okay. An expert in the field of general contracting and residential construction.
And Mr. Bernie, back to you.
Thank you, Your Honor. Good morning, Mr. Blanco.
Good morning, sir.
How are you today?
I'm doing good, nervous, but good.
I'm sure. I'm not going to try to make you nervous, but I do have to ask some questions just to talk about your ability to be an expert with us this morning.
Sure.
You stated you've never been given expert testimony before. Is that correct?
Yes, sir.
Okay. And you said that you've been licensed as a contractor since, I think, did you say 2013?
Correct.
Okay. And do you have you completed contracts under the Department of VA, the Veteran Affairs?
Never.
Okay. So you're not familiar with any of the regulatory schemes of the Department of Veteran Affairs?
I never dealt with them. No,
Okay. And when you when you came to look at the property, how long were you at the property?
say that again?
You came to see, I think you testified you went to the property at issue in this case?
Yes,
And how long were you there?
maybe 1, 2 hours.
Okay. And what kind of documents, things do you review on an ongoing basis to establish yourself as an expert in this field?
Just any type of drawings, any type of projects like restaurants, bakeries, homes.
Do you have a continuing, do you regularly study or attend courses?
Well, I studied. That's why I upgraded my license a year ago, 2 years ago.
And how many hours of study did you do for your license that's current now?
Oh, well, I got both of them, but for this one, I quit working and I committed to study for 30 days, full day. It was hard
Okay,
because I forgot about it, but I made it through.
okay. Your Honor, I would have a motion, I think, regards to Mr. Blanco. I don't know if you want to make it now or outside the presence of the jury.
If this is do you want to tell me what?
The essence of it is, Your Honor,
paragraph
this is
number?
a contract under the VA. Mr. Blanco has no experience under the VA and is therefore, I don't believe he is fit to be an expert witness in this case. No offense to you, sir.
Okay,
But,
understood. All right, on 701 grounds, I think that I'll overrule the objection and allow him to proceed under the fields of general contracting and residential construction and any opinions he has to offer on those subjects.
All right, thank you, Your Honor.
All right, Mr. Craig.
All right, back again, Mr. Blanco. So, earlier I had asked you if you were familiar with let's see, sorry, lost my place here. I asked you if you were familiar with the business practices in the construction industry and project financing. And I've got a question for you about that. Now, in the construction industry, is it common for a contractor to expect a deposit when starting work on a job?
Yes.
Okay. And is it common that the job is financed by a third party, like a lender?
Yes.
Okay. So when a job is financed by a third party, such as a lender, or in this case, an institution that is providing a grant, the Veterans Administration, does the provider of funds typically pay out those funds in installments?
Objection, Your Honor. This is a VA contract. Mr. Blanco's testified he has no knowledge of the VA contracts. He shouldn't be able to provide an opinion on that.
All right, I didn't hear the question as confining itself to VA contracts. It's just more general practices in the field. So to the value that's worth it, that's up to the jury. Mr. Craig, you can proceed. Objections overruled.
All right, I'm going to represent the question and I'll take out the reference to the VA just to keep it straightforward. So, Mr. Blanco, when a lender is providing funds for a construction contract, do they provide all the funds upfront?
Usually, what happens is before you start, you got a contract, and in the contract, you got the payment, how you're gonna get paid.
Okay,
That's how it works. Then whenever, I don't know, usually it's once a month, you write up your pay application, you send it to the lender or whoever is paying, they will come inspect it, and then you will get paid.
okay,
That's a regular, that's what norm.
okay. So, do you usually take a deposit at the start of a job?
Yes, that's a dream. Not always. Sometimes a lender doesn't, but you can negotiate. You
Okay,
can negotiate. Sometimes they give it to you, sometimes they don't. It's negotiable.
okay. And when you get a deposit at the start of the job, is that deposit, well, let me back up just one second. Do you ever work on a fixed price basis?
Most of the time, yes.
Okay, so you have a set price for the job, a specific number?
Yes, sir.
Okay. And in those cases, when you collect a deposit from your customer, is that deposit then added on to the price of the job so that it increases the total above the contract price?
No, sir. That's an advance payment for materials that you need to buy to start to work, maybe to pay some guys to show up, but it's part of the contract, yes.
Okay. So then once you're getting paid by the lender or for, the work done on the job, does the deposit get refunded back to the customer?
Yes.
Okay.
At least that's what I do.
Okay. All right. Is your practice typical of the construction industry?
Yes, because whenever you start, you got a set price. If the advance your money is from the amount, the final amount, yeah, it's
Okay.
advance money.
Right, right. It's not a price increase.
No.
All right. Now let's talk about some specific features of the property and some of the defects that you identified. And I'm going to show you an exhibit here real quick. Small one is small. Because I think it's going to come up on his screen. I don't think it has, it's not marked either. So the plaintiff has a copy. Just one moment, sir. We're getting a copy of the exhibit for you. Yeah, sorry, we'll get there. Wow. Do you have stickers? Let's just mark it. Yeah. So this is his. All right. We're gonna have that on the screen. for you.
Okay.
And we're coming up on exhibit 1. That one, please. All right, so I'm showing you a document that we marked with a sticker as Defendant's Exhibit 6. Okay, so that's our Exhibit 6. Do you recognize this document?
Yes. Yes.
And, all right, and have you seen it before?
Yes.
All right, and is this a site plan for the project at issue in this case?
Correct.
All right. Your Honor, I'll move to admit Defendant's Exhibit 6. Any objection?
Oh, no objection, Your Honor.
C6 is admitted.
All right. Now, Mr. Blanco, could you turn around and just look at the screen behind you? We've got it blown up on the screen there. Could you point to the house? Okay. And is the house there positioned flush against the boundary line of the property?
Yeah. This is the property line.
Okay. And when you visited the property, did you observe that the house was built flush against the property line?
No, it's a little bit away from the
Okay.
property line.
And is it moved to the east?
This way.
Okay.
Yeah. Yes.
All right. Now, can you point to the driveway on that diagram? Okay. All right. All right, let's do, actually. Now, when the house moves east, what effect does that have on the driveway?
Well, it's invading the driveway here.
Okay. All right, let's go to 3. So, based on this plan that you see before you and your observation of the house, is the house positioned in a manner that is precisely consistent with this plan?
No.
Okay. And-
Hold on. No, according to a survey that is as built.
Okay, all right. So you've seen an as-built survey of this property?
Yes.
Okay. All right, let's give him that. All right. Okay. We've got a big one for you.
Oh,
Have you look at this real quick. Then you can fold it back up and then get it up on your screen. All right, do you recognize this, sir?
yes.
Is this a survey of the property?
the as built? This is the
Okay.
final result.
All right. So, Your Honor, we'll move to admit Defendant's Exhibit 100.
No objection, Your Honor.
It's admitted.
All right. Mr. Blanco, does this provide an accurate description of the property?
Yes, there's a survey here. Yes.
Okay. All right. So we've got that up on the screen for you now. And where is the border of the property on this survey? I'm sorry, the west border of the property.
This one.
And where is the west wall of the house? Okay. And is there a gap there between the border and the wall of the house?
This one Doesn't say how much, but there is one.
Okay. Now, does this comply with the, the normal and standard practice in the construction industry to build the house in a position different from what is shown on the plans?
No, no.
Okay.
Usually you get stakes that show you where's the property line, and then you go to the drawing and see where you need to do that wall, where you need to have the foundations and all that.
Okay, so there would be stakes on the property line. You'd be expecting to see those? And
Yes.
that would tell you right where to put the house, right?
You need to have the stakes so you know where's the property line.
Okay, and based on those stakes, you can see where the line is, right?
Yeah.
Okay. All right, I'm gonna move to a photograph now. We may come back to this exhibit later. Let's go to 55. Well, all right, yeah, let's do 55. Has it been tendered? All right. All right, so we've got a picture on the screen behind or in front of you, a picture of the driveway. And when you were at the property, did you observe any problems with the driveway?
Well, it's not as planned as a plan, and big like a pickup truck or some kind of a car, like it is a little bit big that doesn't have a good radius of turning, it's going to be pretty difficult to access that ramp all the way up. If you see this is the as-built, but if you see this other one, the curve is much less, so it's going to be much easier, this one than this one.
Okay,
Plus, on one side, you got a retaining wall, so
okay,
not that you can turn and get one wheel on the grass and go up. No, you got a wall over there, so it's kind of difficult.
okay. Let's get him the as-built survey back up on the screen. All right, so we've got the as-built survey there for you. And could you point on the screen again where the driveway is on the as-built survey? And you're telling me that that driveway was not done according to the original plans, is that right?
Yes.
And that retaining wall is on the, what side of the driveway? Okay, so, and you said the curvature of the driveway was greater than what was in the plans?
Yeah, you don't have, on the drawings, you don't have this.
Yeah, okay. And was that porch, that wraparound porch on the original plans?
It doesn't show.
Okay, all right. Let's go back to the as-built.
Wrap around, you mean, the whole thing?
Yeah, the porch there.
Oh.
Okay, so is this driveway, now you said the driveway, it was difficult to get a vehicle up the driveway, correct?
Yeah.
Okay, and that's, that's because of the curvature and the presence of the retaining wall, is that right?
Yes. I think it's kind of difficult to maneuver.
Yeah, okay. So would you say that this driveway is built is sufficient to satisfy the standard of care in the construction industry?
It all depends on what the owner, I mean, when you got a contract, you got to do by the drawings. If not, you don't get paid. You're going to have problems. So you try to be as faithful as possible on the drawings. If you do changes, you got to do change orders. They need to sign the change orders, and then you do stuff. Because if not, it's problems.
Okay. So the standard and conscientious practice in the industry is to follow the drawings?
Yeah.
And if
If you
you're,
want to get paid, yes.
okay. And if you're going to deviate from those drawings, you confer with the owner of the property?
Yeah, of course. You got to send a change order. They need to sign it, agree with it, you put the cost of the change order, and then after it's signed and agreed, you can do it.
Okay.
If you don't do it that way, you're gonna be in problems of getting paid. That's the norm.
So would a reasonable contractor go about making changes on the property without conferring with the customer?
Sometimes it can happen because you need to do it there in the moment at the spot,
Yeah.
but it's not the best because that's always problems.
What about for major changes?
No,
Okay. All right, I'm going to show you another document. Go to the diagram. Zoom on in. Yeah. All right, Mr. Blanco, I've just got a diagram in front of you, okay? And does this resemble the site plan, the original site plan?
yeah,
And has somebody written on this and drawn on it
yeah,
in purple ink?
yes.
All right. Now, what do you think is depicted there on that?
I don't know, it's not clear. I mean,
Would you rely on this as an amended site plan to make changes to the property, such as a change to the porch?
who wrote it?
That's a great question, sir. Unfortunately, I can't answer your questions for you, but I just want to have you look at this diagram and consider the drawing that you see there. And my question for you would be, is that an acceptable way to plan out a modification to the property?
No,
All right.
it needs to be signed by the owner always.
Okay. All right. Now, I want to point to the drawing for you. I'm going to come up. You see this right here?
Yeah.
All right. Lexi, can we get the as-built survey back up? All right. On the as-built survey, do you see a structure that appears to correspond to the purple lines?
Porch.
Okay. All right. Now let's go back to the drawing, Lexi. All right. Now on this drawing, what is this area right here?
This?
Yeah.
This driveway.
All right. So now, is this porch
Oh.
sticking out into the driveway?
Yeah, here.
So is that now, does this drawing show any adjustment to the driveway to account for the porch?
No.
Okay. So this drawing appears to make a change to the porch, but it does not make a corresponding change to the driveway to adjust for the change in the porch. Is that right?
Yes.
Now, does this comport with the standard of care in the construction industry to make changes like this?
No, but hold on.
Okay.
I think that, I don't know how they were interacting, the person doing the construction, the owner, sometimes in the field, you just say, hey, I'm going to do this and that. And she says, okay. And you take that as okay, she's in with it.
Okay.
But as a businessman, you got to cover always yourself. So you need to write it up and she needs to sign it. That's the only way you can do modifications with the acknowledge or not verbal, but written that she agree with that. But it
Okay.
happens that sometimes, I'm going to do that. Oh, okay. But then you got to follow up and write it down and send it.
Okay, so you can do an informal change like this as long as the owner agrees with it, right?
Yeah. Of
Okay.
course.
All right. Let's do Exhibit 74. All right, Mr. Blanco, I've handed you what's been marked for identification as Defendant's Exhibit 74. Are you familiar with this photograph or what is depicted in it?
Yeah.
Okay. And does it depict the floor in the ADU?
Yes.
And what are you looking at there?
A floor that is wavy, is not correctly finished.
Okay, is that a defect?
Yes.
And is a wavy floor up to the standard in the residential construction industry?
You won't get paid.
Okay. So what can be done about a wavy floor like this?
You have to remove the flooring and then level it with self-leveling compound.
Okay. Is that an expensive process?
Well, you need to remove all the flooring, so you're going to have to supply new flooring plus the compound. Yeah, well, yes, it is.
Okay, all right. And, while we're talking about fixing things, let's go back to that driveway. Can we get the as-built survey back up? So what would you do to fix a driveway like that?
The best way would be like to modify this. But in order to do that, you need to remove the retaining wall, you need to do grading, you need to do fencing, you need to do the gate.
Okay, all right.
Hold on, that's my solution. Maybe somebody comes with something different.
Okay, but you could solve this problem if given the opportunity.
Yeah.
Okay.
Yes.
And could this problem have been avoided if with more careful planning?
Yes.
All right. All right, let's go back to let's go back to the site plan. All right, Mr. Blanco, visited the property. Do you remember what this structure is?
That's a walkway.
Okay. And now please take a good look at that walkway. And Lexi, I'm going to have you switch back over to the as-built survey. Now, is the walkway in the same position on the as-built survey as it was on the site plan?
Now, it used to connect here on this side of the deck all the way. So you can walk all the way straight.
Now, okay. Now, is there anything inherently wrong with moving the walkway up there? Anything wrong with moving the walkway north?
I don't see, no, I mean, if the owner is okay with it, sign it that you're moving it.
Okay, so if the owner signs off on it, it's okay. But if the owner doesn't sign off on it and doesn't want it moved, is that okay?
Problem.
Okay. All right. Now you visited the ADU and did an inspection and did you look at the electrical?
I did.
And was there any problem with the electrical?
There were some minor problems. I think the breakers were not working or they were jumping. I mean,
Okay.
actually, that's what I saw. I didn't go like very deep on.
You didn't go into a lot of depth
No,
analyzing the electrical problem?
no, I know that she has problems.
Yeah.
I know that.
Okay. Do you have okay. And how would you go about addressing those problems?
Well, a licensed electrician needs to go over there.
From what I understand, he's general construction. He's not a licensed electrician. He hasn't been produced as an expert in the field of, electricity. I don't think he's qualified to testify to this.
All right, so Mr. Craig, why don't you, if you can lay additional foundation and renew your objection, Mr. Bernie.
Okay. Well, sir, are you an electrician?
No,
So in order to address this, would you bring in a licensed electrician?
yes, always.
Okay. When you inspected the electrical there at the ADU, did it appear to have been done by a licensed electrician?
Objection.
All right, again, let's explain the basis for that opinion.
So is that overruled?
That would be sustained right now,
Okay, all right.
unless you can lay the proper foundation for his knowledge.
Is it typical in a finished residential structure for there to be electrical problems?
If it is brand new, no. I mean,
Okay.
yeah, no.
And if there are electrical problems in that structure, does that indicate that somebody on the job did not exercise reasonable care in doing the work?
Objection. Not a licensed electrician.
But he works with electricians all the time.
All right, I'll overrule. He can state his opinion as to this.
You may answer, sir. Do you need me to repeat the question?
Yes,
So if you find electrical problems in brand new construction, does that indicate that somebody was not doing their job with reasonable care?
it should be covered in your warranty. You need to go and check it out.
Okay, all right. If a customer comes to you complaining about an electrical problem in a structure you have built, how would you respond to that?
Well, electrical can lead to fire, so I would go there. Always. Electrical, yes.
What would you do when you went there?
I would bring an electrician, a licensed electrician to check, just to double check that everything is okay and why they're having that problem.
Okay, thank you very much. And is that what you would expect as being the standard of conduct for residential contractors in the industry?
Objection, Your Honor. He's testifying as to quality of work of an electrician. He's not an electrician or licensed as one.
All right, that's overruled.
Thank you. Have you inspected the roofing?
Did he answer the
Oh,
question? I don't think.
I don't know.
You can answer the question if you remember it.
What did I ask?
Well,
Let's see. Man, I don't even remember what I asked. Mr. Reporter, do you have a record?
what you would expect as being the standard of conduct for residential contractors and cities.
Okay, yes. So we talked about what would happen if there was an electrical problem in one of your buildings. And you said you would go with a licensed electrician and make sure it was fixed, right?
Yes,
And my question was, is that the standard of conduct for a residential contractor?
yes.
Okay. All right. Let's do Exhibit 42. I think that's been admitted, right? Got another document coming up on the screen for you. Do you recognize this one, sir?
I think it's a barn door.
All right. And do you see anything wrong with that door?
Yeah, usually when you supply a barn door, it needs to be 4 inches bigger than the opening. So whenever it's closed, you won't be able to see through it.
All right. And do you see anyone peeking through the crack in that barn door?
Yeah.
Okay, thank you. All right. Now, we've talked about a few of the defects in this property, and I understand you've put together an estimate to repair defects. Is that right?
Yes, long time ago, 2 years ago, I did it.
Okay, all right. Help you find it. Right. Actually, before we get to your estimate, I've got just one more picture to show you. All right. And let's go to Exhibit 65, which I do believe. All right, Mr. Blanco. Do you see the retaining wall behind the ramp there?
Yes,
Okay. And you're familiar with that retaining wall? You've been to that property?
yes,
And you've seen, are you familiar with the topography of the property?
yes.
Okay. Now, how was so is that retaining wall holding back some soil?
Yes,
And so prior to that retaining wall being installed, would there have been an embankment there?
yeah.
Okay.
Yes, could be.
And how could that embankment have been created?
Oh, when you dig in,
Oh, you dig into the ground,
yeah.
you make an embankment. Okay. Now, the plaintiff in this case has testified that that embankment was created by moving the fence back.
Could be.
Could be.
If you had a difference in height from both lots, sometimes happen. It could be, yes.
Okay. All right. So let's look at Exhibit 49. I think that's been admitted, hasn't it? It's 49. All right. Actually, let's do this a different way. Lexi, would you pull up the as-built survey? All right. So, Mr. Blanco, can you identify that retaining wall on this diagram? All right, and does it connect to the corner of the house?
Nearly.
Okay. Oh, okay. Should I mic him? You just put this on your lapel so the court reporter can hear you? All right. So is this the retaining wall?
Yes,
All right. And is this the fence?
that's a property line. Oh, this is the fence, yes.
Okay, all right. So let's look at the site plan. Lexi, can you? All right, so where is the fence on this site plan?
It looked like these are the posts.
Okay. And this is the corner of the ADU?
Yes, this one.
Okay. And so this fence, is it above the corner of the ADU?
Well, you got here this curve that they give you the height. This is 1022, 1020,
Oh, I'm
1018,
sorry, sir.
16.
I misled you. My question is not about elevation. I was just referring to the screen. So is the fence north of the ADU?
Yeah, yes.
Okay, all right. So this fence is north of the ADU, correct? All right, now let's go back to the as-built. And you see here, we have the corner of the ADU, right? And the retaining wall is right at that corner,
Yes.
right? So now going back to the site plan, is it possible that moving this fence back created an embankment here?
No.
Okay. Okay, let's move to your estimate. And fold that up the better way. You're probably gonna use that one down.
I don't know how it is. Fold it a lot.
Thank you, sir. All right, so I've handed you a document marked as Defendant's Exhibit 27. And do you recognize this document?
Yes,
Is this your estimate to repair the defects in the property?
yes.
And, okay, Your Honor, I will move to admit Defendant's 27. Any objection?
No objection, Your Honor.
27 is admitted.
All right, let's just talk about this estimate a little bit. We've got a series of line items and prices next to each one, correct?
Yes.
So let's talk about the third line item down, demolition driveway, retaining wall, gate, fence. Is that to repair the problem with the driveway?
Which one? I'm sorry.
The third item down, it starts with demolition.
Yes.
Okay. And then we've got another entry for driveway, 10 foot by 30 feet, I think. Is that further work on the
Yes,
driveway?
that's a driveway, yes.
Okay, all right. So it looks like you're kind of taking down some of what's there and then you're putting in new material to fix the driveway?
It's the only way
All right,
that I know of.
all right. I see there's a line item for interior demolition. Why would there be interior demolition?
Well, let me refresh my memory. Oh, it's for the flooring.
Okay. So you've got to talk about the relationship between interior demolition and the flooring, if you would.
Well, in order to repair the wavy finish of the slab, the only way that I know of is to remove the flooring, and then I don't know if it is a floating floor or if it is a glue down, but it doesn't matter. After that, you're gonna have to refinish the slab with, like I said, self-leveling compound, which is
Okay.
very liquid, and by gravity, it goes everywhere and leaves it leveled.
All right. I see on here landscaping to remove debris and even yard. Do you remember what that was for? I know this was 2 years ago.
Lands- Landscaping, you sure? Or ramp landing? Which number is it?
Sorry, this is right below fridge. It's kind of in the middle.
Oh, okay. Yeah, yes. This is whenever you finish a job, you gotta clean up all the mess that's over there.
Okay. Now, in the 2 years since you prepared this estimate, have these prices gone up or down?
Up.
Okay. And what accounts for the increase in price?
Inflation?
Inflation? Material costs?
Oh, yes, definitely.
All
Yeah.
right. So the total estimate to repair all of the defects with the property appears to be $93,136. Is that right?
Yeah, that's my number, yes. That's what I
Okay.
came up with, yes.
And is that all of the work that's reasonable and necessary to bring the property into conformity with the standard of care in the residential construction industry?
I would object to that opinion. He hasn't testified as to a number of things that are covered in this and said that they are defects. So he shouldn't be allowed to say that these are all defects that don't comply with the contracted issue in this case.
Your Honor, I thought we weren't doing speaking objections.
I mean, no, I mean, I need to hear some basics of it. So, uh, Mr. Gregg, if there are any specific items he has yet to address, then I'll refer you to those. So,
Okay, all right. So I think we need to walk through all of these, sir.
Okay.
All right. So let's start with mobilization.
Yes, that's prep work, tool rentals, material bought in advance. That's a little bit like a advance payment. It
All
can
right.
be.
Is that necessary to get the job done and repair the defects?
Yes.
All right. We're just going to knock these out one at a time. Dumpsters, do you need those?
Yes.
All right. We talked about demolition of the driveway and the driveway. The handicap ramp, does work need to be done on that?
We need to move it back where it should be. So it needs to be disassembled and assembled again.
Okay. And the breezeway, does that need to be moved over?
Yeah.
Okay. And so you've got a line item for the breezeway.
Yes.
And the ramp landing, what is that?
Where the driveway goes up, goes to the ramp landing.
Okay. So what needs to be done with the ramp landing?
It needs to be demoed
Okay. And why does it need to be demoed?
because whenever we do the driveway, it's not going to match the existing one, and maybe I think we're going to have a grading problem also. So yes, you need. I mean, if I do a job, I give warranty. So I do everything new, so I know how it's being built, and I know I can give you a warranty on my job.
Okay. Um, Interior demolition, we discussed. Repair concrete slab finish.
Yeah, that's for the flooring, needs to be leveled.
Okay. And then, but we also have another line item for flooring. So what's the difference between those two?
Yeah, flooring is a new floor. Whenever you remove the old one, you cannot reinstall it again. You gotta put a new flooring.
Okay, so you take out the old flooring, repair the concrete slab, and then you put in new flooring?
Yes.
All right. Electrical allowance, what is that?
That's a licensed electrician that goes over there and is gonna see what's going on. Like I said, I'm not an electrician, so I need to take somebody that knows.
Closet and bathroom doors. What's that for?
Well, here it says, new doors will be custom made since the opening is 36. We will not find a barn door 40 or bigger in stock. Barn door needs to be at least 4 inches bigger than the opening. Door shall be selected by owner.
Okay. So this is to fix those barn doors?
Yeah,
All right.
yes.
The fridge, what's going on with the fridge?
Well, the fridge, it invades the pathway there in the kitchen. It needs to be, this is a handicap place, so,
Okay.
you know, you need to be careful about all these things. So it's not,
So
not the proper one.
the fridge is recessed back into the wall, but does it stick out from its
Yes,
container? Okay.
yes.
And does it stick out into the pathway into the kitchen?
Yes.
Okay. So you're going to fix that
You need to get
potentially?
yeah, you need to get a new fridge.
Okay. Um, so we talked about landscaping. Replace water heater. Okay, did you observe a problem with the water heater when you were there?
I think there's no problem. The only problem is not the one specified by the contract.
Okay, so this would be to bring the ADU into conformity with the contract.
Yeah.
Okay.
Yes.
Same thing with the HVAC?
Yes.
Okay. Pressure balanced thermostat, bathroom sink faucet. What is that?
I think it is the thermo is when it gets too hot, it's shut off, so you don't get burned.
Okay. And did you observe a leaking water spigot when you visited
I don't remember that. Maybe, yeah.
2 years ago? But you noted here on your estimate that.
Oh, it's there?
Yeah, you
Yeah,
need to repair
okay,
one.
yes, yes.
Okay. We've got install handicap shower seat per building plans. So did you observe that the handicap shower seat was not installed per the original plans?
Yes,
And this would be for fixing that.
yes.
Okay. Fix exterior deck to regain access to walk-through gate. Let's see. Okay, let's talk about that real quick. So let's get the as-built pulled back up. So with this ramp being positioned up here, does that affect foot traffic along there?
You have a gate here and a walkway, but now the breezeway is over there, so it's kind of obstructing.
Okay.
You are supposed to be here. But the
Okay.
deck, so connecting with the deck.
All right, so this line item on your estimate, fix exterior deck, et cetera, is to address that problem?
Yes.
Okay.
Yes.
Waterproof foundation, what is that?
You can see the foundation on the building.
Okay.
On the house, and you don't see the waterproofing. They just left the concrete with no treatment.
Oh, they didn't waterproof the foundation?
It didn't look like that.
Okay. So is that important to do?
Yeah, yes.
And we've got fix exposed fasteners in roof ridge cap. Do you remember what that was for?
Well, it says there are several roofing nails that need to be removed and installed correctly.
Okay. And then fix improper flashing underneath metal roof at right side.
I think that the connection of the breezeway with the roofing, they didn't put a flashing over there.
Okay. And reinstall bathroom grab bars due to missing mount covers.
Yes.
That's a necessary fix for the ADU.
Well, to tell you the truth, right now, there are new products that maybe you can avoid that. You buy ones that they split in the middle and you can put it without removing them. I'm not sure, but maybe
Okay.
you can find a way out without removing them.
But would this be a reasonable thing to do to get the ADU in conformity with the plans?
Well, the grab bar is installed. It's not politely or neatly finished because they don't have the covers. That's it. I mean,
Okay.
they seem to be okay. They don't have that cover. That's it.
Okay. And you have here install clothes washer and dryer?
Yeah, I don't remember what is this about, to tell you the truth.
Okay. So is there a defect with the washer and dryer? It doesn't sound like you remember. Okay.
I don't.
And how much is that? That's what's the line item amount there?
Couldn't be much. 520.
Okay. So less than 1% of the total estimate, right?
Yes.
All right. And then we have move property fence. What's that for?
It seems like the property fence is not where it should be.
Okay. Can you show us that on the as-built survey?
Yeah, it's here. That's the fence.
Is it still too far south or what's wrong with it?
Well, it's not on the property line, but I mean, sometimes people, they don't want to go to the property line. They just want to play it safe and they put it 1 feet on their property so they know it's their property.
So is that necessary to bring this house into conformity with the plans?
Yes.
Okay, all right. So your total estimate is $93,136. Is that correct?
Yes.
And is all of this work reasonable and necessary in order to bring the ADU into conformity with the plans?
To my knowledge, yes.
Okay. And will this estimate remedy all of the defects that are currently in the ADU?
Yes.
Okay. And does this contain any work that is not necessary to remedy those defects?
I don't think so, no.
So is it common in the construction industry for a contractor to underbid a project?
Happens.
And why would a contractor do that?
to get the job.
Okay.
And then they see how they're gonna make it up,
How do they make it up?
change orders.
I see. So after they start work, how do they get change orders done?
Oh, people can be very creative.
I see.
I mean, there's mainly the drawing doesn't give you all the information that you need, and it gives you room. If you are like focused on getting it, if you're good, you can get it. It all depends. It all depends with the owner, you know,
Yeah.
how you interact with the owner.
I see. So uh, is this an accepted practice?
No,
Okay. So bidding a job and then strategically using change orders to try and get the price up is not an acceptable practice in the industry.
no, but it happens.
Okay. How does the licensing board view that sort of practice?
I guess they're not gonna like it, but it's so difficult.
Why don't you, yeah, if you want to maybe rephrase or establish a basis for that.
Is that considered an unethical practice?
Yes.
Did I tender 27? Yes. Okay. It's been admitted. All right. Give me just a second, Your Honor.
Can I get my phone?
Just wait 1 second.
Thank you, Mr. Blanco. I have no further questions for you. Mr. Burney will have some questions in a moment.
Okay.
Mr. Burney, any rough ballpark of how much time you think you need for cross?
Perhaps 30 minutes, Your Honor?
Okay. Members of the jury. So let me just first map out the road ahead. So after this witness is done, I anticipate both sides will be resting their evidence, and then we need to have a conference that usually lasts about 30 to 45 minutes before we can begin closings. The parties have agreed that the closing arguments would be about 2 hours in total. And so if we break now, we'll come back and then have to have another break. Or we can try to push on till 1 and have the break all at once. All right, there appears to be our first sign of unanimity. So, Mr. Burney, if you can proceed. And while you're making your way up, if I can get Detective Berhalter, we'll go
Sure.
off the record for a moment. You can go get your phone if you need something.
Yeah, this street parking, I want to extend it.
Okay, all right. While he's doing that,
We run to the room, I got.
Yeah.
yeah, we're off the record for a moment. Thank you for your patience, sir. Raise your hand, so this way. Yes, sir.
That's crazy.
I was like, who's Bob? They're Pablo Shea. That's all technical on that, so we got 30 minutes.
You just have to. All right. Hang out. I gotta scan that. Mr. Derberry, we've got some warrants to sign, or excuse me, scan. And is it Officer Lakewood? Yeah. All right, Lieutenant Norwood, you can raise your right hand. You solemnly swear to serve. And then Mr. Derberry, that's not what we can do.
Yes.
Sign this one. Then we're gonna get a copy. Where'd they go? You just wanna. All right, Deputy Scott, if you could check in the hallway for counsel and our witness, maybe they're coming back. All right. We are back on the record. Mr. Bernie, floor is yours.
Thank you, Your Honor. Mr. Blanco, you mentioned that you provide a warranty when you do work.
Yes, I mean, everybody does. Is by the state licensing board. You got workmanship for 1 year.
Right. And so in order to do warranty work, you have to be let onto the property to come back and repair things, correct?
Yes,
Okay. And if the homeowner will not let you onto the property to the work, you're unable to do the warranty work.
correct.
Is that the homeowner's responsibility or yours?
If they don't let you in, no, it's not yours. If you go up to the place to do your warranty work, they don't let you in, it's not your fault.
And even before you get to warranty work, is it not uncommon that when you finish a project, there are things that aren't perfect that have to be looked at and have to be repaired?
100%, yes.
Does it happen in almost every job?
It's very normal and common, yes, but you got a punch list and then you go back and you do, but they're not major things, they're small things, but happens, yes.
Right. So if you know about the things and they're small things, then you could be given an opportunity to come back and you complete the punch list.
Yes,
And then once that's done, the warranty period would be in effect after that. Is that, to your knowledge, if that's how you think it goes?
to tell you the truth, I think it's 1 year after you finish the job.
And how do you know if you finished the job?
Well, you got your CO.
Okay, so the CO would be the starting point to say this is when the warranty starts.
I would say so, yes, sir.
And you're familiar with the city of Atlanta and the CO process?
Yes.
And do you get a CO if there's issues with the job?
Well, the CO, you get the CO after you get the final for HVAC, plumbing, electrical, and the final inspection by the city.
Okay, thank you. So as far as the electrical issues that you've talked about, you don't know what the problem is with the electrical.
No, I don't.
You said it seemed like it could be a small problem.
Yes.
Okay. Let's talk about the door, the barn door with the comical picture of Francisco sitting in between it. If, what other things could you do to remedy that besides replacing the door? Could you improve the jams, put more?
Well, you
jams
can
in?
make it, yeah, sure. You can make it smaller, the opening. And yes,
Okay, and or could you put any kind of rubber on the door to block the sight, to block the vision?
I wouldn't do, you can, but I wouldn't do it.
But you might try that to see if that worked.
Yes, you can try. Yeah, I mean, usually you need to get the acceptance, or the owner needs to be okay with it.
Right, but is there ever a time when you're coming back in to make a repair, remedy to an issue, that the first remedy you offer isn't the right one and you have to go back and do something else?
It could happen, yes.
Right, and that would be a reasonable interaction between a homeowner and a builder, correct?
Yes, I would say, but you need to understand that sometimes the relationship between the owner and the builder, it wears out. So at the end, it can be a little bit uncomfortable.
Sure, but that doesn't negate the opportunity and the obligation to get the
100%.
person.
Yes, you're right. Yes, yes.
I mean, if you have a contract and there's a breach, you want to be given an opportunity to cure the breach, correct?
Yes,
Even though if there's a breach, that's generally when things become uncomfortable, correct?
yes.
And if that breach is in place, you should be given an opportunity to come and correct the breach.
Yeah, I mean,
Thank you.
yes,
So referring to your estimate, you say this was produced 2 years ago?
yes, sir.
I think the date on it is December 7th, 2023. Does that sound familiar?
Yes,
Okay, and you haven't updated this estimate at all? since
No.
that date? When you went to the property, did you do any kind of invasive work to look at anything?
no,
Did you basically just walk around the property?
yes.
And what, were you given any instructions as to what to do? I mean,
No. They explained to me what were their concerns and how we could remedy them.
okay. And so you looked at what they told you to look at.
Well, yeah, they stand out, some of them.
Okay. And did they, do you recommend tearing this building down and starting over?
No, I don't. But I mean, that's option B, I
Right.
think. That is the owner. She need to decide what she wants to do.
Right. If you could look at the as-built survey, could you possibly pull that one up? Actually, we can start with the pre one. I think it's exhibit 6 of yours. And then exhibit 100, I think.
That's right.
Mr. Blanco, if you look at this document here, does this document tell you what the elevation is of the ADU?
$10.22.
What's that mean? 1,022 feet above sea level?
Yeah,
Okay, can you go to the next one? And what's the elevation there?
1021.60.
So is it it's a change of about 0.4 of a foot.
Yes.
Was this property lowered by 3 feet?
No, no.
Your estimates calls for, first of all, let me ask you this. You've been paid to be here today,
Yes.
and have you been paid all the money that you're owed?
No.
Okay. And so you were talking about the issue with the deck. If you could pull up 55, please. I think it's 55. I think it's theirs. Did you?
Oh, sorry. We got.
I got it if,
You know what I'm talking, the corner of the deck. It may be ours. Okay. Does this look like the way the ADU looked when you went to visit it?
Yes.
And you stated that it was difficult for a car to pull up into the driveway.
Not a car. I mean, a truck or a van that the maneuvering is so different than a car.
Is it impossible?
No, I mean, if you try it many times, yes, I think you can succeed.
Did you drive a truck or a van up there?
No, I did not.
Okay. So you don't know for sure if it is.
Oh, yes, I know. I drive my truck every day.
Okay. So you'd say it looks like it might be tight.
Yes.
Okay. And if you look at that, if you look at that building, the deck that is built there, does that look like some sort of optical illusion to you about whether the deck hangs out over the driveway?
I mean, no, but since you moved the driveway, that's why it's not.
Right, but the deck doesn't hang out over the driveway in that picture, does it?
If you, to the as-built driveway, to the driveway that they did it, no, of course not. I agree with you, no, but to the one supposed to be built, yes.
Okay. And so your recommendation to fix this is to remove the whole driveway and to move the fence. If we could go back to the as-built survey, please, 100.
Yeah, that could be one. Maybe you have another one.
Well, let's talk about that.
Okay.
100, please. 100 up. So I think what you testified to was that what you should do is you should make the driveway basically go straight to the street. Is that correct?
That would be awesome, but I don't know, maybe you can soften up the curve over there so you don't have to move that much. If not, you're gonna have to remove a lot of grading over there.
Right. You could also, would another remedy be to remove? Wouldn't another remedy be to remove this section of the deck?
You mean like this?
Yeah, so remove
It
this
could be,
section
yes,
of the
yes.
deck and then add concrete here to make the driveway wider?
You could, yes.
Right.
Yes, you could.
But you weren't asked to evaluate that solution, were you?
Because I didn't know I could remove the porch.
So okay, but if you could remove the porch, you could solve the problem by removal of that portion of the deck
Yes,
and adding some additional driveway material there.
yes, you can do that.
So there's some testimony also that the breezeway, the covered ramp, was moved to the north.
Yes.
And doesn't that increase the usable area of the yard?
Say
In other
that
words-
again?
In other words, doesn't the yard get a little bit bigger if the breezeways or if the ramp is moved a little bit north? Okay, and so you're able to go through the fence, are you not? I mean, you could walk through the fence, it's just a little tight.
Well, you gotta modify the deck over here. And the main thing is you're blocking here and this pathway is used. So
Okay.
it brings a problem, yes.
All right,
Sir, construction is not an exact science. You may have different solutions that I do have.
correct. And so if you can go back, if we're looking at this, I want to look at 100 with you again. If you could look at the survey, you testified that the building was a little bit to the east as opposed to where it was designed to be.
Yes,
And if you look at that survey, there's on the lower left corner of the ADU, there's a little box that has an E in it. What is that? You not see it? Let me show you.
no, I see it, yes, but I have no idea. Electricity, I don't know. What is that? I have no idea.
Oh, you're the construction expert.
Yeah, I don't know. What is it? Usually when they give you this drawing, they give you a table and it refers to their graphic, what it means.
It doesn't look like any kind of electrical service to the property?
I have no idea. You got the full survey, you should say what E is.
Well, this is your.
It's not guessing.
this
I
is-
mean, this
this-
is not about guessing, you know?
Understood. This is Miss Maia's survey. so it's not mine.
Okay.
Okay, I just
Now
asked
you tell me, what is it?
I'm just asking you if you know what it is.
No, I don't. I
Okay,
don't.
thank you. Go to the left here. Go down to the legend. Go.
Oh, there you go.
Oh, they're doing it. Okay, what is that now? Does that refresh your recollection?
Power meter
Okay, and so where can you put a power meter on a property?
on the side.
Okay,
But I mean, if you're building something new, you're gonna have a new power meter to the house. You
Okay.
put it, you call Georgia Power, and Georgia Power is gonna give you some options where to put it.
okay,
It's not something, you're not gonna design a house because the power meter is there. You can move it.
okay, but Georgia Power put the power meter. That's who
Yes.
puts it, okay. You said you weren't sure whether the foundation had been waterproofed.
Well, usually when you have a concrete foundation, you purge it or then you waterproof it and you protect the waterproofing with a membrane. And then after the membrane, you put like another cover to protect the membrane. That's not there. That's not in place
Okay. And how do you know that that's not in place?
because you can see it.
Okay. And in terms of the flooring that you talked about, do you know, what's the average cost of flooring?
Well, it depends what type of flooring you're talking about. I think over there is LVP, luxury vinyl plank, and that's go from $3 to $5 per square feet.
Okay, and what's the square footage of the ADU?
I don't remember that.
Is it 705 feet?
I don't remember that by heart. No, I'm sorry.
Okay, so I guess what I'm asking you is how did you come to a figure of $15,015 for the flooring on this estimate?
Because that's how much it costs to buy it and install it.
Okay. So you're saying that it would cost that much for 705 feet to replace the flooring?
Yeah.
That's not including, is that including the leveling of the floor?
No.
Okay. In terms of replacing the water heater, do you have the make and model of the water heater?
No, I don't.
Do you know what it is? Did you ever know what it is?
When I quote it, I did, not now.
Okay. Is that the same for the HVAC?
Yes.
Are those units working?
I think they are working, yes.
And do you know the difference in value between those two units? Between the value, the unit that's there and the unit that was installed? Do you know what the difference in price is?
No. Oh, you're asking me if he put like a cheaper one? No, I don't know that.
I'm just asking you if, you're saying that what you've said that what's there is not what was on the plans,
Yes.
and that you said you knew what was in the plans. And I'm asking if you know the price difference between what was in the plans to what was recommended in the plans to what is actually installed.
No, no. Why would I know how much it is what the other person installed it?
Well, I mean, it's got a make and model.
But yeah, but why would I search for the cost of that unit?
That's fine. Thank you. I'm very almost done, Your Honor. If I could just have one moment. See the one that's the picture of the before construction.
Yeah.
Okay. Yeah, you can put it up. Mr. Blanco, I'm going to show you a picture that's been submitted by the defendant in this case that shows pre-construction condition of the property. And on the right side of where the fence is, does that property look level when you're up against the fence at the west side of the property, at the back of the property?
No,
No, it's not level. And so if you were to dig out there in order to build a building, wouldn't it be natural that that would have to be retained?
I don't know what type of soil you got over there, but usually with a 45%, you're good. It's not gonna fall down.
Okay, and if you could bring up, but when you build and you dig out to build a foundation, doesn't that create a little berm that you said would have to be retained?
I mean, when you do a foundation, I mean, yeah, you excavate and then you pour the concrete and then you put it back.
Okay.
So, I
Okay,
mean,
so have you reviewed the plans to see whether a retaining wall was included in the original contract?
it should say if
Say retaining walls.
it should say yes.
And does it show a retaining wall?
No, I don't
You
think.
reviewed the contract before you came here today, the
No,
plans.
I didn't review the contract until today. No, I did not.
Reviewed the plans and specifications before you came today?
No, I remember I'm busy.
I know you're busy.
I just came here, I left my job and came here. I didn't have time to review everything, but I think there was no, well, you can see it in the picture. There's no retaining wall.
Okay, so you're saying that in that picture, there's no retaining wall.
Yeah, in that picture, yes.
But you're saying that what you're saying is that if there's going to be a retaining wall, it should be specifically set forth in the contract, correct?
Yes.
Okay. So as you went through and developed your estimate, Mr. Blanco, did you look at lesser alternatives as options to make the remedies?
Maybe you're creative.
No, I'm just asking you. I'm just asking.
No,
you.
I don't think so. But, like I said, this is not exact science. Sometimes people do stuff that I have no idea and they fix it. But I mean, I just try to be as honest and use my knowledge to the best. That's it. But, sometimes people do things that they get away with it because they don't get inspected. If you get inspected, you got to do it correctly.
Okay, so in terms of inspections, there's a whole slew of inspections that happen before you get a certificate of occupancy, right?
Yes.
And you have to pass those inspections to get the certificate of occupancy.
Yes.
No further questions.
Any redirect?
Your Honor, I'll just take a minute to prepare and then I will redirect. And the as-built. Thank you. Let's look at sheet order number 2, the drawing. Yep. Okay, let's put that on the screen. All right, Mr. Blanco, thank you very much for your testimony here today. I just have a couple more questions for you. So would you please look at the diagram on your screen? Sure, right there. So there's been some talk today about whether the porch overhangs the driveway. And on this diagram, show me where the driveway was originally intended to run. Okay. And does this deck overhang the original route of the driveway?
Say that again?
Does the deck stick out over the
You mean
original
all this?
route? Yes.
Yeah, it does.
Okay. Now, I want to ask you a couple questions about elevation. So, Lexi, can you get the site plan pulled up? All right, so we're looking here at the original site plan. And let's take a look at the notations on this site plan concerning elevation. Is this a notation concerning
Yes.
elevation? So what is that?
That's the height of this line, 1022. This is supposed to be all in the same elevation.
Okay. And is there another elevation line up here?
It's not very clear, but here you have one.
And can you make out this number even though it's partially concealed?
I would say it's 24 because it goes
1024?
from 2 and 2. Yes.
Okay. So right here, the elevation is 1024.
Yes.
Okay. And the walkway runs right along here, correct?
Yes.
Okay. And then there's the retaining wall behind the walkway, right?
Yes.
And so right where that retaining wall now runs, the elevation used to be 1024, correct?
Yes.
Okay. Let's get the outlook. All right, here we have the as-built survey. And what is this right here, this line?
Which line?
This dotted line. I guess I don't know what that represents. Oh, is this the covered ramp right here?
Yeah, it looks like it.
Okay. And is this the retaining wall here?
Yes.
And is this an elevation marker?
Yes.
And what does that read?
1021.
So right there by the ramp, the elevation went from 1024 to 1021.
Yes.
And is that a difference of about 3 feet?
2.5 feet.
Okay. All right. 2.5 feet. So based on that, was there an elevation change?
Yes.
Okay. Now there was a proposal that you solve the driveway problem by cutting off this corner of the deck, right? Mr. Burney suggested that?
Yes.
Okay. Now this is supposed to be a handicap accessible building, correct?
Yes.
And there is an entrance here, right?
Yes.
So
I think it's the main entrance. That one is for the kitchen, but
okay.
I don't know.
All right. But there is one here. And a person in a wheelchair is supposed to be able to come out here and exit the building. Is that right?
Yes.
Now, this deck, does it have a railing all the way around?
In the picture, I think it does.
And is it elevated off the ground?
Yeah, it's a railing. Yes.
So if you
Yes.
cut off that corner, can you get a wheelchair around that corner?
I don't know if you you gotta put it this way, going up to see if you can use it. You're gonna have to modify the deck for sure and this for sure, and then you don't know, because if this is used as an ADA ramp, you need to have the pitch and everything. I don't know.
Okay, not sure. All right. So let's do exhibit 28. I think that's been a bit. All right, now earlier you mentioned that the retaining walls were not in the plans, correct?
Yes.
So given the 2.5 foot change in elevation, and the proximity of the house to this embankment, do you need a retaining wall here?
No. I mean, You don't need it uh, because you're gonna have a problem, like a constructive problem. You don't.
So would it be okay to leave a 2-foot unsupported embankment that close to the house?
Well, if you treat it correctly, so the water doesn't go in below the house, yes, you could.
Okay, so you could potentially solve that problem by another method, right?
Yes.
Okay,
But in order to do that, you need to remove the fencing and see how you can do it, you know.
so a retaining wall, was that one reasonable solution to the problem of the embankment?
It could be, yes.
Okay, all right. So let's, all right, I'm going to confer with my client. I might just have a question or two further for you. All right, Your Honor, I'm done. Mr. Blanco, no
Well-
further questions. Thank you very much.
Let me double check if there's any recross, Mr. Bernie.
No, no recross, Your Honor.
Okay, thank you, sir. You can step down. Take care.
Thank you, sir.
All right, Mr. Craig, any further evidence on behalf of the defense?
No, Your Honor, defense rests.
All right, Mr. Bernie, anything further on behalf of the plaintiff?
I would like to have a moment. I need a couple minutes to talk to Mr. Reynolds, but I do have a motion, Your Honor.
I understood
Feel free to
that.
go. Thank you, sir.
Preserving the right to present all possible motions that you have, do you anticipate any further evidence?
No, well, that's what I want to confirm. If I do, it'd be very briefly with Mr. Reynolds, but I just want to confirm.
Okay,
And I need to have an opportunity to talk to him.
understood. All right, so members of the jury, at this point, we're going to let you break for lunch. So I'll ask if you can come back. I believe this is, like I said, would be an extended break, so we can work on some things. If you could be back here at 2:30. All right, thank you. All right, Mr. Bernie, why don't we have you make that motion, I suppose, so we can at least plot out where we're headed?
Actually, Your Honor, is there any possible way we could go to lunch and just give me a moment to finalize that, my argument on the motion?
That's fine. Okay. So we still have to work through that, the charge conference, and everyone has received an email copy of the consolidated charges of our kind of our rough draft. Okay, you're about to. And so that's something to review while we're on break. And then you've got the verdict form already. So we'll take that up. And I don't know, I'd propose we come back at 1:45 thereabouts. All right, not hearing any strenuous objections then, we'll be back then. We're off the record in recess.
Yeah.
I think I need to go buy a snack.
So I think
1:45. 1:45.
should chat for a few minutes and then I should dine alone to work on.
What time we have to be back?
1:45, so it's hour at 41 minutes.
All right, so grab my lunch box.
Do you want these with you?
I think we can leave this.
Seriously.
I have a high degree of confidence in this judge's work.
I'm right behind you.
No, we used to, I think the
I come back in and out that way or?
Yeah. I'm hoping that go back up at 2 o'clock.
Okay.
So I didn't matter, I want to start to come in here. 2 o'clock.
Yeah, absolutely. I guess we're done with evidence, right? So I can just email them to you? Awesome. I'll get those ready. What's been admitted? Yeah. Is it Google Drive link?
Yes.
Okay.
Left you guys my exhibit sleepers yesterday and they could wrap them. I'm not sure if you're allowed to bench.
Should be able to.
Let's get them later.
Right there, or there's a plug right here. Yeah.
Stop.
Okay.
Yeah. I said that.
Oh.
As soon as we got council back.
Okay. See, if you might want to grab this credit.
Okay, thanks.
Something.
Yeah, did you get something to eat? We
Yeah.
got snacks.
I didn't know, I was saying for you, because.
Oh, yeah. Well, I just sit here. I don't have to, doesn't take that much.
Check. They'll jump all sit.
All right, then let's go back on the record. All parties and counsel are present, and Mr. Bernie, I believe, has a directed verdict. Motion.
Thank you, Your Honor. Your Honor, my directed verdict is based on two things. One, I don't believe there's been any evidence of damages on any conversion claim. I don't think there's any evidence as to the value of any lumber or to any sink that was submitted in the case.
Did someone at some point say it was $500 or something as it relates to the sink or the countertop?
Um,
Lumber, I didn't hear anything, but the sink, I think there might have been something about that.
I don't
That's my
recall. It's
recollection.
possible. Sorry?
That's my recollection was
I think
500
that
on
came
the
through
sink.
Mr. Maia. Just there was an offhand reference that the sink was $500.
Okay. As to the negligence, I don't think there's any evidence that Mr. Reynolds was, or wasn't specifically broken down as to what he would have supervised or participated in as to the negligence actions. And so I think that that's not sufficient to bring against him personally. I think the fraud claim is a question for the jury. I think that the slander claim has been dismissed. As for the attorney's fees, I think I have to state that I don't remember there being any evidence of an attorney fee agreement or retainer agreement between the defendant and the counsel being entered into evidence.
No, I think this is just as it relates to a bad faith claim, 13611.
There should still have to be evidence of a attorney's fee of a contract or retainer.
I thought, well, we can reopen the evidence if you want, but I thought that was what the purpose of the stipulation was, is
Okay,
that,
well, I'm just raising it up to be complete.
yeah.
So yeah, we would move for directed verdict. I think there's obviously, I think an arguable issue about the breach contract. That's clearly, I think, on the company alone. I think the other claims are as per the instructions. I just don't think that there's evidence of personal acts on the part of Mr. Reynolds in terms of supervising or participating in the individual acts that can give rise to those claims.
Okay, well, let me clean up that one thing about the attorney's fees, though. So with the stipulation, you said we were going to lay out what your attorney's fees are.
I thought it was only to the amount.
Right. And so let me start with yours. Do you have your amount figured out?
I think it's 65,000, Your Honor.
I'm saying, like, go ahead and if you've got it handy, let's just
Okay.
put the dollar amount so it's part of the record and we don't have to have any questions after we've gotten the verdict.
Pull it up.
2 seconds, Your Honor.
Okay,
More than 2 seconds.
that's fine.
2.5 seconds.
And then, I guess as if the stipulation is to the amount, I suppose I could have been more clear on this, but I think it was presumed that amount is coming as a result of the other side being retained on this matter.
Okay, well, I guess that needs to, I mean, if that's the stipulation, then, and there's no question that he's her attorney, I think it's just a question of proof. I felt obligated to raise it for the record to the extent that there's no evidence of a fee agreement that's been placed in. I thought the stipulation was only to the amount of the fees if they were proven that there was a fee agreement, but I mean, it wasn't completely specified, and so we would raise that objection and want that included in our motion.
Okay, so is it your position a fee agreement is, I mean, I understand someone has to be hired to be the attorney, but there doesn't have to be any specific form of agreement? I'm just trying to understand exactly what you're
I
saying.
don't think there was any testimony whatsoever that she hired Mr. Craig and had an obligation to pay his fees.
Okay. And that's not something you're willing to stipulate to, that she hired him and he's
Well,
charged her money?
I mean, I felt obligated to raise it up. It's a question that's come up. It's also in the complaint is 13611 fees have to be pled and prayed for. It wasn't prayed for. It was only pled. It's in the main part of the complaint, but it's not in the prayer section.
I can double check that.
Okay, haven't heard that before, but maybe that's a thing. You have a site for me?
Will, Your Honor.
Thank you.
I was hoping to get back in here a little bit earlier to, and I apologize.
I would beg to differ with Mr. Bernie on that technical point about the pleading. Opening, I'm getting the wrong file here. 1 second.
And wasn't, I believe Miss Maia was asked
In the
at some
record.
point that she had incurred costs as attorney's costs because of that. I think she was asked that direct question.
I think she said that this has been expensive. Or words
She
to that effect.
said it's been financially ruinous for her.
Well, but specifically that she'd had to pay an attorney. Is that
No.
perhaps not? I don't have that off at my fingertips.
Let's just go to prayer for relief. Attorney fees is in the prayer for relief, just as a,
Okay.
And in the third amended,
yes, sir.
Second.
Second amended. Oh, is there a third amended? Oh, yeah,
third amended answer and counterclaim.
let's get the third amended.
What's the date?
That is, yeah. I'm big on amendments.
This. Yeah, the fridge. Got adding up all of
Okay, yeah, it's there.
but that's
All right. So just to drill this home, what I was trying to convey the several times I brought it up is that the line on the verdict sheet would simply be the jury making a finding whether there's been liability for 13611 claims, meaning they find bad faith, stubborn licentiousness, etc. And then if that box is checked, those fees are automatically then awarded in the final judgment, assuming everything else flows. And so that's why I've just been asking you the amount. So if now, Mr. Bernie, you're telling me that you think it also needs to be established that she's the one who incurred those fees and that your stipulation didn't cover that, then I would
just feel obligated to raise it up, Your Honor, and I didn't hear the evidence of it. That's why I'm saying.
I think that's because we all assumed that was stipulated. If you're now saying that's not stipulated, we'll reopen the evidence.
But then that's fine, Your Honor. I understand you can easily do that. I'm not going to be that. I just felt, I wanted to see how you wanted to look at that, and that's fine.
Okay. All right. So with that, what is the, maybe we're still pulling that amount?
Yeah, is it possible that we could, because I have to update it for this week?
And that's fine. I just want to make sure everyone's clear. I don't want anyone after the fact raising, crying foul because we didn't establish that amount before the verdict came back. So if you both agree, we'll supplement that amount later. We can do that. That's perfectly fine.
I'm prepared to state an amount.
Okay. Well, we've got yours then. We can at least start there.
Okay, $107,000.
I'm just going to say even.
Yes, Your Honor,
All
round
right.
down.
Okay.
All right, so stipulated. And if you could just give me,
It's fine.
after the jury comes back.
We'll have time to wait then. That's fine. And so from there, I kind of interrupted were there more aspects of the directed verdict that you wanted to raise and preserve?
As to the tort claims, I don't think that there's sufficient evidence to show that Mr. Reynolds was involved in all the elements of the negligence. He had people working for him. He didn't perform any of the work himself. As to the fraud claim, I think that goes to the jury. And I think that obviously, I think he signed the document, so I understand that. Conversion claim, I don't think that there's been sufficient evidence to support any of the conversion claims. I don't believe that there was evidence of a demand of the return of the lumber or the sink. It's been in this case in terms of evidence, and I think that would be it, Your Honor.
All right. Well, as it relates to the issue of Mr. Reynolds' personal liability versus the corporation, I do plan to cover that aspect in a non-pattern charge and have that distinction there, which we can get into here shortly in the charge conference. But for now, on all these issues, I will defer ruling on these. On certain aspects of these, I very may revisit them after the verdict if I feel so compelled by the result and after reviewing the evidence. But for now, all these motions are deferred.
Okay, thank you, Your Honor.
So maybe it would help to work our way backwards, and we can start with the verdict form. And so what I tried to do here was just to divide it out and make it very specific of kind of guiding the jury where they need to make findings and how those flow from each other, since they don't need to answer all these questions if they don't find for certain claims, and the punitives would only follow intentional torts. So I had the punitives only flowing if they find fraud or conversion, not negligence. Just trying to make that distinction. So, and then I divided it out so they'd have to be actually making individual findings of whether it's the corporate defendant or Mr. Reynolds individually throughout. So any thoughts on phrasing, organization, anything at all about the verdict form?
Can we revisit the relationship of punitives with negligence?
So my understanding and looking at the punitive statute was that just even an allegation of gross negligence isn't going to allow punitives to flow from that, that you can't get punitive damages just from negligence because it has to be an intentional act. Now, double check that, but that was just my understanding of it. And that's why I confined it to the intentional torts, which I saw as fraud and conversion.
I'll need to get you some authority on that. I know. But just for the sake of discussion, I thought that you could get punitives on negligence if you can show malice, which would be willfulness or a conscious disregard for the consequences. Which, we plead that as a separate count, of course, in our counterclaim. And I do think there's evidence to support a finding of malice in the legal sense here.
Your Honor, I think it may be helpful to understand what is the exact allegation of fraud. If the fraud is in the inducement of the contract, that's one thing. If fraud is some other thing, I don't think there's been any evidence of malice in any of the fraud evidence or the negligence evidence. I don't think it can be inferred. Trouble getting connected here.
So on fraud, we are arguing that Mr. Reynolds was not honest about his intentions at the time of entering into the contract, which is a misrepresentation of fact that is actionable fraud.
And let me go back on that. I think I just overread the jury charge there. They will get charged that mere negligence, although amounting to gross negligence, is not enough for punitives. But punitives can flow from a negligence claim if, as you point out, it's shown to be malice fraud. And so that reminded me of there's a 2023 case that came out of the Supreme Court, the Devereaux Foundation, that talked about the caps and exactly what the finding is that was a negligence case and involved 50 million in punitives. So I'll revise that, the language in right
Thank you
before
very much,
10,
Your Honor.
it'd be questions 5 through 7. Could award punitives. It wouldn't be unjust enrichment, but it could be 5 through 7 because those are all torts.
Yes, thank you, Your Honor.
But I mean, to the extent you're saying that the evidence here doesn't rise to the level to support punitives, I'll take that as incorporated into your directed verdict motion.
Okay.
Okay.
Yeah, again, Your Honor, also, I mean, their negligence claims arise out of not abiding by a contract.
Right.
And so, the point is that it's a breach of contract claim and not a negligence claim.
I think as the jury instructions kind of point out, it has to be something outside of the contract that we're talking about with negligence. So if there's something outside of the contract that you can point to, conduct that's been done that was outside of the contract, I think the testimony of Ms. Maia was that the $16,000 charge was outside of the contract and didn't have anything to do with the contract. And that right there could be a aspect of the tortious conduct here. Is that fair to say, Mr. Craig, as a one example?
Yes, Your Honor. Now, we're specifically talking about negligence here. I may have lost. Okay.
That's right. Is how is the negligence distinguished from your breach of contract claim here?
Your Honor, on that front, I think the proper cause of action for the 16,000 would be money hadn't received, not negligence. If it's negligence because what's negligent about the 16,000? It's a breach of the agreement between the parties. And if it's not negligence, it's money hadn't received that he should have returned. And that's not pled. They're going to claim in this case.
That's our fraud claim.
Well, and I think I shouldn't be just kind of speculating here. Let me go back to the pretrial order. And as described in count 2, it's the negligence claim is based on unreasonably shoddy and unworkmanlike compliance with the, I suppose, that didn't comply with the standard of care. So in essence, they may be more viewed as alternative claims than anything.
I think if I may just speak somewhat hypothetically here, if a contractor does something that builds something in compliance with the contract but does shoddy work, that can be negligence that needs to be remedied without actually being a violation of the contract. But if that shoddy work is especially bad or is done in such a way that it actually deviates from the terms of the contract, it could be an act of negligence that is also a breach. And so that's essentially what we're contending here, is that we have numerous acts of negligence, many of which also rise to the level of a breach of the contract.
The contract has a term in it that the work will be done in a workmanlike manner.
I mean, this is what I'm saying is I've seen these brought in several cases as they're right beside each other. And when I've dealt with them at the MSJ or motion for summary judgment stage, it's applying a very similar standard. And so whether if the jury were to find on both of them, again, would you have to elect a remedy between one and the other?
You have to elect now, I think.
Well, that hasn't been my experience so far. Is you can, just like you're not electing between your remedies between breach of contract and quantum arrow, you can put it to the jury as to here's hypo 1 if you want to go this route, and here's hypo 2 if you find that way. And then at the end, once we know where they are, if there's anything left to elect, I think that's when you can make that determination. So unless y'all show me some case law of how this has been applied or distinguishing between them, I think the question is submitted to them on its face, and you can argue these distinctions to them during your closing.
Okay, Your Honor. As to are we talking about the jury instructions now? Or?
I was still we hadn't moved on from the verdict form. I'd corrected that part about the punitives. Was there anything else that you saw there that you think needs some work or have suggestions?
Number 5, I'm not sure I see a legal defect, but I feel like this could be pretty confusing to the jury. We find in favor of the defendant as to plaintiff RR Inc. As to counter defendant Simon Reynolds, or, okay, sorry, it's just getting late in the week and my brain is not functioning quite as well. Um, I hate to ask for such a trivial change, but would it be possible to spell out counter defendant? C-def, I don't know if the jury would necessarily pick up on what that is.
We'll see. Yeah, we'll see if we
Okay,
can
sorry.
format that in. All right. Anyone else or anything else? If not, we can move on to the charges. So
Fine, Your Honor.
I will first I'll note the copy that I've handed to you and what we'll be referring to during these discussions. I'll mark and tender as Court's Exhibit 1. And instead of going kind of line by line, page by page, I'll just start summarizing and y'all just jump in whenever you have a suggestion or concern about it. So I start with that I think some folks had asked for the preliminary instructions. I've already given those, and so I wouldn't give those again. And so I had those as struck through. I'll also note, by the way, we will consolidate all of these and give the jury a copy along with all the exhibits so that they can refer to these during their deliberations. I go down to the bottom of page 2 where it's most of the pattern charge on pleadings, and I try to delineate exactly what the claims are. So double check me there.
I guess on that, on the claims, Your Honor, I would just say that I think that it would be inappropriate for him to be able to argue that anything regarding the lien, the slander claim, which arose out of filing of the lien, would be that he could argue that as fraud, because he hasn't said that the lien in the pleadings, the lien is not alleged as part of the fraud. The fraud is when he signed the contract, he didn't intend to live up to it. So
Okay.
he's dismissed his slander claim. So that would be the only claim that the argument of a fraudulent lien would go to, or the lien would go to.
Okay. So I don't know what charge you're referring to, but I guess this is just kind of something else that came to mind.
Pleadings, I mean, you're talking about I guess it just comes up in terms of, it's just something that I thought of. You said to jump in as you sort of summarized.
Sure. Okay. Well, I
I
don't.
just want to be clear because I would like to, the instructions are important. I want to make sure that I understand what they are.
Right. So I don't refer to the removed claim in the pleading section here, but to respond to your point, I think through the terms of the pretrial order, the fraud claim is confined to the representations made when the contract was signed.
Right.
I don't think just because he's dropped the claim, referring to the lien is impermissible. I think whatever other evidence that can be argued from that, he can argue it. And if he thinks that it shows intent or bad faith or course of conduct and that sort of thing, that's all fair game. But
Well, okay.
because the lien was filed before the lawsuit, and so 13611 covers all conduct before the lawsuit's filed.
Right, and similarly, Your Honor, I think that on that front, it would be the argument about the text messages which happened during litigation. There's no, that's what they're complaining about. The text messages were given during litigation and discovery, and that they were missing, and that shouldn't be a basis for any kind of fraud or improper conduct that is part of the facts of the case.
Okay. I mean, I really just see you as now raising concerns of what might come up in closing and how things are phrased. So that could be a very limitless list of things, I'm sure. And I think we're just going to have to see how it comes out at closing. So I'm not hearing anything else about pleadings there. So I turn to page 3 where I have pattern charges. I've broadened the pattern charge on burden of proof to essentially make it applicable to both sides, since both sides are bringing claims.
Right.
I've got it noted where the parentheticals would come in. I think all these parentheticals, as noted, would stay. Evidence generally, I would give as charged here, and I would probably just include all the parentheticals here. And well, there's an alternative parenthetical second to last. I'd strike the one such as an eyewitness. I think such as personally observing covers that. So hearing none on page 3, I'll turn to page 4. We get to stipulations. I need to update that one. And I would update that to say they've been approved by the court regarding the amount of their attorney's fees and the issues listed in Defendant's Exhibit 23, I believe it was. And otherwise, everything else would be as indicated here. We've got the pattern charge on expert witnesses, just using the main one instead of the 11th Circuit alternative. And so unless there's any input on page 4, I'll move on to page 5, where we get to credibility of witnesses. Wasn't requested, but we'll put in the pattern charge there. And then they've got those specific charges on exactly how a witness can be supported or attacked. There's the catch-all on the following page that just says a witness is attacked by disproving the facts to which they testify to. And that kind of is more of the overall statement. Turning back to page 5, I'd struck through them just because I didn't know if those necessarily were, we needed to highlight those since we have the overall witness impeach charge, just saying if they're attacked. But if y'all want to hone in and, well, I mean, I suppose how I did this morning. So now that we've heard, we have had a character witness here, so I suppose we should be talking about this. So what I would do then, in light of this afternoon's testimony, is I would take the catch-all one about the credibility of a witness may be attacked on page 6. I'll move that to the top. And then I would include the old impeached version about witness attacked, where it says you may consider, and it would include character for untruthfulness. And that would be shown by specific instances of conduct. Well, again, I don't know if we actually got that far. It was more just prior inconsistent statements, which comes up later. So let me put it this way to the parties. Does anyone think that the charge 02.150 is justified by the evidence or implicated?
I think the first bullet point would,
Character for untruthfulness?
yeah.
Oh, I see.
So which one of those things was brought out here?
Character for untruthfulness. I guess not. Let's see, bias towards a party.
Which page are we on? I'm
I'm
sorry.
on 5.
5, okay. Okay, so
I don't have any objection to the removal of that, Your Honor.
Okay, so we'd remove that one, but then we did have witness supported. So I'd put that one back in and say, in determining the credibility of any witness whose credibility has been challenged, I'll use that parenthetical, and I'll throw in the character for truthfulness shown by opinion of other witnesses or reputation. And just leave it at that, unless there's any other aspects of this that anyone's requesting.
there you are.
Okay, then I move on to 6, and these are all pattern charges. So we've got prior statements, failure to produce witness, and then we go into contracts and the definitions there. So unless you see any issues with page 6, we'll be removing all the headers and references and that sort of thing. I don't see this as necessarily a consideration issue. I don't know if I would give the parenthetical at the top of page 7 unless anyone requests it.
You're talking about the parenthetical at the top of 7?
Yeah, about consideration.
Yeah, we can chop that.
All right. So I'll strike that parenthetical. And then we get to defendants 13. Is that still one that you're requesting, Mr. Craig?
Yes, Your Honor.
All right. You're going to have to tell me just exactly how that fits in, because a duress defense, as I understand it, is going to say that in defeat consideration. And it just seemed like a very unique set of facts that I'm not sure if I see that here. So why don't you walk me through that?
Okay, yes. So this would not apply to the contract, the written contract the parties entered into, but plaintiff is alleging there were these other oral agreements that were entered into in the midst of the project, and she has said she was under enormous pressure, financial and personal, to get this project done. And she really had no choice but to accept and concede to his demands. So to the extent that, there's a claim as to these other contracts, we would argue that duress does apply there.
Your Honor, I think the testimony was that she was wanting to get the contract done so she could get her father moved in. She had to keep it going. I don't think that it was that she was needing, that she was trying to receive money or, had some economic impact from the actions of Reynolds. I think it was more about what was happening with her family and why she wanted to get the contract done so she could get her father moved in. Because it was difficult on her to not have that happen, to have to deal with him living in the house and not in the ADU. And so I think that's not economic duress or business compulsion.
Well,
I think I understand the arguments. It's really just, I'm going to take another look at this case because, I mean, the case points out, and this was back in 2002, but as I put in the italics, there's never been a Georgia case voiding a contract under this theory, that it is a kind of a high bar, and it generally refers to illegal acts being committed by the other party.
I see.
And I don't know if the other party also has to have been the one that created the economic circumstances either. And so I'll take another look at this case. I mean, I think the things that you're talking about would be adequately and more accurately covered by just the fact that there was never a contract entered. There was no meeting of the minds.
Okay.
And I don't know if the circumstances presented here are going to rise to that level of saying that this is an economic duress case, but I'll take a closer look at that and we'll see. Okay.
Your Honor.
All right. I'll move on to page 8. We put in some more pattern charges on contracts that appear to be generally applicable here.
No objection on page 8.
All right. And then on page 9, we get into several non-pattern charges. And a lot of these are just quoting statutes, so I don't really see too many issues with that. But I'll start with substantial compliance. Any concerns with that as a non-pattern charge, Mr. Craig?
No objection to the first paragraph.
All right. We put in duty to ascertain facts as a pattern charge, but I don't know if that's actually applicable to this version of fraud, since there's really not a fact that was misheld. Is that accurate?
Not a fact that she could have independently ascertained.
So I would say that we would strike 16.410.
No objection.
All right.
No objection, Your Honor.
We have some general language there about rescission, about how a contract can be rescinded. That's a pattern charge. I think that's an issue percolating here. The next two we have about, the next 3 are all non-pattern charges about allowing performance. And I think I would be more inclined just to quote from the 2 statutes. So the bottom 2, I believe those accurately reflect the statutes as they're quoted. And so the first non-pattern charge, I think, is somewhat cumulative of the statute that's already listed there. So right now I'd say I would just be giving the pattern charges that are quoting 13-4-23 and 13-4-22. Does anyone want to be heard on that?
I'm fine with that, Your Honor. I think I thought I meant that to be alternative, because that's fine. That's fine.
Okay. All right, then. I will move on. We've got damages for contracts. One to flag here is nominal damages, and this is going to apply to the torts nominal damages as well. We've got a Supreme Court case coming out in June that is pretty important on that, and we've already changed the pattern. It just hasn't been reflected, I think, yet. We just changed that a month ago. So I have that sentence in italics, which is now If it's not officially part of the book yet, it will be. And so that would be based on the Walmart case about nominal damages being a trivial sum.
Okay, no objection here to the inclusion of the italic language.
All right.
No objection, Your Honor.
Okay, and then we get into attorney's fees. I had that italics. That was if there was still going to be some findings need to be made about whether the claims are intertwined. Since it appears that's no longer an issue, I'll strike the italics at the bottom of page 10 and just give it as we have written out there with the line edits and everything. We have a non-pattern charge on 11 that I've plugged in and used in other cases about just what is bad faith, so they can have some idea of what that is when they're assessing it. And then we have the other pattern charges on contract damages for the rest of page 11. So then I move on to quantum merit. And from here, we just did all the straight pattern charges here. Didn't really see much to tailor except for striking this part about the presumptions, about relatives. So we do have, let's see, on the top of page 13, we then have a kind of a crafted charge for unjust enrichment. If anyone has any input, feel free to weigh in, but I think that was an accurate reflection of what that claim means and the elements there. And so that's what we would plan to include.
No objection.
All right. Thank you. We go on to fraud, and some of these may not be as applicable here, so take a good look at these. I mean, do we need to get into constructive fraud? I don't think that's really what's being alleged here, is it?
I don't think we need to get into constructive fraud.
Okay, so I would
Oh, I don't know.
yeah.
I think we can take it out.
I have no objection, Your Honor, one way or the other. In terms of. And I'm out.
Okay. All right, then I'll plan to strike that one sentence beginning in constructive fraud. And so it'll just be those two sentences about what actual fraud is. Getting into the elements on element C, I don't think the fraud here is about refraining to act in reliance. This is about an intention to induce. So I would say we strike or refrain from acting in reliance. And so element C would just be an intention to induce the claimant to act or to act on the false representation.
Where are you, Your Honor?
I'm still in that same charge. There's A, B, C, D, E as to the elements of fraud.
Okay.
And I'm saying C, since this is an inducement fraud, I would remove the part about refraining from acting in reliance because that's not the type of fraud I believe that's claimed here.
Okay.
All right, and then I would ask if we need the pattern charge on misrepresentation and concealment.
I think that might be applicable here.
All right, I'll leave it in.
I'm not sure I'd like to understand what the material fact that was misrepresented was, how it was acted on. I don't know that I see that.
Well, that's a fair point. If the misrepresentation is I will perform, Is that what's complicated or contemplated by this pattern charge?
Well, it's not I will perform, it's I mean, I have the intention to perform some act. So a party lying who misrepresents their present intentions at the time of entering into the contract is committing an act of fraud per Georgia law. I can dig for that if you want me to, Your Honor, but that is our theory, that there was a misrepresentation about the deposit, that the plaintiff represented that he intended to refund the deposit to my client. And then ultimately that was untrue. Not only did he just, fail to refund it later, but he actually did not intend to refund it at the time that he took it. Also, the contract price, plaintiff did not intend to complete the project for that price at the time that they entered into the agreement.
All right, and this is getting into, I think, a lot of what you have in your non-pattern requests 18 further down, where you say a promise made without a present intent to perform is a misrepresentation of a material fact.
Thank you. Yes.
Right.
I knew I
So
had that in there.
yeah, it's right there, right below it.
I would just argue that they appear to be duplicative.
Right, I agree. So I think I would go with the pattern charge then, and both of the ones below it now having already been covered by the pattern charges, including plaintiffs, because that's just talking about the elements, and then defendants non-pattern, which is the one in 26.040.
I'm sorry, can I just look at this a little more
Yep.
closely, Your Honor? This one is important to us.
Can I get another clean copy of
So the pattern charge, oh, sorry.
version 2? Or have you already been editing it? No, the charge bag. Can I get another one because I didn't get it marked? Thanks. All right, sorry, Mr. Craig, what was that?
Quite all right, Your Honor. So I don't think the pattern charge really gets to the issue of the intentions of the party at the time that the contract is formed and a misrepresentation pertaining to those intentions. So the first paragraph of the pattern talks about, it's just a general fraud, principle, defines a misrepresentation of material fact being actionable. The second paragraph deals with willfulness, and if the person is injured, they have a right of action. And mere concealment will not support an action unless done in a manner to intent. So it deals with mere concealment. And then the third paragraph really deals with reckless misrepresentation. So that's the pattern charge. And then when we get to the two sort of dueling non-pattern charges, I think these are kind of redundant with one another. They both state that essentially a party who has no intention of performing the promise when made has committed fraud.
All right, I think I see what you're saying, and that sentence you have in your non-pattern request does add some clarity, I think, to the exact nature of the claim you're bringing here. So I would take that one sentence of your non-pattern charge and pop it at the end of the pattern charge.
Okay.
What sentence is that?
A promise made without a present intent to perform. So then one thing is of reorganization. Well, as I think I would take all of this whole section on fraud, beginning on page 13 and going through 14, and add that after the section on negligence to track the verdict form and to track kind of the order the claims are brought. So all the fraud charges are going to go after the ones on negligence, but before the ones on trover and conversion. All right, so I move on to the torts and negligence generally. And these are all, let's see. Start off with a lot of pattern charges. We've got plaintiff's non-pattern request regarding breach versus negligence. Anything about that one, Mr. Craig? On page 15?
Page 15, are we at 60.01?
We're a little bit further down there. I'm just skipping to plaintiff's non-pattern request.
Thank you, Your Honor. Sorry. Okay. That's non-pattern though.
That is.
Can I look at the case real quick?
Sure. Oh, okay. I just need to put a sticker on it.
On his version?
Yeah. Yeah. As long as I sticker it, that's all I was trying to do. And just put courts exhibit. I don't know if he has one of those. Do you have a courts exhibit sticker? I'll find one. I got one. I'll get one in the back. It's fine. Oh, okay. What we like what I haven't really I haven't written much on here yet. There haven't been too many line items. Yeah, well, I mean, he's looking at a case right now. I'm just trying to see what I actually wrote on here. And then this. Striking that, but it's
What page is that?
9. Yeah. Substantial performance.
Are you waiting for me still, Your Honor?
Well, no, if you have looked at that, any thoughts? I think we were on page 15.
I do think it is an accurate statement of the law articulated in Anderson, so I have no objection.
All right, so we'll include that. Also, we have one that hones in on negligent construction. It wasn't requested, but I think that this is the more specific basis of the claim here. So you can take a look at that, see if you have any input of the exact type of negligence that's alleged here. And I think this would more kind of fully cover what's requested in defenses number 21 on the top of page 16, just talking about workmanlike manner.
Yeah. I'm good with that. Thank you, Your Honor.
Your Honor, if I could just have a moment. I think it's accurate, Your Honor. Thank you.
Okay. All right, we'll turn to page 16. And so we're removing plaintiff's 21 because that's already covered. We have pattern charge on proximate cause. I think we removed the bracket because I don't think there's an evidence, or I don't know, maybe if there has, about contributing causes here, about combining with another cause to result in an injury. It doesn't seem like that is what is being argued. So we would then move into Trover, which are all these pattern charges that are to relate to the conversion claim. And I think this first one might be unnecessary. The first aspect of this first one unnecessary. I don't think there's an argument that the plaintiff was in unlawful possession at the time. It was more that they initially had the property, the countertop, the lumber, and then there was a demand and refusal. So I think to tailor this charge, it would begin, suits in Trover are proceedings to recover possession of chattels, that is personal or movable property. When the counterclaim defendant has come into possession of the property lawfully, there must be a demand and refusal.
Again, I think it only applies possibly to the sink. I'm certain that there wasn't any evidence of any damages as to the lumber, or that
Did we get the
or
text
that
message?
really who took it. Definitively, it could have been stolen. I mean, I just don't think there was any evidence of it.
There's a text message between Ed and Simon that I think they put into evidence, right? Did they talk about the value of the lumber? Never mind, Your Honor.
Okay, so Mr. Craig, are you planning to confine your arguments on conversion to the countertop?
Oh, I'm sorry.
Yeah, question to you, Mr.
Addressing
Craig.
me.
Yeah, question to you. Would your arguments at closing be confined to the countertop as it relates to conversion?
I intend to argue as to both the countertop and the lumber.
Okay.
I can't say for certain, I just don't know for sure if the value of the lumber was mentioned at some point in the last couple of days. I don't have a clear recollection of that, so I would not be comfortable conceding that it should be left out of closing. I'd prefer to have the issue deferred.
Okay. All right. Well, we'll tailor it as best we can here. So I move to page 17. These are all the pattern charges on Trover again. And so I think that would already have covered defense request 23.
So when you read that 70.120, Your Honor, will you read the note?
No, I generally would not. But if you're saying that's
I think that should be included.
that should be included. Well, that's what the pattern charge I think is saying. Does not mean the highest estimate given by any witness, but it's what you think it was worth. That's what the note is. It's basically just another way of saying what's just in that pattern right above it.
We're happy with the pattern charges over here, Your Honor. You can strike the defendant's request 23.
Okay, we'll strike defense request 23. I'll move on to 18. I've got a non-pattern on veil piercing, just saying generally, when can someone pierce the corporate veil? And when can an officer be held liable for torts. And that's taken from the Thorpe case I cite here. And then the bracket, actually, I think I would strike the unjust enrichment because that's not a tort. And the punitive damages, attorney's fees, those are going to flow as a matter of the verdict form. So I'd strike that in the bracket as well. So it would just say whether he can be personally liable for negligence, fraud, or conversion is a matter for you to determine. So any thoughts on the page 18?
I would object to the top part of that charge, Your Honor. Everything above the paragraph 1, a tort is committed. I think that's a separate claim, piercing of the veil. It has to do with more, commingling of assets, failure to observe the corporate formalities. There's been no evidence of any of that. No discussion of piercing any corporate veil. So we would seek I think the second part is, and I want to look at Thor, but it's potentially good, but I don't think the top part is relevant to this case. It should have to be supported by an actual claim to pierce the corporate veil, which is not in this case.
Okay. Mr. Craig?
Much as it pains me, I will have to agree with Mr. Burney.
Okay. All right. I'll strike the top part, and then you can tell me what you think about Thorpe when you've had a chance to look it up. But that's what I saw as the theory here of how Mr. Reynolds is reached individually.
I do like the inclusion of Thorpe, and I would contend that it's essential. So that's the second part of your charge there.
I reserve the right to come back to you on that, Your Honor, if I could.
Sure. All right, we move on to page 19 where we've got tort damages. I'll note the addition to nominal damages. And duty to lessen. We've got a request for pain and suffering, general. And I think there are several notes here for us to sort out, which is, I jumped here to 21. What's up? Where's that? Oh, right. And because I think the nominal damages in the pattern charge is already covered, and I actually don't think patent request 28 is any longer a good statement of law in light of that Walmart case. I would strike defendant's non-pattern 28
Okay, yes.
on nominal damages. But on the general pain and suffering, there's been no physical injury alleged here, so I think we need to make sure that one of these, as noted in the pattern, exceptions applies from OBGYN Associates.
Sorry, Your Honor, I've lost this word. You're on page
Sure.
21, correct?
I'm on page 21. I go down to mental, and there's this item about, but mental suffering is not a legal item of damage unless there's physical suffering also. And this not having been a physical injury case, to take the pattern on its face would suggest there should be no mental pain and suffering recoverable here. But there are exceptions, and I just want to, as noted in the notes, we need to see if any of these exceptions are applicable here.
I don't think pain and suffering, I mean, that comes from either a claim of negligent infliction of emotional distress or intentional infliction of emotional distress. That's not what's going on here.
I mean, it comes from negligence. People bring car crashes and say, I've got pain and suffering, right?
True. You're right.
But it's when there's no physical injury, that's what I'm more honing in on.
Hasn't been any allegation of physical injury. There certainly be well,
So, Your Honor, you mentioned there are some exceptions. Are these described in the pattern charge?
They aren't. They just kind of say, go read this case.
Oh, okay. Let's see here. Do you have the case right there?
It's
Under your
it's
eyes?
OBGYN, the 1989 case. So you can see the note down here where it says subsequent case law.
Oh, thank you, Lexi.
And this is the impact rule. for tort claims?
I know I researched this before I submitted the charge, but I did not look at this case. Emotional distress, is there a different charge for emotional distress? What's that?
Well, I mean, essentially, I don't know if this case is really calling into doubt whether pain and suffering should be included as a pattern charge or measure of damages at all in this case. I mean,
Mm-hmm.
the negligence claim, there is no physical injury alleged. Uh, the fraud is the same measure of damages. If there was still a slander or defamation claim, then we'd be talking about injury to the reputation, which would allow some emotional distress damages, but that's not any of these torts. And so I guess essentially I would say, Mr. Craig, ball's in your court. Why should this request be included of pain and suffering generally as a measure of damages for any of your tort claims?
Can you give me just a moment to check my notes, Your Honor?
Bless you.
One observation, Your Honor, it says that mental suffering is not under. Okay. I guess I'm a little confused on what we're deciding is to stay in the charge or.
Right now, I think the idea is that this charge shouldn't stay in at all because pain and suffering isn't recoverable on any of these claims or under the faxes that came out here.
Just one more moment, Your Honor. I'm trying to salvage this, but it's not looking good. Can we come back to this later?
Yeah, we can put a pin in that.
I don't know if we'll have a pocket of time for me to
We'll
really
see.
try to address this. I don't know. I would say probably just strike it. But if I find some time to look into it, I'll try to come back to you with a saving
Okay. right.
argument. But
We'll revisit it, but right now I'm not seeing how it survives the impact rule under these facts.
I know I researched this, but if I can't justify it now, I think we just got to move on.
The top of page 22, defense requested kind of definitions on general versus special damages. I don't know if that's necessary to include here. We're going to have the pattern charges on tort damages just generally. their pay or compensation for injury done, kind of distinguishing between the two, unless you were wanting to delineate them in the jury verdict form itself. I'm wondering if there's even a need for the jury to know what that means. So,
We can chop them.
all right. From there, we've got our pattern charges on punitives and the higher standard of proof for that, and that's all pattern. You had a request down here about the 250,000. That's where I have them needing in the verdict form to make a specific finding on specific intent to harm. So I don't think we would need your request there talking about what happens should they find that.
Okay.
We would just have them have to make a finding on what it means, whether they possess the specific intent to harm, which is covered in the patterns on page 23, where I direct them make this finding on specific intent to harm as well.
Okay. That's fine, Your Honor. Thank
All
you.
right. And then from there on out, it's just kind of the closing pattern charges on unanimity and everything else. So why don't y'all take a minute if you need to kind of see what other things you want to raise about the charge, and then we can see where everything lands. We can go off the record for a moment here. Yeah, that's fine.
Okay. All right. Thank you. But I swear I researched emotional distress and fraud. You could maybe it was an AI hallucination. I know now it's all right.
And real quick,
Yeah,
to hear
that's
your-
right. Move that
so
to
I
the
put
top
that
of right here.
After credibility.
Yeah.
Yes. I'm gonna, okay. That's right.
Keeping,
Which he should do.
well, no, actually,
He'd be
no.
competent if he wasn't doing it. That motion for directed verdict is addressed.
Yeah, sorry.
It was presented in the court, which is different.
Yeah, getting rid of this one, keeping this one, and Ginger.
I don't know that we ever talked about. What I had in my notes was that they were like, they're more. I think honestly, we should dump it because the jury, they don't give a fuck about that. They care about like this huge fuck up on the house. To me, wasting time even talking about that during closing. It's like. Yeah.
So duress was one I needed to look at.
God. We didn't have 6 days. Your Honor, oh, I'm sorry.
Let's go, if you're ready to talk again, we'll go back on the record. Give me 1 second.
Show my opinion of whether witnesses or reputation.
Yep, that's it. All right, we're back on the record. Mr. Craig?
Well, I don't want to create any extra work for you, but I've conferred with my client. And we're not really going to argue the conversion claims in closing. And in light of that, I think we can just go ahead and withdraw those claims, which would allow you to take them off the verdict form and out of the pattern charges and would just simplify the case.
Okay. All right, let's see. Just make sure I've got what all that includes. All right, so on the first page, yeah, we'll take out that one claim. It'll be everything on 16 and 17 regarding the Trover. And that would be it.
Your Honor, is there an appropriate charge that should be given if claims are dropped from a lawsuit?
I mean, I would just instruct the jury that those charges are no longer for their consideration. They're not supposed to, and that should have no impact on their consideration of the remaining claims. That would just be something I would generally tell them. I don't even know if they could sit here and list you what the claims are right now. So I don't, if, you know, we can highlight that or not, or y'all can just bring it up in closing.
Fair enough, Your Honor.
Okay. And again, like I haven't yet. And I wasn't thinking to do it in this case to send back the pleadings. I just think that kind of unnecessarily complicates things. And so since they don't have that pleading to follow along with, it's the verdict form and the jury instructions that we give them as them to know what's at issue.
And to be clear, just no other pleadings are going back to the jury either. In terms of discovery pleadings.
Pleadings just being complaints, answers,
Requests or
admissions, right,
Interrogatories, those are
Right.
not going back with the jury.
right. Those would all be, I think, and also fall under a continuing witness rule. So I'm going back to the duress pattern charge and consulting Georgia contracts here, where it just talks about what is this doctrine of duress. And the code section pattern focuses on illegal conduct and essentially saying the act is wrongful and it causes the party to enter into the contract. And the contract must be executed solely as a result of the duress. And we're talking about illegal imprisonment, threatening to put someone in jail or to criminally prosecute them.
Let's chop it.
I just don't see how that applies to this case here. So I would not plan to give that.
Thank you, Your Honor. I appreciate your.
Here we go. Economic distress or a difficult bargaining position is not sufficient to constitute duress. It's not duress that the contract was entered into reluctantly or that the bargaining power was unequal or negotiations were unfair. So so just for the record, I'm reading from chapter 316 of Georgia Contracts by Larkins. So I would say that it sounds like without objection, we're removing duress as a defense to the contracts here. So I think the only one we left to pin in then would be just general pain and suffering and whether we think that is an appropriate measure of damages here to consider under the tort claims. Do you have anything for us, Mr. Craig?
Nothing new, Your Honor. So I think we're letting that one go.
All right. Then with that, we'll delete that. We'll consolidate all of these. We'll give you a final version here and as well as amend the verdict form, take out that claim. And I mean, would y'all want to come back in 15, 20 minutes or what do you want to do?
I intend to split my closing, Your Honor. So I'm happy to get started. I would ask a question just for clarification. Can I use the charges in closing?
Oh, absolutely. That's why I'm printing them off for you.
Okay, so
Yeah.
can I put them up on the screen?
I don't have a problem with that.
Okay.
We need to send them to you in electronic form too. So why don't we do this? Deputy Scott, if you're still with us, can you give the jury a 15-minute warning and then we'll get started with opening closings here and see where that takes us as we finalize the charge.
The jury to see.
We're off the record.
And go.
Try.
All right. So this one's no good. Say what? Yes, it is separate. Water basically good or?
Oh, this year. Yeah. And I need the access to it. Available.
I got them right here. Oh, no, that's the free trial order. I don't think I have them anymore.
Okay,
Okay.
let me finish doing.
Mr. Derberry, if you're with us, what time could I tell the jury tomorrow that you're bringing pizza?
This is from a different hearing altogether, along with this.
Oh, very well, Mr. Derberry. I was gonna tell him.
I don't have it delivered at 1:30, at 11:30. Well, that's then, I mean, you can get it sooner, but not much. It might sit, I think that might be the earliest, so. 11:30. I'll go ahead and put the order in it. I think the last time my option was 11:30 was the earliest. If it's 11, I'll just change it.
Yeah,
So what
okay.
I'm gonna do with these, they're split.
Okay, great. Right here.
Not numerical, but they're split.
Can we get them in numerical? So I can find you.
Okay,
They got that, please.
that's the defendant. There's some more plaintiffs.
I. think I'm closing. So, yeah, well. I'd be a little faster over here with my mouse. I got this. This game. Oh, you don't see the mess? It's okay. All right, that's okay.
Yes.
Throw that in there. Oh, that'd be great. I could borrow your mouse a bit. Oh, did you?
Where's that? Well, I just think.
What happened to mine? That's just the very form. There you go. All right. I don't need it back. Great.
Oh.
It might be in my backpack. All right, yeah, I got something. I don't know. It's yeah. Only with this, we went down to only two. I would say. Five.
Your mouse is nice, though.
On either.
Have you do the PowerPoint maybe too. I'm gonna, if my PowerPoint come up in there.
Five or six.
Thank you, Jesus.
On
No, that's all right. It might be in one of the
I
boxes
put
in
it
my
in one.
backpack.
That's it.
I put it in.
Oh, good. Worried I took it home.
Okay.
Okay. To the charges.
Mhm.
This one to match the verdict one I put last.
Perfect.
And then before I moved all this stuff about. Does it make sense to do that?
Actually, I don't know. Unjust enrichment should follow. and stay
Yeah,
away
I'm not
from
sure how we
torts,
split it up
right?
exactly.
Okay, it
That's how
doesn't
you
match
have
the
it.
verdict form though,
It doesn't.
but,
It
okay.
doesn't, but it
I'll move
does.
it back up here,
I
which
know.
is what I thought made sense.
Oh, did you just
Oh, to
do it?
watch the closing?
No, I'm putting the
Okay.
verdict.
Yeah, yeah, that's fine.
Okay.
Yeah.
So do you want it to go?
I don't know,
What
actually, you
did
know
you
what?
say you're changing?
Just leave it on the back. No, you're right. Just leave it at the end. It doesn't matter.
But
Yeah,
that's at the end.
just leave it at the end.
Okay, but then what about all the general tort stuff? Cause you wanted, what? Negligence. The only when you move conversion,
Okay,
when you were
defendants
going
are in
over.
order.
No, it was fraud. Fraud needed to go
Fraud, you
inside.
wanted to.
It had to go
do
after the thing about torts.
After the.
Because right here in the torts, we say we have these things. So then it should be negligence, then fraud,
Negligence and fraud,
and then you can tap on it. That's good. That's torts introduction.
negligence, fraud.
Yeah. Yeah, exactly. And honestly, the stuff we gave up is pretty easy. I put in like a lot of fucking margins.
Here, plaintiffs. What? Hasn't been marked, but. I can do that. Are you sure? I can do it really quickly.
Okay.
Yeah. I think they said they give like a break. They didn't say. I'm gonna run to the bathroom really quickly.
Sure. He said,
Just leave it there. Oh.
say talk about.
Do I think we have one finalized?
I just need to.
She's gonna give
In direct evidence, such as Hollywood method.
Yeah.
Okay.
Mhm.
So a fact such as I personally.
Sure.
Your Honor, may I step out for just a second?
said, I want to give you notes, but I know better. What do you want to say? Sweet.
This was a draft. Page 16.
Yeah.
You may award versus imposed punitive penalties.
Award. Right.
interesting, the charge on punitive damages, it says if you decide to award punitive damages, then you should further specify whether you find specific intent to cause harm. I
Right.
guess, well, I mean, the verdict form says to go vote, so
Yeah.
hopefully there won't be an inconsistency.
No, there's not. The one follows the next, I think, on the verdict form. Right. Yeah. All right, ready to go back on the record. Ready? All right, we are back on the record and providing a consolidated written copy of the charge to the parties. I also have a revised copy of the verdict form here for inspection if anyone wants to look at that before we'd give it to them. And I would say right now the plan of attack would be to bring them out and begin closings, and I think we go until 5:30 and finish closings, and I'll just charge them in the morning. I think at this point that there's much point in staying. And I mean, we still have to compile exhibits and all that sort of thing. So I'll just tell them they'll come back in the morning, probably have them report at 9:30. And my plan would be to also go ahead and let the extra alternate go and tell him he's still on call. He just doesn't have to report in the morning. And assuming all 12 of ours come back, those will be the ones we charge at 9:30 and then send them back there to start deliberating. Anyone want to weigh in on anything else related to the charge or anything else before we bring in the jury, beginning with the plaintiff?
No, Your Honor, thank you.
Okay. Anything on behalf of the defense?
No, Your Honor. Thank you.
All right, then hearing no other objections to the charge, we'll consider the charge conference concluded, the evidence closed, and Deputy Scott, if you can retrieve our jury. All right, thank you. Please be seated, everyone. Welcome back, members of the jury. Apologies for the delay. We've been working on the law that applies to this case while you've been in the jury room. But we have now reached the point where the evidence is formally closed and we're ready to begin closing arguments. And as I mentioned to you yesterday, by law, the parties are entitled to 2 hours each. But the attorneys here have graciously agreed to cap each of their arguments at an hour. So I believe we'll be able to finish closing arguments at the latest today by about 5:30. What that means, though, is at that point, it's probably too late for us to be able to charge you on the law and to begin your deliberations. So I think the plan of attack would be to bring you back tomorrow morning. I would charge you on the law, and then the time is yours from there. So with that roadmap, we turn to closing arguments. And as I instructed to you at the outset of this case, is that closing arguments are not evidence. They're just the statements of attorneys drawing your attention to the evidence they believe was introduced and that is important for your consideration. And the plaintiff has the right to open and conclude the closing arguments in this civil case. And so with that, I will turn it over to Mr. Burney.
Thank you, Your Honor. All right, ladies and gentlemen of the jury, first of all, I'd like to thank you very much for being here today. These last several days, it's been a long week, and thank you for paying attention to this case. I'd like to also thank the court and its staff for being so accommodating and gracious and allowing us to put this case together. I'd like to thank Mr. Craig too for being a good person to work with in this case. I have the right as the plaintiff's counsel to split my opening, and so I'm going to do that. I just wanted to tell you all that I thank you very much for what you're doing. The evidence in the case is closed. What you'll hear next is not evidence, but argument. And hopefully we can show you the evidence that we think is important and let you and give you some instructions about the jury instructions and what those mean. And then I will come back and finish up after Mr. Craig's.
I was not listening to you, sir.
He says he's done.
Oh, okay. All right. Very good. Yeah, that's all right. Your Honor, go ahead and run my clock. We're just going to take a little time to get a little more organized before I start. All right. And okay. Got a little. Just plug that in. Ladies and gentlemen of the jury, thank you very much for your service. All this. Agreements must be honored. The primary rule of contract law, the very first thing we learn in contracts class in law school, is that agreements must be honored. There's a Latin phrase for this. Pacta sunt servanda. Which tells you that agreements must be honored, but it also tells you this is a very old rule. Going all the way back to Roman times. It's an ancient basic rule of the law. If you don't have this one basic rule, you don't have contract law. And if you don't have a contract, you don't have a civil society. A contract is by definition an agreement that is enforced by the law. Now, you all have direct experience with this. You enter into contracts all the time. You've bought a car. Maybe you've bought a house, signed a lease, accepted employment. And you have abided by your agreements because you know that is the expectation. That is the requirement that our society imposes on its citizens. That is necessary for the orderly functioning of a modern civil society. So if you find that Mr. Reynolds entered into a contract, it is your legal duty to hold him to that agreement, just as it was his legal duty to honor that. Now, I've got this cheesy stock photo symbolizing a contract. And I put that up there because I needed a visual aid. But when I found this picture, actually really made me start thinking about what a contract means. when you enter into a contract with somebody else, it is more than just words, it's a kind of bond. It's like you're putting your hand into their hands. You are investing them with your trust, and you are to some degree putting yourself at their mercy. And they're doing the same with you. You become kind of entangled with one another. So obviously there's very simple little contracts, very fleeting contracts. You know, you go and buy some popcorn, believe it or not, like a little micro contract. But a big contract, like the one in this case, it's very, very entangling. So when people enter into this bond, and when someone is at another person's mercy and that bond is broken, that can really hurt someone. And sometimes that's a small thing, but sometimes it's a really big deal. And you can't just say, oh, it's just a construction matter, and dismiss the real world consequences of a breach of contract. You can't dismiss the human element, the human consequences of the breach. So in this case, as I recited for you in the opening statement, Reynolds Renovations breached its contract because it did not honor the contract price. It did not complete the project on time, and it made all kinds of changes without a change order. And this caused a lot of problems in the construction. So here we have the backyard before construction. I just put this up here so you remember kind of where the property started out, what it looked like in the beginning. And there were a lot of defects in the construction as it took place. I'm just going to read a few off to you. The house was in the wrong place. There were elevation changes made in the yard. The porch was changed to a wraparound porch that protrudes out into the driveway. The breezeway is in the wrong location. The porch on the main house was extended without permission, which blocks the gate to the front yard. The wrong shower tile was purchased. Mr. Reynolds left construction debris all over the yard. The electrical was messed up. He installed an inferior HVAC system without notifying his client, Mrs. Maia. He installed an inferior water heater without notifying his client, Mrs. Maia. He messed up the roof flashing. He made the bathroom door too small for the doorway opening. And let's see, you all are expecting more slides as I go through this. I will get to these. And actually, I'm going to move forward to the bathroom door. Here we have the debris. Here we have the driveway where you can't get around that corner. And here you have that doorway that's too small for the opening. Now this picture is amusing, but there are some problems here that are really not amusing. They're big problems. And in my mind, the biggest problem is this driveway. When you build a house for a disabled veteran, it pretty much goes without saying, you got to get your handicap van up that driveway. That is absolutely necessary. The whole point of the structure is to care for that disabled person. If they can't get in and out of the house, it's of no use. Another major problem was the electrical. This was a man who was on oxygen. He needed a constant, steady, consistent, and reliable source of electricity to sustain his life. If he didn't have reliable electricity, he couldn't be in there overnight or even for any length of time. So I was struck, really, that Mr. Reynolds didn't actually understand very much about the veteran's disability. He just said that he was bedridden. And I thought, well, you know, if you're building this whole thing for this guy, wouldn't you just want to take, I don't know, a couple of hours at the start of the project to sit down with the family and just talk with them about what their daily life is like, what this guy's needs are like, what and how exactly this is going to serve him. Because with all of these defects, this didn't serve him. Couldn't get in and out. It just, he never got to use it. And one other serious problem, the wavy floor. This one I have a hard time understanding because, you know, as I'm pacing back and forth here in front of you, this floor is flat. In fact, I would wager every floor that y'all crossed over on your way from home to the courthouse today, right here, was flat. I've never seen a care facility for any disabled person that didn't have flat floors. I don't think I've ever been in a house that didn't have flat floors. Flat floors are important. And to not do that right, that's a foundational problem, you know, both literally and metaphorically. And then not to want to address it when it's brought to your attention, I can't understand. So, I mean, we've had all of this information thrown at you about the deposit, this contract and that contract, and the inaccurate invoicing. You know, there was this series of invoices for the project. And, you know, there's a dispute over $7,000 and there's a dispute over a $16,000 deposit. But I mean, she couldn't use the house. She could not use the house for her dad. How do you come in demanding that she pay you another $7,000 when you haven't done the job? The whole purpose of this thing was thwarted by problem after problem. You know, Mr. Reynolds, he might be a fine builder, but he didn't do a good job here. And we brought in an expert. You know, we're not just asking you to take Mrs. Maia's word for it. We brought in an expert, Mr. Blanco, and he's an architect and a contractor. And you know, he was only here for a half an hour or so. That's the only time he needed to tell you, yeah, there were a lot of problems here. a lot of problems, serious problems. And he confirmed everything Regina's been telling. You know, she's not pretending to be unhappy with this project. You know, this is not, she's not just trying to nitpick or get out of paying $7,000. You've seen, she's genuinely very upset about this. This didn't work. All right, where am I on my slides here? I just need to get oriented. Okay, yeah, so let's go to the complaint. So in this closing argument, I'm trying to focus on the really important points in this case, the things that I think really define the whole situation. And I want to talk about this lawsuit and what happened here at the end of it all, because I think that actually this lawsuit speaks volumes in and of itself. So, you know, we're not going to spend too much time rehashing what we've already talked about. But Mr. Reynolds, through his company, he brings this complaint in the Superior Court of Fulton County. And, you know, he sues the dad and Mrs. Maia. And, you know, he could have gone to magistrate court. You know, magistrate court is a forum where you can hear small claims. Anything under $15,000 can be addressed in magistrate court. It's our small claims
Objection, Your
court.
Honor. Can I approach?
Yeah. Yeah, I do. Just why don't you just perfect the record here?
Objection. I'll make it clear. So magistrate court is for small claims. All right. And but what you can't do in magistrate court, all right, what you can't do is you can't foreclose on somebody. All right. You can't foreclose on a lien. So he could have gone to magistrate court. He could have gotten a judgment for $7,000. But he didn't want to do that. He wanted to foreclose on the property. And I should add, by the way, that in magistrate court, there's no jury. It's not a week-long trial. It's not a years-long process. You go in and you can get things done in an hour. And for a $7,000 dispute, that's generally what people do. So why not keep it simple? You know, why did we have to come to Superior Court? Well, let's just look at what they were asking for. You know, the $7,000, and then to foreclose on the lien, and then attorney fees and a jury. I mean, it's just so excessive. It's so over the top. it's so incredibly aggressive. It's like, it's kind of staggering to me. And now let's back up and just look again, once again, what was alleged in the complaint. The complaint was that plaintiffs and defendants are parties to the agreement signed on October 10th, 2020. This was their public statement as to what was the agreement between the parties and what was the agreement they were suing on that was the basis for their claim. All right. And then the next statement is defendants have breached the agreement. So they're saying, okay, we're suing for breach of contract. We're suing for breach of this October 10th, 2020 agreement, which you guys have seen a bunch of times. So, you know, all right, I think, okay, we've got a copy of the agreement attached to the complaint. You know what this case is? And, you know, like a year later in deposition, all of a sudden, we're talking about side agreements. And, you know, I don't understand that. You come to court, you make a public statement that this is my contract and this is what I'm suing on. And then a year later, it's a different story. So I want to go back to this page though, and explain to you what foreclosure is. You know, what happens when somebody forecloses on a lien is that the property gets auctioned off on the courthouse steps. Then the money from that sale is paid to the holder of the lien. Well, the excess proceeds do go back to the title holder, but ownership of the house goes to the buyer. The family loses ownership of the house. And the then the $7,000 goes to the lien holder. And this to me is kind of where the case just took the wrong turn. Because who does this? I mean, it's extreme to foreclose on a lien on a family over $7,000. That's extreme. But then when you add in the fact that the family is caring for this disabled veteran and he's in hospice, and you know this, you know his condition, you know, at least you know he's bedridden, and you still do this. To me, it takes an astounding lack of empathy to do something like this. Over $7,500. Now, Mr. Reynolds' explanation was, well, I needed to preserve my lien. But what was the lien for? It was for $7,000. So when he says, I needed to preserve my lien, what he's telling you is, I wanted my $7,000, right? I'm willing to foreclose on this family for my $7,000. And did he need it that badly? Well, I don't think anybody needs it that badly. But he didn't, because, you know, he just had another lawsuit and he got his $30,000 out of that case. So he just gotten some cash. I don't know. The thing is, that lawsuit, that was a lawsuit like this one. And in Superior Court, that's expensive, you know? That's tens of thousands of dollars minimum to prosecute a lawsuit like that. So he's got money to go on these adventures in litigation, to spend tens of thousands of dollars on jury trials. So is this really about the money? Because this case has cost him far more than $7,000. He knew he was starting a fight here, and it was going to be an expensive fight. He knew that. He'd already been around the mulberry bush one time. So he knew what he was doing. And he told me during our conversation here in court, oh, I didn't know what foreclosure was, right? I didn't know what foreclosure was. But I have a hard time believing that, frankly. The man is a general contractor. He works in the construction industry. He's dealing with real estate day in and day out. He worked in the industry through the subprime mortgage crisis when everybody was getting foreclosed on and losing their homes. He knows what the word foreclosure means. He saw the word foreclosure in his complaint that he had his attorney file. And, you know, doesn't he have a responsibility to just reflect on what he's doing? Doesn't he have a responsibility to know what foreclosure is if he's going to sue somebody to foreclose? Is that really a defense? I didn't know what I was doing. He had an attorney. Mr. Burney prepared this for him and filed it. So he had the advice of legal counsel. He's a contractor. The foreclosure, what a foreclosure is common knowledge. It's not plausible that he didn't know what a foreclosure was. And even if by some bizarre possibility he did not know what a foreclosure was, it's not an excuse. He had a responsibility to inform himself about what he was doing. He's also asking for attorney fees, and he knows what that is too. And he has sat up here and he's kind of expressed remorse, like, oh, I really regret how all this turned out, right? It didn't turn out. He did this. He chose this. He's been pushing it and pushing it and pushing it for 3 years to get it here, to get in front of a jury, to charm the jury. You know, his debonair gentleman persona, which I think, you know, to a large degree is authentic. But there's more to the man than a debonair gentleman. There is an anger there. There is a desire to make a statement, a desire to hurt, a desire to use force, a desire to make these people submit to his demand. Because you don't go to Superior Court and try to foreclose on somebody for $7,000. It's not that important. It's not in proportion. You don't hire an attorney that's going to cost you tens of thousands of dollars to get $7,000. That's not a rational choice. So that tells you everything you need to know about what was going on in this case. And I would like to add that if he regretted this, if he was sorry, why is he up here apologizing to you all? Y'all aren't the victims. Why would he express his regrets to me in front of you? He hasn't apologized to my client. He's never expressed the slightest remorse to Regina. The only time we've heard anything like that out of him is in here in front of you. Maybe he understands that this doesn't look good. Right? It doesn't look good. So he doesn't want consequences. But this is what he chose. Now, they're going to tell you they dismissed this fairly early on in the case. And I want to put that into a little bit of context. Because if you're really listening, they also told you why they dismissed it. They dismissed it because when you do foreclosure, you foreclose on a lien, okay? And the lien, you gotta have a lien to do the foreclosure. And they filed their lien really late. And so, and they also didn't do the paperwork right in other respects. So, you know, shortly after Regina hired me, you know, we just saw that the lien wasn't done correctly. Actually, she pointed it out to me. You know, so I filed a motion to have this dismissed, you know, because I wanted the judge to look at what was going on.
Your Honor, I would object. None of this has come into this case. It's inappropriate for him to argue this.
All right, members of the jury, I just want to provide you with this instruction that any point being made here recently regarding the procedural history of this case and what happened to the lien as it results in any ruling by this court is really not a relevant matter for your consideration, and you're to disregard that and not give it any consideration in your deliberations. All right. With that, Mr. Craig, you can proceed.
Thank you, Your Honor. All right. So I think we've exhausted this topic. But I will simply reiterate that this foreclosure escalated the lawsuit tremendously. I mean, it started the lawsuit. It escalated this dispute tremendously. And it speaks volumes about Mr. Reynolds' motivations in this case. And there's another point in the case that I think is very significant in this regard that I also would like to talk about specifically. And that's at the end of the job, the project is substantially complete. Things kind of really fell apart very rapidly there at the end, like April of 2022. And I would ask you to put yourself in my client's shoes in April of 2022. She's got a full-time job, okay? And she's got a second full-time job, essentially caring for her disabled father. And she's had 2 bereavements. Or 1 bereavement, and she's got another brother who's dying, and she's trying to find him an organ transplant. Okay. And she's in the middle of this dispute with Mr. Reynolds, and he's certainly not giving her any quarter, any space to deal with this. He's still demanding his money. And she's been begging him to fix things, all kinds of things. I mean, you've heard her testimony. She was constantly asking him to fix problems, and one of the problems she asked him to fix was the retaining walls, and the bare embankments in her yard. And he came in and put in retaining walls. And then he wanted to charge her extra for this, for supporting the embankments that he had created. You know, during the construction process, when he deviated from the plan. So she's at her wit's end, and this is the very end. So, you know, she paid him this deposit, and you heard her testimony. It's absolutely clear and unequivocal that she was expecting to get this money back. And you heard the contractor who was here, Mr. Blanco, he told you, yeah, that's normal. When you put down a deposit on a construction contract, that money comes back to you. It's part of the contract price. So when the contractor gets paid by your bank or the VA, when they get those disbursements, then they give you the deposit back. And as a result, you know, you've got a fixed price contract and that's just the price you pay. So that's normal. That is normal. What Mr. Reynolds has described is not normal. And that's why you use the word deposit. So she's expecting her deposit to come back. And it becomes clear by April, it's not happening. And she realizes that he never intended to refund this deposit to her. That he has kind of played her on this. And so now she's really mad. She can't get things fixed. And she's been defrauded. And she's grieving. So she just tells him, you know, don't come back to the property. You know, she's done. And when you've made an effort to work things out and you're not getting a good faith response, and you have a lot of other things going on that you have to deal with, that's a rational thing to do. And Mr. Reynolds knew what was going on with her. He knew what she was going through. And so he just decides, okay, I'm done. I'm not going to try anymore. And I don't know. I go back to the fact that he's the industry professional, right? He's the contractor. He is supposed to be the one who knows how to handle these projects. He's the one who knows how to reconcile these differences and to do, you know, dispute resolution, to soothe his upset clients. And he just decides it's over. He's not going to try anymore. He'd rather, you know, wait 4 months and then do this foreclosure. That's his way of de-escalating a difficult situation. Just come in with overwhelming force. And so, of course, they will have to give in to your demands. And then I guess it's over for you. But I would like to point out that after we counterclaimed for negligent construction, he could have said, wait a minute, I'm invoking the Right to Repair Act. I'm gonna pause your case and I'm going to require you to consider a written offer to make repairs. And he never did that. He could have forced the case into a dispute resolution process if he had been interested in a dispute resolution process. But he was not. And that is evident by his choice not to invoke the Right to Repair Act. I would also like to remind you all of the undisputed testimony that Regina would have just moved on with her life. That's what she told you. She didn't sue Mr. Reynolds. She didn't want all this. She didn't take him to court. And actually, you know, she's got great claims. She's got very substantial claims. I mean, that ADU needs $100,000 worth of work, approximately, per the estimate we provided, to bring it up to par as a dwelling for a disabled person. And she's got a disabled person at home. You saw her mother in here. She could still use this ADU for her mom, or could have been using it all this time. She's not litigious. She really didn't want this. She got dragged in here involuntarily. And she's still being sued. He's still demanding the $7,000. And you know it's not about the $7,000 now. All right. So I would like to talk about our counterclaims a bit. This is a civil lawsuit. And the only thing we can really do for her, that you all can do for her in a case like this, is award her money. And that money can be used to make repairs on the property and try to fix some of the things that went wrong. And she's also asking for attorney fees. Just, you know, put her back in the position she would have been if none of this had ever happened and the project had been completed as promised. So her statement at the end of her testimony about what she wanted was just to be made whole. She just wants to be made whole. And so I just want to talk to you all a little bit about what that looked like. So let's see here. Let me look at the slides real quick. So she's got a claim for a breach of contract. All right, and there's been some argument about how much she paid. We paid a total of $150,000. Okay, and actually, I guess I could show you all that here in just a second. But for my note takers, please, jot this down if you would. So we contend she paid a total of 150. The contract price was about 120. And so the difference is about $30,000. So that's kind of what we're looking at for breach of contract. The difference between the amount she paid, price of the job that was promised to her. So just to get the 30 grand back. We could argue that there's other ways of calculating that would result in much higher numbers. But we think that's covered pretty well under negligence, which we'll get to here in just a second. And then we also have a claim for fraud. Thank you, Lexi. So fraud, take that off, please. So I'll just tell you about the claim for fraud. So our understanding of the fraud claim is this. When you enter into a contract with somebody, if they lie to you and they use that lie to induce you into that agreement, that's called fraud. All right, so it's different from just a standard breach of contract. So like if you enter into a contract with somebody and then they don't fulfill their promise, but you know, maybe it was an accident, maybe it was something beyond their control, they might still be liable for not fulfilling the contract, but it's not fraud. They went in with good intentions. They were trying to fulfill the contract and they couldn't do it. But fraud is when you are not being honest about your intentions going into the contract. And in this case, it's clear Mr. Reynolds was not honest about his intentions going into the contract. And there's a particular deception that he did, which is he told her that he was going to do this job for $120,000. But see, he already knew he wasn't going to do that. He had this whole deposit thing going on in his mind. He was going to charge her a deposit, and then he was just going to keep it. Right? That was the plan. And see, he told us that was his intention from the very beginning. We know that's what he actually intended. And so we would argue that the fraud happened right there on October 20th of 2020, when the parties entered into that contract. But alternatively, you could also say fraud happened during the start of work when he demanded, I want that deposit now. And at that time, he told her, you give me the money and, you'll get it back out of the last disbursement from the VA. But he knew he wasn't going to do that. And the way you know is because he told you, I never give back the deposit, right? That's his practice. He never gives it back. It's a price increase, but it's called a deposit. So that's fraud. All right, let me just double check my slides, make sure we're up to date. Okay, great. So our next claim is negligence. Jury instruction. All right, so the court is gonna present you with some statements of the law. And we've already agreed on what these are gonna be. The court has decided what they're gonna be. And I'm gonna just read one of these to you. Regina Maia has alleged that the plaintiff and Simon Reynolds are liable in damages for negligent construction. I charge you that an action for negligent construction arises when one fails to perform work in accordance with industry standards. Okay? From the evidence, I'm going to go ahead and read the whole charge. From the evidence, you must first determine what the standards of the construction industry are with respect to the improvements made by the counterclaim defendants for Regina Maia. You must then decide whether the counterclaim defendant's construction was done in a manner that was in conformity with those standards. If you find that the counterclaim defendants failed to meet industry standards and that the failure resulted in damages to Regina Maia, you would be authorized to return a verdict for Regina Maia. If you find that the counterclaim defendants met those standards, your verdict would be for the counterclaim defendants. So you may remember, so we'll make this very straightforward for you. You may remember my conversation with Pablo Blanco, and we walked through the estimate that he did for repairing the property. And we went through item by item, and we asked him, is this a defect? Does it need to be fixed? Is this compliant with the industry norms and standards? And in each instance, he said, yes, this is a defect. It's not compliant with the industry norms and standards. It needs to be fixed, and this is the price for fixing it. And then we've got the whole list of defects and repairs that need to be done. And we've got a total. And that total is the amount that is necessary to remedy the negligence in the construction. And we're seeking these damages from both the company and from Mr. Reynolds personally. Because, well, Mr. Reynolds was personally involved in this project. He was involved in every aspect and every detail. And I mean, it's not that we're trying to make it personal, although he has made it very personal for my client. It's just that, you know, a company might have money or not. It can just be closed down a lot of the time. So getting a judgment against a company that's solely owned by one person, it's often not worth the paper it's printed on. You need somebody who owns something. You need to be able to collect. And so we need to be able to get a judgment against Mr. Reynolds individually to hold him responsible, so he can't just, you know, close down one company and open up another. Because I don't know if you guys have ever done this, but opening up a new company with the Secretary of State is super easy. It's like 10 minutes. So we, you know, we need this to be real. I also want to emphasize that any award of money to my client is for her. It's not to pay me. All of my legal fees have been paid. Well, she has a little bit of a balance that she's running, but it's not very much. But anything you award to her goes to her, not to me. I'm not on contingency. I'm not here to be like, I need $1 million. You know, it's not that kind of case. So please bear that in mind. Okay, I think we have one more claim. 7 minutes. Yes, let's just do it. So we're also asking for attorney fees. So, you know, it doesn't do her a lot of good if she gets $100,000 to fix up the house, but she's got $107,000 in attorney fees. And, you know, I will just tell you, this case has gone on for 3 years. So, and it has been a lot of work. We produced 2,000 pages of documents. They produced like 3,000 pages of documents. That construction project, it went on for a long time, you know, a lot more than 135 days. And there were emails and text messages and contracts and invoices. And then we were presented with a lot of things that really weren't true. And we had to sift through the evidence and figure out how to box them in and show that the things that they were saying were not true. Like you remember from earlier in the trial that this whole thing about the breezeway is a completely separate contract. And then we went through the contract and it was like breezeway, breezeway, breezeway through the whole thing. And there's a picture of the breezeway. So that is exhausting. It takes a lot of work to box people in and to show when they're not telling the truth. And you'll remember the text messages. We had a big stack of 250 pages of text messages. But then actually Regina did this. She went through message by message and she found where they had taken things out. Things that were particularly relevant to the case and inconsistent with Mr. Reynolds' testimony. Do we have a slide on punitive damage? So we are asking for punitive damages. At this stage, you're not going to have to worry about coming up with an amount. But punitive damages are available if someone has acted with malice. Now, malice in the legal sense of the term means knowledge or intent, meaning they did something wrong and they did it knowing. So if you determine that he acted in a way that was wrong and it was a knowing wrong, then you've got malice and you can choose to hold him liable for punitive damages. The other phrase that often defines this is conscious indifference to the consequences. I couldn't capture a better description of the case right there. Conscious indifference to the consequences. He knew this project was messed up. He knew it had consequences for the veteran, and he didn't care. So I'm going to go back to the negligence thing for just a second and remind you all that the law requires of us all that we exercise reasonable care in everything that we do. Driving a car, riding a bicycle, playing a game of baseball, building a house. In all these situations, you have to be careful not to hurt other people. And building a house for someone to live in is actually a significant responsibility. A builder is crafting the space in which a person or a family is going to live. And if it's a good space, their lives will be greatly improved. If it's a bad space, their lives will be diminished. And in this case, Mr. Reynolds was presented with a really special opportunity to be of service. Can you go to my last slide? An opportunity to be of service. Just like Mr. Ordonez voluntarily sought to undertake service to his country and stayed in Vietnam for 6 years in service to his country. Just like Mrs. Maia has dedicated much of her adult life in service to her father and her family. He had a wonderful opportunity to be of service. He was not successful in that regard. He did not create a good space for them. He did not improve the quality of their lives. Quite the opposite. The quality of their lives was significantly diminished. And the money that had been allocated for their benefit went to his benefit. And that didn't happen because he did his best and failed. He's had 35 years in the construction industry. He's good at this. He knows how to do this. It happened because he just didn't care. He didn't care about this opportunity for service. And you know, the law doesn't require him to take an interest in the veteran. The law doesn't require him to care about this family. But it does require him to exercise reasonable care in the construction of the building. And he didn't even do that. So in the end, my client is just asking you to make things as right as you can. You can't unwind 3 years of broken promises, lies, negligence, and frankly, antagonism. And yeah, that's another reason, you know, he doesn't care, because he sued to foreclose on the home. So, ladies and gentlemen of the jury, please put your hand on the scale and balance things out for my client. Please make her whole. We ask that you award her damages for negligence, damages for breach of contract, damages for fraud, and just award her and cover her attorney fees. That's all my client is asking for. Thank you, ladies and gentlemen of the jury, for your time, and on behalf of Mr. Ordonez and his daughter, for your service.
Does anyone need a minute before we continue? All right,
Just say that.
absolutely. I'll join. I felt you.
Is this a stand and stretch?
All right, Mr. Bernie, when ready.
Thank you, Your Honor.
Smile.
All right, let's get to work. This is the closing statement. I told you at the beginning of this case, this is a construction contract dispute. And what you're gonna have to do here is follow the oath that you made in juror in this case. And that oath is to follow the instructions that you're given by the judge. And if you do that, you'll make the right call. We trust you to make the right decision in this. But the instructions are very important. They're not optional. You don't get to decide not to follow them. What your job is to determine what the facts of this case are, weighing the credibility of the witnesses, weighing the testimony and documentary evidence that comes in. You're like a sieve. The facts get poured in by the attorneys, by everybody else. They come through the sieve, and then they drop into another filter, and that's jury instructions. You have to apply the facts to the law, and the law is the jury instructions. And we've worked with the judge over the last day or two to create what those are. So let's talk about the claims in this case. It is true that there was a lien filed in this case. Liens have to be filed in Superior Court. It's a common practice among contractors. This is where you can use your own understanding and experience of how the world works. And contractors use liens because it's the one thing they have to get paid. Doesn't mean that they're mad at someone or vindictive, or they're following the law. They're exercising the legal right to file the lien. If they don't file the lien within 90 days of when they last did work, that right goes away. And so what happened in this case is Mr. Reynolds filed a lien on behalf of his company. And then Mrs. Maia, exercising her legal right, filed what's called a notice of contest of lien, which is in the evidence in this case. Read that when you get it. That says, I don't think your lien's any good. You got to sue me within 60 days. Mr. Simon Reynolds did not file a lawsuit until she had done that, and then he had to in order to preserve his rights. And that's what the law is. So it's not true that Simon Reynolds created this lawsuit out of whole cloth. It's not true that he went to some big, scary Superior Court instead of soft, easy magistrate court. In fact, what would have happened if we had filed in magistrate court, she would have filed her counterclaim in excess of $15,000, and we'd be right back here. So let's keep the facts straight and the way this is really working in the real world. Because that's what happened. Simon Reynolds said, 35 years I've never filed a lien. 35 years I've had one lawsuit that I won. 35 years contracting in Atlanta, in town Atlanta. Imagine what that's like. Never sued one time. I want to talk about the contract. I'm not going to go through every exhibit and all the details. You've seen that. I know you're exhausted and you'll have plenty of time to look at that tomorrow. Most of that will be going back with you to, you can take your time and look at it. But I need you to look at plaintiff's 1, which is the exhibit, the estimate that was done in May of 2020. That's the exhibit, the estimate, I keep saying exhibit, that's the estimate. And here it is. That was the very first document in this case. And that says, hey, I'll do this job for $136,000. And at the bottom of it, it says specialty covers, walkway, footers, posts, roof structure, clear panels for roofing. You'll know when you get to the contract that that exhibit has changed. The price has dropped from 136 to 120. She wants to say it's for some other reason. It's because this was pulled out of the contract. That was the intention of Mr. Reynolds, and she knew it at the time that that October 20th contract was signed. The intention was, we're pulling it out. How do we know that? Because of the text messages in this case. They didn't produce a single text message. Did you notice that? Not one. They didn't give you one letter to anybody in this case. And the judge will charge you that if a party has evidence that can prove or disprove a claim, they have to bring it. Or you're entitled to make an inference that that evidence would have been against them. That's an instruction. It's not optional. They didn't bring any evidence of a single complaint to anybody. Not even in the text messages to Simon Reynolds. Not one. If they're so outraged about everything that's happened and how terrible everybody's been, where's the documentation? It's just phone calls? Hey, Simon, I didn't like what you did. Why are you making me pay 16 grand? That's not right. That's not how the world works. And that's where you use your own understanding and experience in the world to make that decision. So the contract that got signed does not have a line item for the walkway. It doesn't have it. And it doesn't have it because it wasn't part of the contract as far as Simon understood. Okay, he was not using his contract. This was a contract by the VA. He was trying to help her. He wanted to help her. He wanted to help her. He worked on this from October 19th to October 2019 until when the contract was signed in October 2020. He worked on it for a year for no money. This is some great fraud claim, right? What a fraudster. Let me work for you for free for a year. That's what the evidence shows in this case. And that's not what happened in this case. When he signed that contract, his understanding, his good faith understanding was that the walkway was not included. Mrs. Maia wanted you to believe, well, it went down from 136 to 120 because the earlier one was this more elaborate pergola walkway situation. But when I showed her the contract and said, look, here are the plans that were on the July 2nd contract, exactly the same as the plans. And that July 2nd contract is the 136 contract that included the walkway. Because it was based on the 16,000 ad that's in the final contract. And that was first provided. Okay, so he provides an exhibit for 16,000. They sign a contract in July for 136 that includes the walkway. She says, well, yeah, but it was too expensive and it was a weird, different design. It was more complex. And then they signed almost the exact same contract in October of 2020. Same plans. There's no difference in the plans at all. They didn't bring any evidence of different plans. If they were so different, where are the plans? They weren't different. They were the same. And you know why? Because on July 21st, 2020, Mrs. Maia sends a text. Hey, Simon, I've got an idea about the deposit. Let's talk offline. There's not a single other text messages in her thread that says, let's talk offline. What does that mean to talk offline? I mean, this is what you have to decide using your own understanding. Is that trying to hide something? You don't want it in writing? She said it was, oh, I was explaining to Simon all these options. Not a shred of documentation has been provided from them showing that she offered him any other solution to the deposit. Simon gets to work the way he wants to work. And you've heard and you know that most contractors every time ask for money up front to get started on the job, and it's not refundable. The very expert that they had, his very first line item was mobilization. Part of his fee. There's nothing in his contract about, and then I return your $1,500. Their own evidence is against them in this case. They produced it as their best evidence. So we have this contract. Simon, at that time when he signed the contract, believed that we're going to do this deposit off, or we're going to do this deposit out off the record, and we're pulling the walkway out so that I can get some money up front to do the greater job. That's what the invoice said that you'll see in the exhibits. Now, it didn't get paid right away because they still had a lot of work to do, right? They had to do the variance. There was work that had to be done. They had to get approved with the VA. The VA had to approve. We all know how the federal government works. It's not the easiest place to get stuff done. But it took time. There's no evidence of any delays on Simon's part other than what she says. Not a single email, not a single document, not a complaint, nothing from the VA that says, why are you taking so long? Nothing. We get into May of 2020. We're getting ready to start. The building permit has been issued. And Simon says, oh, like the $16,000 we talked about and that we understood was part of this. What does she do? Sends a check, sends a wire transfer, $16,000. Not a single text message, not a single letter, no communication going, Simon, that's not the deal. Why are you asking me for that? Is that what a reasonable person does? They just say, well, I just want to get the contract started. And I guess Simon was confused. It's fine. No. So you write a note, you document it, you say, we didn't agree to this. And I want it in writing that you have promised to give this back to me. Nowhere in the evidence does it say that, except for what she is saying verbally to you. No. If the party doesn't produce evidence that tends to prove or disclaim a charge, a claim in this case, and they don't produce it, then you have a reasonable inference that that evidence would be against them. So the intent here in this case was that Simon understood the contract was going to, that they were going to do the walkway off the contract. And now it is true, of course it is, and we're not denying it, that he should have maybe pulled that out, those plans out. You know, this thing has been going on for a year. He didn't pull it out, but he did take it off the exhibit. That's the thing he's concerned about, is like making sure he's got everything covered. He's going to get paid for what's in the contract. And so that wasn't part of the contract. It never was. And it wasn't so that Simon could get started, because if you heard him say he doesn't work that way, he gets to decide how he works. So the problem with their fraud claim, which is solely based on what Simon's intention was when he signed that agreement in October 20, their whole problem is that one of the elements of fraud's a very difficult claim to prove, and let me tell you why. Fraud has 5 elements. You have to find evidence on each fraud, on each element of a fraud claim. The first one is a false representation. Okay? There's nothing in writing. It's just her statement that Simon said, Yeah, it's okay, I'll work without a deposit. Nothing that Simon, she says Simon said he would. That's it. There's nothing in writing about any of that. And next, and this is the most important one, the intent to deceive. It can look like deception. It can smell like it's being deceptive. But if there's no other evidence to back it up, it's not deception. It's Simon having a good faith, reasonable belief that she was going to give him the deposit because they pulled the walkway out. There's no intention to deceive anybody in this case. You heard Summer Benton, known her for 20 years here in Atlanta, a detective with the police department. He's done work for her. You heard what she said. Simon is not a liar. He's not a fraudster. And we're shocked. And he's crushed that this is even here. Let's talk about the jury. And they said, well, you guys asked for a jury. You guys, as if to imply that you guys wouldn't have to be here unless it was for us. But in their answer, they asked for a jury too. The lawsuit that they made us file, they responded to and asked for a jury. So I could ask for a jury, and if the other party doesn't ask for a jury, I can waive the jury. But I can't waive it if the other party's asked for one. So they're just as responsible for you all being here as we are. And we're happy you're here. You guys are gonna do a great job. I gotta remind you, you're being instructed by the judge. It's not recommendations, it's not options, it's not something to think about. These are instructions that you must follow. So the fraud claim's out because there's no intention to deceive. And why do we know that? Again, just to sum up, there's not a single piece of evidence that that deposit was meant to be refundable, except for what she says. This is the same person who said, well, the contract plans changed on the walkway and that's why it went down. They didn't. She's been impeached by her own testimony. They did not change at all. So let's talk about the breach of contract. Excuse me, let's talk about the negligence claim. The negligence claim. As I said from the very beginning, this is a construction contract dispute. It's not a negligence claim. It's not a fraud claim. It's not the claims that got dismissed in this case, the slander, the conversion. You remember being talked about those? Those are gone.
Objection, Your Honor. May I approach?
I'll just instruct the jury, any claims that have been removed from your consideration are not to impact your consideration of the claims that remain. So with that, unless there's anything else, Mr. Craig?
That'll be fine.
Okay, you can proceed, Mr. Birdie.
Sorry, we just got this document. It's been compiled beautifully by the court, and I gotta find the one I want to read. If you could pull up page 6 of the instructions, please, Katie. This is extremely important, and I need you to pay attention to this part. A breach of contract does not always give rise to an action for negligence. Such an action will lie if, in addition to breaching a contract obligation, it also violates a duty owed to the claimant independent of the contract to avoid harming the claimant. They're saying he didn't work in a workmanlike manner. Look at the contract. It says that in there. It's a term of the contract. His allegations are not separate and apart from the contract. They're exactly what's in the contract. This is a contract case. They're instructions. They're not optional. They're not recommendations. It's undisputed in this case that the VA paid every dollar that it was supposed to pay in this case. It's also undisputed that they made their last payment in May, and that's on the exhibit with the spreadsheet showing the calculation of what was paid and what it was applied to in this case. So you can see that that was the last payment The last payment was in May. So they could have immediately in May said, wait a minute, she said she was gonna get paid by the last payment. Look for any kind of document. Where's the demand letter? Where's the lawyer letter? Where's the text message that says, Simon, you got your last payment, where's my 16 grand? It's not in evidence. What Mr. Craig says isn't evidence. What I say isn't evidence. It's not in evidence. You're also going to be instructed on a very important thing that comes with, when we talk about the breach of contract claim. Very important. These are instructions. They're not optional. If you find that a party failed, let me read it to you so I don't screw that thing up. I guess. Very important to my client. Just a moment, please. Your Honor, can I have a moment, please? I need to confirm something about these parties that I just noticed.
Mr. Craig, do you need to approach on something?
Yes, I think it would be good.
Okay.
Having a little bit of. Thank you, Your Honor. Apologize to everybody. This is a document that we all worked on and got compiled, and I haven't been looking at it like every other document in this case for all this time. There's a jury instruction you're going to get that says if the non-performance of a party to a contract is caused by the conduct of the opposite party, such conduct shall excuse the other party from performance. These are instructions. The evidence is unequivocal that Simon asked to come out and make repairs. And you heard her husband. I took it over and I told him not to come unless he brought me money. They didn't allow him to come and make the repairs, which at that time we thought were basically 4 things, because that's what she sent to the VA in February, late March of 2022. 4 minor things. Nothing about all these other things. She said, well, they only give me 1 day and then the next guy wouldn't talk to me and it just got closed down. And we're sympathetic to Miss Maia of her situation. Simon didn't create that. He wasn't trying to bank off of it. It was just a situation that happened. He had to raise the claim of lien when he did. He had no option if he wanted to. He wanted to be paid. It wasn't intentional to cause her any kind of distress. But the fact of the matter is, she did not give him an opportunity to come and cure this contract. This is what I told you in my opening. They have to give you a chance to perform. And if they don't, the other party's excused. There's also evidence that there's a 1-year warranty in this case, and Mr. Blanco testified that that would start from the certificate of occupancy issued by the city of Atlanta after multiple inspections. Did we ever get anything regarding any of that during the warranty period? Hey, Simon, this is in the wrong place. Simon, this floor's working. Simon. Nothing. No evidence of a single claim on the warranty. Contracts have meaning, like Mr. Craig said, and parties expect the other party to adhere to it, and I steadfastly agree with that. So Ms. Maia can adhere to the contract as well. These are instructions. You're going to see in the contract that there's no talk of information, or there's no talk of any tile in the front yard, on the front walkway. There's no evidence of Miss Maia rejecting the work, or there's no evidence of her complaining about it. There's no evidence of the fact that the north side fence was included in the contract. Okay, the moving of that fence, there's no evidence that that was discussed. What was discussed in the contract, according to Mr. Reynolds and confirmed by Ms. Maia, was that there was a fence on the south side of the property where the driveway and the gate was. And she admitted Simon did work on that. Did Simon send an invoice for that? No, because that was part of the contract. But moving the north side fence benefited Ms. Maia, and it got done by Simon, and she paid him. So what we have is a string of all these payments that Ms. Maia made because she had to do it for some perceived belief that if she didn't do it, she wouldn't get paid. But the fence was one of the last things done. This contract was substantially complete in February of 2022. So it wasn't like there was a lot left to do. That would have been a good time to say, you know what, I think it's time for me to start sending me all this money just because you want it. If her statement is, well, I can't get you to get started, or I can't get you to keep working. At this point, we're way past that. We're almost done. There's almost no work done from February and early March, as was testified to, after that part. But you know what happened? A certificate of occupancy got issued. Why does that happen? Because almost all the work was done when they last did work. So there you go. She wants to talk about how the HVAC unit was wrong, the water heater was wrong. They have not produced any evidence of what make and model of either the water heater or the HVAC unit is actually installed. There's no evidence in this case about it, except for what she says. Their own expert who came out and spent 1 to 2 hours there and put it on his itemized invoice. So, well, I gotta replace the water heater, I gotta replace the HVAC. He didn't even put the make and model down. It's so important. He said that they were working, and she says, well, they were inferior. There's no testimony about how they were inferior. How can we know if they're inferior if there's no make and model? So we can see the specs. The way you prove something is inferior, specification sheet number 1, specification sheet number 2. Did we get that in this case? No. If you could bring up the exhibit with this corner of the drive. I think it's on there. Yeah. Yeah. I don't know about you, but that looks like a nice house. That deck does not stick out over the driveway. It's not an optical illusion. It's where it's supposed to be, according to the change order that was signed in this case. They have some illusory little talk about, well, the change order, it's funny, like this one looks like this and this one looks like that. There's nobody here testifying that anything's fraudulent or forged. All there is work that got completed, and this would have been done sometime between October 2020 and the spring of 2022, October 2021 and spring of 2022. And look in the text, see if she complains about that. There's no evidence of them trying to find a lesser solution to remedy the problem. They could have done all kinds of other things that are not rip out the entire driveway and start completely over. Their own expert admitted he didn't even look for lesser alternatives. He just came with a super expensive one. There's no evidence about how the value of their property is diminished by the fact that this property is in this condition compared to what it should have been. There's been no real estate appraiser. Well, that property has got a problem because that is not in the right place. So this property is worth this much less money. It's not here. Because they're just fine with this stuff, honestly. They're just trying to get out of honoring their contract. They're trying to get out of, and if you find that the thing about the fence, the front walkway, the retaining wall, if you find that these things, and the retaining wall, let's talk about that, because that's really what caused this overage. And is the retaining wall was about a $7,000 bill. You can see it on the invoices. And that's what basically Simon's breach of contract claim is for. If you find that, if you look through the contract, there's nothing in there about a retaining wall anywhere. She paid $3,000 towards the retaining wall. Don't you think that'd be something that you'd want to have in the contract if it was supposed to be included? There's no evidence that my client's, what he testified was reasonable, charge for the retaining wall. There's no evidence from their expert about it. Or if there is, you can find it and make your own determination. But the fact is that it was necessary to the property per Simon. She got the benefit of it. So we have two claims in this case. We have a breach of contract claim, and we have a claim called quantum error, what I talked to you a little bit about it. The breach of contract claim would be for if there were issues related to the claim, the contract that weren't covered. And the quantum error claim is for things that you decide aren't part of the contract but should be paid because she accepted the benefit of the services. The services were provided, and the evidence of the services in terms of their cost is reasonable. That's uncontradicted. Let me get the instructions on that one. These are instructions. You're not going to get these. You're not going to take these back with you. Okay, that's a thing that happens in these cases. You don't get to have these with you.
Mr. Bernie, I'll provide him a copy of this.
Oh, you will? Okay, thank you. So quantum meruit. It's a fancy Latin phrase. It's really the only one that matters in this case. And that claim is as much as a person deserves. Because you did work that they accepted, it benefited them, and the value and the price charged is reasonable. She paid every one of these things. Is that not evidence of reasonableness? The only thing that she didn't fully pay was the retaining wall. Breach of contract, we talked about that. If you find that there's a breach of contract in this case, that will be up to you, and you'll have to decide that is from Simon Reynolds for doing what was supposed to be done and not paid. If you find that there's some on her part, on our part, back to her, then you have to look to see, again, is it negligence? Because no, because what's in the contract is that the work will be completed in a workmanlike manner. That's the duty. That's a contractual duty. It can't give rise to negligence. The fraud claim, no intent to deceive. There's a good faith, reasonable understanding of what the contract meant. Again, she was just gonna let it go, she said. Would you let $16,000 just go? Is that reasonable? If you felt like someone took $16,000 from you, would you let it go? This whole right to repair act they talked about, that works for both parties. There's no obligation that you have to do it. It's not a requirement. The judge isn't going to instruct you about anything about the right to repair act. She's the only one that didn't give us an opportunity to come out there and see what was happening. And remember this, at that time, in the spring of 2021, we thought it was 4 things that she put in the VA complaint. That's the only thing that was ever in writing. 4 minor things. I appreciate your patience. I know this has been a long week. This is important to my client, and I need to take my time and not rush myself. Mr. Simon Reynolds testified about what the 4 things were. Kitchen cabinet's missing. It's missing a piece. The builder's attempting to charge us for the installation of appliances. Oops. You'll see that on the itemized exhibit D, $500. He did install the dishwasher. They purchased and installed the other. You heard Francisco Maia talk about installing the refrigerator. The breezeway, the big breezeway that's in the wrong place and isn't supposed to be part of the contract. She says it's missing lights. Look in the contract to see if there's anything about any lights in the specs. There's not. I repeatedly requested that the builder put a change order in to remove the $1,450 sidewalk. There is a change order that's in this case that removes the sidewalk, and because they built the wraparound deck to make it a solution so that they could actually use the front door and come out of it with a wheelchair or a gurney, they washed it. They did that work for no, you'll never see an invoice for that extra deck that they built. It was a wash. The fence gate is not complete. She's referring to this electric gate that she has going across her driveway. Simon Reynolds would have fixed that gate in one day. He'd been given the opportunity to do it. You heard the anger from Francisco Maia. You saw him in court. You saw what he wrote in his text messages. Would you want to go back there when the guy's demanding $9,000, $10,000, $11,000 each time a different number? They prevented us from fulfilling our obligations under the contract, therefore we're excused. They didn't make a single warranty claim. The warranty started in June. You would think by that time, she'd had time to look at everything and say, well, these are all the other things that are wrong. Why didn't she write anything to the VA and go, hey, they took $16,000 from me? Because it's not in the contract. Because she didn't want it to be part of the contract. She wants to talk about it offline. She pulled that line item out of Exhibit B. Somebody pulled it out or was pulled out because that was the agreement. She never said that that's the incorrect version. Did you notice that? She never said, yeah, it should be that other one, that it should say 120. She never said that. On their breach of contract claim, they prevented us from coming out and making repairs. They prevented us from any warranty claim. They gave us no chance. They gave us, don't. Here, I got it. No. That was some fast action there. Let's see. Breach of contract, they prevented us from fulfilling our obligations under the contract. Where one of the obligations is to do things in a workmanlike manner. If they'd asked us to do it, we would have done it. Simon's never been sued in 35 years. He's had one lawsuit. He won. Same kind of claims. You heard Mr. Craig say it. Contracts matter. Promises matter. I'm just going to leave you with this. I think we've talked about all of this enough. My client put in evidence of what the total charges were for the work in the contract and the extra work that she asked for. They didn't pay all of those charges. They had an opportunity to pay, but they didn't. They chose to make up this idea that the $16,000 that she never complained about ever until this lawsuit wasn't part of the contract. That authorizes you to award attorney's fees to my client. These are instructions, by the way. They're not optional. There's a charge in there about sympathy. Okay? I encourage you to look at it closely. You need to look at the sympathy charge. Simon Reynolds did not cause Mrs. Maia's father to get sick. He didn't want him to be sick. He didn't want his illness to be worse. He didn't want him not to have an ADU that he could live in. He didn't want any of those things. He was not given an opportunity to make it right. And for that reason, you have to fine for my client on the breach of contract claim. You have to dismiss all of their claims because they didn't give us an opportunity. On the fraud claim, no intent to deceive, must be dismissed. on the negligence claim. The negligence that they complain of is a duty that's in the contract, and therefore it cannot give rise to a separate cause for negligence. So these are instructions. I know you'll follow them. You took an oath. You need to look at them, read them, think about the facts, think about who brought what evidence and who didn't bring what evidence. She talked about 5 or 6 other people that she had to come out and look at the problems with the property. Where are they? Why didn't she line them up? Hey, these are all the things that are wrong. They didn't produce the witness. You're entitled to make an inference that their testimony would not be helpful to their case. I just ask you to do this. You're the jury. You have an incredibly important job. Reputations are at stake. People have to be held accountable to the contracts they sign. I ask you to come back with a verdict in favor of my client after you've carefully considered the evidence. I thank you again for your time.
All right, thank you, counsel. Members of the jury, at this point, we'll break for today, and let's plan to reconvene at 9:30 tomorrow. And at that point, I'll bring you in, I'll charge you on the law, then we'll be able to provide you with the exhibits and you can get started with your deliberations. As consolation for my inability to stick to my promise, I think we will have pizza here for you at 11:30. Wherever you are in the process at that point. So you can take advantage of that, or if you want to pack your own lunch, feel free. And then you can decide whether you want to work through lunch or break for lunch. We're at your disposal from there on out. Please don't discuss the case with anyone, including amongst yourselves, and don't do any research about the case or anything involved in the case. So you're all excused until 9:30 tomorrow, except juror 31, if you could stay behind with us.
All right, for the jury.
You did it.
That's the offense. I think that's the one we're dismissing.
I was trying to do look about the alternate.
All right, juror 31, you're not in trouble. You just happen to be our alternate. And so you're not off the hook just yet. We have had to sub people in after deliberations start. But what I want to do is ask, go about your business tomorrow. If you got to go back to work, understood. But if we could have you on, what do you think? Can we do hour and a half? I don't know what part of town you're in. Hour call, hour and a half call?
GP Center, so.
You can just walk down the street and join us. Okay. Well, we're going to give you a ring if we do need you, and then we'll also give you a shout when we let you know if you're totally excused. But you still fall into those obligations of, the requirements of your service, not to discuss the case and that sort of thing. But you can just wait at home or at work for further word from us. So if we don't see you again, thank you so much for your time and attention in this case, and take care. All right.
Father juror stickers. Thank you.
All right. Anything to take up on the part of the plaintiff? Anything on the part of the defense?
No, Your Honor.
All right. So what I would ask the parties is if y'all could still be back around 9-ish tomorrow. I'm not going to be coming out right at 9, but what I want y'all to be able to do is meet and have the stack of exhibits ready to give to them, right? Because y'all have to work through what goes out, what goes in. There might be objections about that. And hopefully we can work all those out and at least have some idea of where it is. Ideally, if you just got a stack ready to go and they're all here at 9:30, then I'll charge them and send them back there, and then we'll just await word.
I think our intrepid court reporter is holding the exhibits. Is that right?
He may, I don't know which ones he has, which ones he doesn't. So that's why I'm going to rely on y'all to make that stack. And some of them may not all be going back. As I talked about, we got our continuing witness rule to consider, depending on if the parties are objecting or not. So with that, then we'll be in recess and we'll take it back up at 9:30 tomorrow. All right.
Thank you, sir. That's what we discussed, but y'all have beat it on.
Oh, I see.
So they've just gone back to you.
Okay.
All right, sir.
Understood.
This was courts 1 for you.
Sorry that we have our religious difference. So let's back up. Help me.
Should we bring the exhibits we've used?
Yeah.
Those here. Well, ours and theirs.
Yeah.
Yeah.
I used it.
I'm just seeing this email.
You pulled
I
out
guess you had, tell her just to email it to me. It could be
a
legit.
couple from the
I'd
bottom.
email it to me and then,
This is the bottom
I think I
stack.
got lost in the,
Here, and then in the morning we'll just go.
down to the sunset.
Figure out what's in this. And then that's extra copies. I just checked those on the.
Been able to clear out your inbox?
Um,
All right, all right.
I do not. Huh? Yeah, so with this and
I'm gonna
this.
take that with me. Bus going.
I have. Just size of Europe. Yeah, just we can leave all this stuff here, or should we take it back with us?
Not in just you, but just common sense.
All right,
I said, should we just leave this here or take it all back with us today?
I'll take it.
Oh, really?
Get it out here. I don't want to do it tomorrow.
I feel like that's stupid.
Thank you, sir. Great job, as always.
Just don't like to look at.
I'm gonna run to the bathroom really quickly.
What did they comprehend and what did they retain? That's why I was on, I need to focus. It's in my pocket. Oh man, and the dongle, what happened?
Oh, I think I
Okay,
got the wrong computer.
thank
This
you.
one's yours.
Oh, all right, yeah, you don't want this one, the battery's dying, so.
Okay.
Version 2 is.
Yeah, it was just internally our version too.
Yeah.
But that's the first one that we discussed.
I gotta tell you,
I can see how that.
with,
Yeah, I just wanted to make sure the one that we stamped was the
Of
one.
course.
Yeah.